Start, no? What up? 13.
Wait. This appeal is something different. It is not against conviction, not against anything. This Act, National Investigation Agency Act, has created this provision.
National investigation.
Section 21. I think this is
I'm not sure if you're audible to my senior brother.
Yes. I do not know during the course of the proceeding because the internet connection is not very strong.
Connection appears not to be very strong.
Anyway, you can proceed. If I find difficulty, I will mention.
Yes.
Lord, we are
Mr. Bhattacharya, you are referring to the National Investigation Agency Act, section
21. Here is the case, my lord. Under the CRPC, you can come to the court after moving it before the learned trial court or before the session court. But here it is something different. Appeals. Your Lordship got the act.
Yes.
Notwithstanding anything contained in the code, an appeal shall lie from any judgment, sentence, or order, not being an interlocutory order of a special court to the High Court, both on facts and on law. This is quite wide, Major. Every appeal under subsection 1 shall be heard by a bench of 2 judges of the High Court and shall, as far as possible, be disposed of within a period of 3 months from the date of admission of the appeal. Except as foresaid, no appeal or revision shall lie to any court from any judgment, sentence, or order, including an interlocutory order of a special court. Notwithstanding anything contained in subsection 3 of section 378 of the Code, an appeal shall lie to the High Court against an order of the special court granting or refusing bail. Every appeal under this shall be within a period of 30 days from the date of the judgment, sentence, or order avail appeal from, provided that the High Court may entertain an appeal after the expiry of the said period of 30 days, if it is satisfied that the appellant has sufficient cause for not preferring the appeal within the period of 30 days. Period further, that no appeal shall be entertained under the expiry of the period of 90 days.
Yes.
Now, those problems are not there so far limitation is concerned. My lord, unfortunately, these accused persons are in jail for more than 10 years. They are facing the trial now. If your lordship, to which I am not going, but I am little surprised, having made an act in spite of the fact that CBI, a full-fledged organization, is there. They have made. This has created a lot of problem for the accused as well as from the court. Now, as your lordship knows, in last about 6 months, some of the benches in the Supreme Court, they have taken it up very seriously so far bail is concerned. I do not know, what gain the prosecution will make by keeping these people for 10 years in jail. Does this act provide for that? In fact, my lord, some of the cases recently say, probably one or two have not been reported, but anyway, whatever is reported, I will place that.
No, is there an interlocutory application for bail today?
This is the appeal, which is for bail. As the Act says,
My lord,
All right.
we move the learned trial court, learned trial against that order, my lord. We have come on appeal.
Okay. Okay.
This appeal is something new, my lord. In spite of the fact,
Because subsection 4 permits that. That is how this appeal has been filed.
your lordship will see the beginning of the section. Notwithstanding anything contained in subsection 3 of section 378 of the appeal shall lie to the High Court an order of the special court granting or refusing.
All right.
Am I clear?
Yes, yes. Now you are clear.
Because here in this act, you say it is a special act. But so far, appeal against the bail is concerned, is mostly the Honorable Apex Court has said that provisions of the act, then the appellate court against the order of the trial court would consider not only the facts, possibility of conviction, and also the delay in trial.
Yes.
Now, I will point out one thing, my lord. 10 years being in jail, I am sure trial court will have to say, though I convict, the accused will go out of the trial. Your lordship will be surprised to see the effect of this new act. I am conducting some of the trial court cases under this. Public prosecutors, they can't do anything. They issue their summons, court issue their summons, whole day sitting, one witness is coming. Sometimes they don't inform.
What is the status of the trial?
62 witnesses,
62 witnesses have been examined,
Out of
110.
110.
total 110
Yeah.
witnesses are there. Prosecution. And out of that, 62 has been examined.
62. Now,
Yes.
your lordship has called for the scanned copy of the evidence also. He said,
I sent you scan copy. Photocopies of these has been sent. Huh? पठाई सर सब पठाई सर Yes.
I have not seen the honorable judge here, my lord, in the.
Oh wow. He that Ulwana hai no.
I don't know.
Mr. Bhattacharya is not being able to see you, brother.
I have to see his reaction.
Yes, yes, of course.
With you.
Is he visible now?
Has your lordship heard me?
Yes, I'm hearing.
Okay.
Brother Goswami, do you have a copy of the LCRs?
It has come apparently. Has it been sent to you?
No, I have only the copy of the memo.
All right.
And
All right.
Lord, I propose to do this since the honorable senior judge is not available. Let me speak this. Let me complete the argument. Then when the honorable judge will come, then my lord, your lordship can look into it because it has not been sent to me.
It has not been sent.
So after looking into that, there can be one more here. It won't take much. Even my lord, My
Will
learned
the-
friend
is
also
that
will-
comfortable, brother?
Yes, yes. Yes, but it will be happening only after vacation. We
Correct,
cannot
correct.
be sitting in principal seat before the vacation.
There is one more thing, my lord. No other bench can take it.
Yes, I have seen that note. It has
This
been
bench is
assigned before this
created.
bench. But the only thing in this hybrid mode, the difficulty is that the papers are not made available before senior brother. So that is the problem. If we have to dispose of the appeal today, then all papers have to be available before both of us. Otherwise,
Yes.
it will be a namesake division bench. That is the difficulty.
If your lordship can agree, then a complete fixed days,
That can only happen on the reopening.
only reopening.
Because next week 9, right? Next week also, senior brother will not be available in the principal bench.
The way senior counsel has proposed, we can continue for some time at least, get a grasp of the facts, then we can spill over the hearing immediately after the vacation. That can be the best way out. Am I? Oh, I'm sorry.
Yes. You're audible. Yes.
Whether your lordship can fix the date today itself.
Yes.
Yes. I think we can do that.
Yes.
We'll go with them. 24th October.
24th October.
Looks okay. Looks fine.
Yes.
Can it be made pardon?
It is already assigned before this bench. So,
Let it come as a first item.
or
24th October, man.
Yes. Brother Joseph, you can pass the order then.
okay. Hearing remains inconclusive. List again on 24th October. So and so. Bora.
May I please lordship, with the consent of the petition, I beg to mention 36 and 37. Ma'am. That will be taken after
36 and?
petition. 36 and 37. The matter is conducted by R.B. Bora. There's some bereavement in her family.
Yes, I
After
believe
vacation.
so. Yesterday also someone mentioned 36 and 37.
37.
It is mentioned that in view of the bereavement in the house in the family of Ms. R.B.
R.B. Bora.
Bora, Learned Standing Counsel BTC, Learned Counsel appearing for the respondent. A mention is being prayer is made to accommodate the matter today. Prayer is allowed. Petitioner is present, not opposed, and list after 3 weeks on a date to be fixed by the registry.
My lord, in item number 49, 50 and 51, my lord, I have filed 3, my lord, affidavit in reply. I may be allowed to call for.
All right.
May I please, the Lordship?
Yes.
Lordship, I beg to mention item number 12 to 15. Lordship, this matter may not be taken by your Lordship.
12 to
15.
not by this court.
Yes.
Not by this court. Yes.
May it please the court? Your Lordship, I beg to mention item number 54 on the supplementary list.
Yes.
With the consent of the other side, we are praying for an adjournment and fixing of date if permissible, Your Lordship.
You have for the petitioner.
For the respondent number 2, Your Lordship.
You have sought consent
Yes, Your Lordship.
as prayed for by MS.
Ms. Das. M. Das.
M. Das, Learned Counsel for respondent number 2 with consent from the petitioner, with consent from the Learned Counsel appearing on behalf of the petitioner, list this matter after 2 weeks on a date to be fixed by the registry.
May it please the
Yes,
lordship.
Mr. Das.
With the consent of the other side, my lord, I beg to mention item number 35.
35.
35, my lord. The matter may be.
You are for
Respondent, my lord, 5 and
as
6.
prayed for by Mr. S. Das, Learned Counsel, for respondent number 5 and 6 with consent from the Learned
Petitioner.
Counsel appearing for the petitioner. List this matter after 2 weeks on a date
First
to be
week of
fixed by
November,
the
my lord.
registry. 3 weeks, correct. All right.
Highly obliged.
May I please, Your Lordship? I would like to mention item number 5 and 10, Your Lordship. In this case, I am on behalf of Mr. H. Umar, my lord.
5 to 10.
Yeah, no, 5 and 10, Your Lordship.
5 and 10.
Yes, Lordship.
Yes. What do you want?
Can it be after puja vacation?
You are for the petitioner.
Yes, Lordship.
As prayed for on behalf of the petitioner by Mr.
SD Roy, Your Lordship.
SD
Roy.
Roy, Learned Counsel for the petitioner. List this matter after 2 weeks on a date to be fixed by the registry. 5 and 10.
5 and 10.
5 and 10.
Deeply
I'm
obliged.
appearing, my lord.
May I please, Your Lordship? Here, Your Lordship, I have been selected as a Gram Pradhan, Your Lordship. Gram Pradhan, Your Lordship.
Yes.
Under Revenue Kolyabur Circle, Your Lordship. At page number 22, that is selection list, Your Lordship.
Page number
22, Your Lordship. Annex 3.
yes.
My name is reflected at serial number 11, Your
11.
Lordship. Your Lordship. But my grievance is that, Your Lordship, I have not been even appointed till date, Your Lordship. But the similarly situated person, Your Lordship, from the same selection list got appointment. That is my
Yes,
grievance,
Mr.
Your Lordship.
Borpujari. Very short grievance. Appears to be.
Yes, Lordship, I have received 2 instructions in similar other cases. One is received today, Lordship, item 26.
Before.
There-
Before.
Yes, Lordship,
Before
before
this
we are
court?
only item 26. Well, Lordship, an appeal is pending. One of the
Appeal is pending means?
before the DLR, Lordship. Because they, the person who, the petitioner, their Lordship, he challenged the selection process and filed an appeal. He filed a,
So her selection is under challenge.
yes, Lordship, and there are another also
But is there any stay order?
that we are not aware of. But only thing
So
is
if there
appeal
is
is
no
pending,
stay
that
order,
this is
then-
there.
Mr. Borpujari, because it appears that the petitioner has been selected at serial number 11. Correct.
No, it has been selected, but my lord, under the rules, my lord, departmental appeal lies against any grievance, my lord, pertaining to appointment and selection of Dambura.
Very well.
Now, my lord, since my learned college has
No,
made a
but what I
statement.
am saying is that just pendency of an appeal will, does that mean that the selected candidate shall not be issued the appointment order?
No, otherwise, my lord, if she has any grievance, my lord, she ought to have approached the.
Oh, actually, you are
authority.
saying there is an appeal provision.
Absolutely,
Yes,
absolutely.
Where is
Here,
that?
here, Your Lordship.
Huh?
Here, Your Lordship, the appeal provision for the challenging of the appointment, Your Lordship.
Where is the appeal
Not for the
provision?
non-appointment, Your Lordship.
Where is the
My
appeal
grievance
provision?
is the
One sec,
162C.
Ms. Bora.
No, appeal provision is 162C.
No, that is 162C, executive instruction 162C. Otherwise, lordship may be pleased to issue notice in this matter.
Only issue notice is all right, but it defies the logic of this court as why the selected candidate has to wait for her appointment
Yes.
if there is no bar. If there is a bar, that is a different thing. If there is no bar, then why?
There is no
my
appeal.
lord,
I just,
there may be a possibility, we do not know, because it is on facts. Now, if tomorrow, my lord, the appellate
All right,
authority-
this is at the motion stage.
Yes,
Motion.
Lordship, this is for
Uh,
motion.
So therefore, my
Can
lord,
you,
this is the third time, Your Lordship.
Ms. Bhattacharjee,
Yes,
since you
Lordship.
have already received instructions in a
In
similar
item
case,
26, Lordship,
yes,
yes, Lordship.
but the instruction possibly will not be same, or is it the same
Yes,
selected?
definitely,
26 is
Lordship.
different.
Because in
Ms.
another
Bora, please
Lordship,
calm
Lordship.
down.
Lordship,
I cannot hear everyone together.
Lordship. Apology, Lordship.
Lordship, that's exactly what I am submitting. In another case of the same district, Lordship, there was a challenge by the T tribes community where they have said that the
All right,
majority people are there.
let me take this matter with that matter.
Lordship.
Item 26,
item
Lordship.
26.
Yes.
I'll
so
take it when that is.
Lordship.
yes, absolutely, yes.
Another matter we are filing affidavit today, Lordship. This is also of Nagaon, Lordship.
And when is that matter fixed?
That matter, Lordship.
Anyway, you have a find out when that is also
Yes,
fixed.
Lordship.
I will see you together at that.
Lordship.
The 20?
Item
26,
26,
Lordship.
Lordship.
Item
26.
number 26
One more
listed
letter.
to them. Obliged.
This is connected with item
Lordship,
three.
although Lordship, it was reflected as a connected matter, so Lordship may segregate this matter, issue is slight different, Lordship. So Lordship may take it after the taking of the item number 3, Lordship.
After item number 3, madam.
Item number 3, Lordship may.
Okay.
Item
It
number
took with 3.
He's coming.
Yes, Mr. Datta.
May it please, Lordship. My Lord, your petitioner, who is a forest ranger, Kaline Range, my Lord, has been promoted to the rank of assistant conservator of forest-wide order dated 10/9/2024. And he was posted, my Lord, as assistant conservator of forest, North Kamrup Division, Rangia, against existing vacancy. Now, my Lord, he went to join there, and over telephone, my Lord, the officer, he said, you come on Monday. Now, on Sunday, my Lord, they have passed an order. Your Lordship will find that order is at page, my Lord, 16.
16.
My Lord, your Lordship will find, my Lord, on 17, my Lord.
Yes.
No, not 17. That is 18, your Lordship can listen.
Annexure 5.
Annexure 5.
Yes.
That is on Sunday. They have
Why-
modified that order.
This is a typed copy or this is the date is not
This is
mentioned?
original
Huh?
copy. Date is, my Lord, that is 22/9/2024.
22/9/24.
24.
Yes.
Now, on Sunday, my Lord,
Reversion.
yes, they have not reversion. He was posted in a different area. That is, your Lordship will find the last line. He is posted as Assistant Conservator of Forest, Office of the Additional Principal Chief Conservator of Forest, SF, Guwahati. Now, on Sunday, what is that reason, my Lord, they have modified that order. And that too on Sunday.
So on 22nd September is a Sunday.
Sunday.
You
And before that day,
earlier order,
your Lordship will find, Lordship, kindly see Annexure 1. There is on 14.
this
page
is
14.
on 10.
10/9/2024, page 14.
On that day, on 10th, you have been promoted temporarily to the Assistant Conservator of Forest, and then you have been posted
Rangia,
at Rangia.
my Lord.
And on 22nd, which is a Sunday, you have been asked to report. Your transfer has been changed, and now you are asked to at Guwahati.
Guwahati.
Correct.
My Lord.
Why this has been done within a week? It seems within a week, that also on a Sunday. You are for?
I'm for the forest department. Your Lordship.
Huh?
I'm for the forest department. Your
For
Lordship.
forest department.
Lordship, at this moment, a notice may be issued.
Notice, you see, you don't have to tell me about the issuing of notice. That this court will issue, but this court is asking you if you have to say anything about the interim that is being sought for. Because apparently on the face of it, this order looks illegal. How can this order be passed on Sunday?
Lordship.
Where are you now?
My Lord, I'm hanging because I went there and the officer said you come on Monday, and Sunday they did all this thing.
What order are you seeking today?
My Lord, this order is required to be stayed, and my Lord, I may be allowed to join there where I have been promoted. That is in Rangia, my Lord.
Heard Mr. S. Datta, Learned Senior Counsel, assisted by Mr. J. Ahmed, Learned Counsel for the petitioner. Stop. Also heard MS
M. Kalita, Your
M.
Lordship.
Kalita, Learned Counsel,
For the
Standing
forest-
Counsel?
Yes, Your
Learned
Lordship.
Standing Counsel, Forest. By way of this petition under Article 226 of the Constitution of India, the petitioner is assailing, not seeking, assailing the impugned notification dated 22/9/2024, whereby the petitioner was retransferred to the office of the Divisional Forest Officer, North Kamrup, whereby he was retransferred from the office of the Divisional Forest Officer, North Kamrup Division, Rongya, where he was posted as Assistant Conservator of Forest, to the office of Additional Principal Chief Conservator of Forest, SF, Aranya Bhavan, Guwahati. Correct?
Right.
Stop. Issue notice returnable 4 weeks. You accept for all?
Yes, Your Lordship.
MS so and so accepts notice on behalf of all the respondents. Extra copies within the course of the day. As regards the prayer for interim, Mr. Datta, Senate Senior Counsel, submits that upon being promoted to the rank of Assistant Conservator of Forest by order dated 10/9/2024, the petitioner was posted in the office of the Divisional Forest Officer, North Kamrup Division, Rongya, however, when he had gone to join the said post, he was not allowed, and it is learned that on 22/9/2024, which is a holiday, within bracket Sunday, the respondents retransferred the petitioner, retransferred or reposted?
Reposted.
Reposted the petitioner to the office of Additional Principal Chief Conservator of Forest, SF, Aranya Bhavan, Guwahati. Stop. Prima facie, the impugned order dated 22/9/2024 appears to be illegal. Accordingly, in the interim, in the interest of justice, it is provided the operation of the impugned notification dated 22/9/2024 is stayed, and the petitioner is allowed and the petitioner be Mr. Datta, I think this is sufficient, because otherwise it will be giving you the final relief.
Otherwise, the question would be, my lord,
I'm staying it.
Yes.
I'm staying it.
But then the original place where that place is also, my lord, occupied.
I'm staying it till the next date.
All right.
Obliged, Your Lordship.
Yes, Mr. Saikya.
Met the lordship. The petitioner of the lordship is the in charge Gaon Pradhan of the charge number 12. Respondent number 6 was
Is
selected.
this similar to that case, Gaon Pradhan?
No, my lord, this is
different. Yes.
My lord, the respondent number 6 was selected as the Gambura of the village. The petitioner before lordship filed an appeal before the appellate authority. That appeal is pending. During pendency of the appeal, she was sought to be removed. Then, my lord, she approached this honorable court, challenging that order. And this order, this honorable court, my lord, at page 49, passed an order directing the parties to maintain status quo. That order is, my lord, in operation. During pendency of the status quo order, another order was passed by the circle officer. The circle officer is against the petitioner. The circle officer, he is still working in the same place, my lord. He is against the petitioner. He wants to remove the petitioner. He passed an order.
What is the challenge?
Challenge is, my lord, page 69. Page 69. During operation of the status
You
quo
are
order,
challenging the appointment of respondent number 6 as
my lord,
Gaubura,
my lord.
a Gao Pradhan.
My lord, instance Gaon Pradhan, my lord, not regular Gaon Pradhan.
The notice only at this stage.
No, my lord.
No, Mr.
Lordship,
Saikia.
you kindly see, this is in violation of the
relieved,
post order, my
Lordship.
lord.
He has been relieved. She has been relieved.
No. My lord.
Mr. Saikia, do you want me to here consider the interim today and pass an order, or you would prefer that I issue notice on the interim?
My lord, Lordship, you pass the
What would
interim
you
order-
prefer?
Lordship, you pass the interim order today itself. my lord.
All right. Yes.
My lord. The interim order Lordship will find in the earlier round of litigation, Lordship will find at page 49.
Page
49, my lord.
49.
My lord. And relevant portion is page 52, my lord.
Page
52.
yes.
Paragraph 9, my lord. Till next returnable date, status quo as on date be maintained. Lordship, got it? Thereafter, my lord,
One
by
second,
another-
let me see in what context this order has been passed.
My lord.
You cannot simply show the last order and say and
Yes.
seek a similar relief.
My lord. Paragraph 2, my lord.
Yes.
The petitioner is a resident of village Suparjar, post office so and so, and she was appointed as in charge Gambura of charge number 12 under Bagbor Moja in the district Borpeta by order dated so and so. The petitioner was allowed to hold the charge of Gambura post pursuant to date of her husband, namely Osman Kuni Akan, who expired on so and so, while he was working as Gambura of charge number 12 under Bagbor Moja. In response to the advertisement of dated 3/9/2022, inviting application for the post of village headman for the local people of the areas, the petitioner submitted her application. According to the petitioner, in spite of she having requisite qualification and the private respondent, in spite of having requisite qualification, private respondent was selected. The petitioner agreed that the process of selection of the respondent authorities did not apply the provisions regarding reservation of women. The learned counsel for the petitioner submits that the apex court in so and so that Gaon Pradhan is an executive post and is under the supervision of Moja.
Here you have been selected.
No, Malad, I was not selected.
You were not selected.
That is why Malad, I filed an appeal before the appeal.
That appeal is pending.
That appeal is pending. And Malad, this honorable court directed the parties to maintain a status quo. As I was working as Incharge Gambura, I am still working as Incharge Gambura.
No, this court means in this case it is your case.
Yes,
You are the petitioner.
Yes, Malad.
Oh, you are the petitioner.
I am the petitioner.
So, in as per this case, but why did you have to come again?
Malad, this Indian order has been passed, appointing the private respondent Malad as Incharge Gambura instead of me, by replacing me.
No, what happened to that appeal?
Appeal is still pending, Malad.
But here there was already a status quo order.
Yes, Malad.
This order has been violated then.
Yes, Malad. That is my case, Malad.
This are, Ms. Bhattacharya,
Lordship.
is this because you see there is a status quo order? How can this status quo order be ignored? A serious allegation has been brought to the notice of this court.
Earlier also, Malad, the circle officer.
This order is very clear.
But
Needless to say, the appeal pending before R3 may be expeditiously disposed of, if not already disposed of, till the next returnable date. Status quo as on date be maintained. If anything has happened, the one could have moved before this court.
Yes, ma'am.
Lordship, only this thing is there, Lordship, because of public complaint, Lordship.
Ms. Bhattacharya,
Lordship,
please be mindful of what you say.
Lordship,
You've understood what I have pointed out.
Lordship,
We all are part of this institution, which we all have to uphold.
true, Lordship.
You are an officer of the court.
Lordship, then let us obtain instruction, Lordship.
Tomorrow,
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 Monday,
yes. You find out over the telephone
Lordship.
what has happened.
Okay.
Because if there is a violation, this court is going to be take serious
Lordship.
note of it. Such contemptuous actions cannot go on.
Lordship.
And that petition has been finally disposed of, my lord.
Mr. I.S. Saikia, learned counsel for the petitioner, by drawing the attention of this court to the order dated
22.
22/2/2023, passed in WPC 1008 of 2023, passed by the petitioner filed by the petitioner,
Filed by the petitioner. Filed by the petitioner.
filed by the petitioner, comma, wherein this court directed maintenance of status quo till the returnable date, comma, he submits that during the continuance of the status quo order, the petitioner, the respondents have appointed the respondent number 6 as Gao Pradhan of charge number 12 of Bagbor Revenue Circle by releasing the petitioner in total violation of the said status quo order. Stop. Let M.S.M. Bhattacharjee, learned additional senior government advocate for the state respondent, obtain specific instruction in this regard by tomorrow. List on so and so.
May I please your lordship? Lordship, kindly pass over the matter
Along
for
with take this
These
matter along with
matters
item
also
number
item
3.
three,
Item number
Three.
3. Along with item number 3, Lordship.
We are going to 3 only now.
Only after 3 everything will.
All right. 3 lagat name. Yes. No. 2 others. Yes, Mr. Fukan.
Yes, Your Lordship. Actually, they had submitted that date. Mr. Bhattakur was supposed to submit. Respondent number 7 has submitted. Respondent number 9, 10, and 11.
Yes.
Lordship, so far as the my submission, Your Lordship, I adopt the submission of learned senior counsel, Your Lordship.
It has been encoded.
Encoded,
The
Your
post of
Lordship.
stenographer.
Stenographer.
And has been
Translated.
translator.
And on the
And has been equated with the post of librarian.
Lordship. And there is
Mr.
one
Fukan, this is
judgment.
their argument. Yes.
And only, Your Lordship, I just want to point out Your Lordship, one judgment, Your Lordship.
Yes.
This is
Mr.
2007.
Chaudhary had given one judgment on
judgment.
past
Yes,
practice.
Lord
This
Suresh
is-
Nathan. Lord, the other, sorry, I referred to para 5, para 4 is also important.
Para 36 of this judgment, Your Lordship, on past practice.
This is the same one.
No, Your Lordship, this is different. Your
Just
Lordship.
a second,
This
just a
is
second.
Soilendra Dania and others
I will
versus
declare.
SP Dubey.
Mr. Chaudhary's was
2007
N.
5
Suresh.
SCC 5. Yes, Your Lordship.
4 and 5, Mr. Chaudhary.
Yes.
4 and 5. Yes.
9, 10, and 11, Your Lordship.
9.
I am for 9, 10, and 11.
9, 10. Paragraph 9, 10, 11.
Paragraph 36, Your
No,
Lordship.
no, 9, 10, 11 means?
No, I am for
Oh,
respondent.
respondent.
No.
एक रूपक लोग लिखी ले लो respondent numbers ये ले लो हाँ paragraph
Paragraph 36, Your Lordship. It has also relied on N. Suresh Nathan, Your Lordship.
yes
From a reading of the decisions rendered by this course, one thing is clear to us that your decisions in N. Suresh Nathan so and so are based on the interpretation of the respective rules, calls, and creation, giving meaning to the words used in the context of entire schemes governing service conditions and the facts involved in each case, and it cannot be said that decisions rendered by this court after decision have been taken a different view than what has been decided in N. Suresh Nathan case. Thus, we are required to decide the matter on the basis of the entire scheme of the rules, the facts and circumstances at the relevant time, and the rules called in question for us,
and past
independently giving meaning to the words, the principle involved, and past practice, if any, which is in consonance with the interpretation given by us to the rule. If we find that two views are possible after interpreting the rule, then the rule would be interpreted keeping with the practice followed in the department for a long time and does the practice practically acquired status of rule in the department, Your Lordship.
Past practice
If it
is
is
acceptable.
Lordship, acceptable,
Here,
and if it is
past
followed for
practice is one thing, but it appears there are notifications
Lordship.
equating the post
Lordship.
of translator to the post
Lordship.
of librarian,
Lordship.
and which is permissible under the rule.
Lordship. And Your Lordship will kindly consider one more aspect, Your Lordship. So far as Your Lordship, his claim against the other respondents, Your Lordship, respondent number 7 represented by Learned Senior Counsel, Your Lordship, she was already promoted, Your Lordship. And so far as the other respondents are concerned, his prayer for Your Lordship in respect of them, Your Lordship, claim in respect of them, probably, Your Lordship, in view of the affidavit submitted by the government, Your Lordship, might have, Your Lordship, become infructuous. The government, Your Lordship, has categorically stated in their affidavit that they have taken a policy decision, Your Lordship, not to promote anyone till, Your Lordship, rule is, Your Lordship, amended, Your Lordship, or new rule is brought in, Your Lordship. And if that be so, Your Lordship, until and unless that decision is challenged, Your Lordship, so far as his claim or the other respondents is virtually become infructuous, Your Lordship. This is my humble submission, Your Lordship.
Yes. Yes. Anything more? Please give all your names. Yes, Mr.
Please, Your Lordship. Today I will be rebutting, giving my reply, my lord, to the points raised by my learned senior counsel, my lord, on the other day, my lord. My lord, the first point which I would like to rebut is that, my lord, the first point which learned senior counsel had taken was 3(2)(b). If Your Lordship takes up the rule, page 4 is the internal page, my lord.
Yes. Rule 4.
Rule 3, man.
Rule
3(2)(b), that is, service may include. The first point.
Yes.
Yeah, page 3. The page 4, man. Page
Yes,
4.
I have it.
Yes, Lordship. The service may also include any post equivalent to a post in any of the cadres mentioned in sub-rule 1, my lord, and any cadre or post laid down by the government to be included in a cadre of service. Now, my lord, the first thing they relied on was the my lord, page 138 and 142. Lordship comes to page 138 of their, my lord, of their affidavit.
Yes, I have.
Yes, Your Lordship. This particular thing I would like to point out is that page 138.
Yes.
My lord, here, if I may, I'll read, my lord. In inviting the reference to the letter on the subject quoted above, I have the honor to state that the post of translator of this directorate was created and written so and so. The proposed encadrement of translator may, my lord, will I kindly note here, may.
Yes.
May perhaps be made by the government. So, my lord, it was just a normal communication. It's not even an executive order. This is a mere communication from the then director in 94 to the deputy secretary. There is nothing to show, they have nothing concrete to show that this is a particular executive order. And even though, my lord, if it is, after that one more point, next page, 142, page 142, annexures 3. There also, my lord, if your lordship comes to A, that day, my lord, they had read B. Kindly see B, A first. Implementation on the recommendation, your lordship got it? Implementation of the recommendation of the Pay Commission 1994, encadrement of translator of Finance Budget Department. That's different, my lord. With that of Public Relations Department is feasible. It's just a suggestion.
That is all right. Then
My lord,
come to B and D.
Yes, your lordship. Then, my lord, D says Rule 1125 of the Assam Information Public Relations Service Rules 1986 has clubbed together journalist, subeditor, proofreader, librarian together for promotion to the JIC. The scale of pay of translator is also equivalent to that of these posts. As such, the appointment
What
will be
more
guided by the same.
clarification is
Now, my
required?
lord, no, my lord, I would,
And just see the next line.
my lord,
No separate
a
rules.
separate proposal suggesting to government to empower the department selection committee to select translators is being sent separately. It has not been sent, my lord.
No.
The last
As
part.
such, their appointments will be guided by the same rules.
Yes, your lordship.
No separate service rules will be necessary in
my
this
lord.
regard.
We are, no, my lord, we are.
See, Mr. Fukan, the issue, you have to appreciate that this court, while exercising powers under 226 in terms of promotion challenge matters, is very limited.
My lord,
Now you have to show why the promotion order is bad, right?
I'll show it
If you would have if you can show it is divorce the rules, one could have understood. Now it appears a reading of the rules that in case of equivalent post that is covered.
Can my lord, I will submit.
You see
I got
it
the
appears
point.
prima facie that rule shows.
My
Now
lord.
documents have been put before this court firstly to show that the post of translator is already equated to the post of librarian. Page 142 prima facie shows that. That apart, the averments made in the affidavits filed by the government also shows that it has been doing so for a long for in the past.
I'll come to
So
that.
therefore, it is the past practice
That
also.
also, my lord, I have a debate.
Correct.
I'll come later to that.
So just confine your argument to
My lord,
this.
I'll come, my lord. My lord will hear me, my lord. Next point, my lord, if your lordship here. So what my take is, my lord, that this particular thing is not a. It's not
All
an
right, I've
executive order.
noted. According to you, it
It's
is
not
not.
an executive order. It's just a suggestion by the.
According to you, this is not an executive instruction.
It's not, my lord. It's just a letter from the director to the deputy secretary on
All
top.
right.
And just they are saying it's feasible.
All right.
And my lord, I will show judgments regarding that also, that executive instructions cannot override statutory provisions. As on date, my lord, there is no amendment.
Override.
Cannot
You
override.
see, these are settled principles of
My
law.
lord, my lord.
You cannot override. But if there is a gap, you're explaining that is different.
I will show, my lord. I will showcase. My lord,
Yes.
lordship will kindly come to the. My lord will kindly come to my reply now. My reply, that is the AIR. My lord, filed by me. My lord, reply to the R7's affidavit at page, my lord, 183 first, annexure 1.
Page
183, my lord. Annexure 1. That is the affidavit filed in reply filed by me. This here I will showcase, my lord, that all first of all we are from the feeder cadre. Our cadres are all different, my lord. The advertisement itself will show that they have been relying that our posts are all equivalent. First of all, my lord, our post is totally different from theirs. Each post is distinct. Our exams which we have given when we have joined the advertisement is separate. Our qualifications required for being a librarian is separate. Their qualification for becoming a translator is separate. If everything was equivalent, if our jobs were equivalent, then why would we have these kind of, why would the advertisement show? I would like to show. Kindly see, my lord, at page 183. Has your lordship got it?
Yes.
There, serial number 2. That is
What is this advertisement?
This is, my lord, the advertisement
Advertisement for?
for my lord, recruitment of all these people, my lord.
Okay.
Because based on this only they were recruited.
Okay.
So this will show that all our, my lord, qualifications, everything is separate. All our job profile only is different. A librarian cannot
You
do
are
a
trying to
translator's
say
job.
that the qualification for translator and librarian are different.
Yes, my lord. So they have not shown that, my lord, before. Translator, my lord, 5 posts, if your lordship sees.
Yes, I think you had shown this
Yes,
document
yes.
on the last
My lordship
occasion.
comes to the required qualification column.
Yes,
And there, my lord, for education qualification, minimum education qualification for the rest of the posts is a bachelor's degree in arts, science, and commerce from any recognized university, minimum 6 months diploma in computer application with typing skill in SMEs. Other essential qualification under candidate must be capable of translating any matter, my lord, from SMEs into English and vice versa. This is for the translators. Now, librarian specifically, my lord will see note there. Librarian education, the minimum education qualification is bachelor's degree in library science or graduate in any discipline with PG diploma in library science from any recognized university, my lord. And other requirements are adequate knowledge of latest software packages of computer application in library management, my lord. It cannot be anybody. Anybody can man my post, my lord. If they are saying it's equivalent, will a translator man a library, my lord? How can they have to have a proper degree? And this shows that our
Mr.
posts are
Fukan,
different.
when you address the court, you don't ask a question.
My lord,
When you address the court, you don't ask a question.
my lord.
You can pose the
Apologies.
question to yourself and place it before the court.
Well, that's what I'll.
Please be mindful in the language that you speak.
Fine.
Yes.
Then, my lord, like library management, DTP, and internet, my lord. So this is the point, my lord, that their qualification itself is totally different. So we are
All
totally
right.
distinct and feeder cadre. Now, my lord, apart from this, my lord, I would like
One
to.
second. Let me note down your argument.
Yes, ma'am. That is at page 183.
Qualification different. That's what you said, right?
Qualification, we are from feeder cadre. Our whole so this thing is different in the advertisements.
All right.
We are distinct from them.
Yes.
That shows there's no equivalence in our work.
All right.
Which gives us. Now, my lord, I would like to place, my lord, certain judgments, my lord. First is, my lord, I would like to place
Yes.
First, I would like to place. I'm giving a copy.
You will look. Mask. Yes.
My lord, I'm giving a copy to the other side also.
Yes, yes. Kuppa Swami.
Kuppa Swami, my lord. Kuppa Swami, it's a one-page judgment, my lord. It's a three-judge, my lord. Para 3, I'm relying.
There is no quarrel to this.
My lord, para 3, I would like to just point out, my lord. Para
Yes.
3, I would count, my lord, sequentially, my lord. First, my lord,
This
I would say
court is appreciating
short
your
point, the short point on which these
arguments,
appeals
but-
must succeed is that the tribunal fell into an error in taking the view that since the government had indicated its intention to amend the relevant rules, its action in proceeding on the assumption of such amendment could not be said to be irrational or arbitrary, and therefore the consequential orders.
Which executive order has overridden the statutory provision,
So,
Mr.
my lord,
Fukan?
here too there is no,
Which one?
there is none.
Then why
No,
are
I'm
you?
just-
You
I'm
see,
just
Mr. Fukan, you can keep arguing
No,
for the
one-
whole
one
day,
point I want to show,
but please argue to the
Just one point I want to show.
Mr. Fukan. Which point do you want to show? Before you place this decision before this court, first show that
This-
there has been an
the last
executive
part, the last part,
instruction
the last
which has overridden the statutory provision.
The last point.
Yes.
The relevant rules it is admitted were framed under the proviso to Article 309 of the Constitution. They are statutory rules. Statutory rules cannot be overridden by executive orders or, my lord, one more thing, executive practice.
I understand.
So this is
But
one thing.
what has overridden the statutory rules?
Well, they have divorced the rules, promoted the petition. I mean the respondent.
Mr. Fukan, they have shown something. Now, that particular document at page 142, which you are saying,
That is not an executive instruction.
that is understood. I have accepted that argument of you. But if you want to rely on this decision of Kuppaswamy, first you have to show that there is an executive instruction which is overriding a statutory provision. That is why I'm asking.
No, I'm saying, my lord, in that context that even though if it was an executive instruction, then also they couldn't have overridden it.
All right.
This I'm relying on. And here, my lord, even executive practice also cannot override it. So this is one judgment, my lord. Para 3, I'm relying on this.
Yeah.
And next, my lord, same two paras, my lord. One more case, my lord, supporting this itself. My lord is Paluru Ramakrishna, my lord, which is
On the same point,
1989, my lord, I'll just give it, send it over, my lord. 1989, I won't repeat it, I'll just give the relevant para. 1989 to SCC 54. And then I'll come to the past practice part. That part I'll have to show. 1989 to SCC. My lord, I'm handing over a copy, my lord.
Thank you. Yes.
1989 to SCC 541.
Yes.
Here I am relying on para 10, 11. At page 8, my lord.
All right.
There also the same thing, my lord, has been reiterated. Nagarajan case also has been cited there.
All right.
That executive instructions or executive practice cannot override, my lord, the Article 309 rule when the rule is in force. Since there is no amendment to the rule till date of the 86. Thereafter, my lord, I would like to show, my lord.
Blinders click.
That was a 3-judge, my lord, and this is a 2-judge bench, my lord. Same relying on the same thing, my lord. Page 4, my lord. This is 89-1 SCC 175.
Page
1989-1 SCC 175 is the thing.
This is on past practice.
No, my lord. This is also same. Relying
Same.
on this, and after this, I'll come to the
Why you need so many decisions on the same point, Mr. Fukan?
My lord, page 4, para 6.
All right. And
Now, my lord, I'll come to past practice.
when you need to multiply
Sorry, my
the authorities,
just wanted
it
to be sure,
indicates that you are accepting your case is a bit weak.
No, my lord. Handing over the past practice thing also to the. My lord. This is a crucial judgment which I would like to rely on.
This is past practice.
Yes, my lord. This is counter to
Papers, arrange your papers, no
Yes,
problem.
My lord, this is D. Stephen Joseph.
Yes.
I've given a copy to the other side.
Yes.
1997 4 SCC 753, my lord.
Yes.
This has special mention to the case which they have relied on, my lord. This, my lord, I would like to showcase paragraph 5 of page 3, my lord.
Para 5.
Para 5, page 3.
Yes. Yes.
It appears to us
That Surasnathan case.
that case, ma'am. It appears, they have mentioned it here. It
Yes.
appears to us that state government is laboring under a wrong impression as to the applicability of the past practice as indicated in Suresh Nathan case. This court in the said decision has only indicated that past practice should not upset, provided such practice conforms to the rule for promotion. In our case, my lord, it has not conformed to the rules. And consistently for some time, past the rule has been made applicable in a particular manner. In our view, the decision in Nathan case only indicates that past practice must be referable to the applicability of the rule by interpreting it in a particular manner consistently for some time. Now, my lord, this part is the most crucial part. Kindly note, my lord. Any past practice, my lord, any past practice beholds the rule cannot be taken into consideration as past practice, consistently followed for a long time by interpreting the rule. Any past practice, my lord. Here they are relying on the past practice, but they are going against the rules. That is Rule 11.25, where it is specifically mentioned that journalists to be a JIC, that is Junior Information Officer, you have to be from the feeder cadres of, my lord, feeder cadres of journalist, sub-editor cum proofreader, and librarian, which is me. And I have showcased, my lord, at page 39 on that day, my lord, that the journalist was rightly promoted, the sub-editor was rightly promoted, but instead of both of us, the practitioners, they promoted the dehouse the rules, this one. So this they cannot, my lord, this shows that it distinguishes that case. And my lord, therefore, my lord, again I would like to come rule 11, therefore I would like to come to the rule again once. My lord, rule 11, my lord, rule 12, which I rule 12.2, subclause 2. My lord,
You recognize the past practice, but you contend that the past practice
Divorce.
should not be divorced.
that is what my submission is. And my lord, here I would like to now place rule 12.2, my lord. Again, I would like to not 12.2, my lord, rule 19, sorry, 19 subclause. Therefore, my lord, since this error has, when I have made a prima facie case out, my lord, where I have shown that there is an error apparent on the face of record, and I have backed it with cogent materials. So therefore, my lord, I have shown that there is an error. There is an error apparent in the face of record that the person has been promoted. So I have backed it with cogent materials, my lord. So therefore, I am relying on this particular clause now, my lord. 19 subclause 2. They have already made a provision out here. And 19 19 at page 17, my lord, internal.
Yes. Yes, yes.
19.2 says, my lord, I will say a temporary or officiating member, my lord, a temporary or officiating member, in our case it's officiating member, shall be liable to be reverted to the original post if, my lord, it is found to on a subsequent verification that he was initially not qualified for the appointment. So in our case, my lord, this is a fit case that, my lord, your lordship will invoke 19.2 and revert her back to the original post, and my lord will promote us from that day onwards, like my lord. And my lord would likely come to page 39 of the main page.
Can this court promote you?
My lord, I have made a prayer, my lord, because, my lord, I have made a prayer also in that case, my lord, because I should have, because my seniority will be affected, my lord, in the extraordinary powers, my lord. My seniority will be affected, my lord, and I am rightfully due, my lord. I have been working diligently, my lord, and my lord, I would like to just show one thing, my lord, that if your lordship comes to page 39 again of the writ petition, my lord.
Yes.
Writ petition, my lord.
39.
Yes, your lordship.
Yes.
At third para, my lord, where her promotion is given. Already it is given, my lord. That's why that they had said, my lord, subject to reversion without notice. First part, subject to reversion. She
You
can,
had, yes,
my lord.
I remember.
I just want to, my lord. And one more thing I
The
need to point out,
petitioner, no, the R7 is the third one, no? Moshami Bhattacharya.
yes, my lord. And one more thing I want to just point out, my lord, off the record, in the sense I would like to show it, because here they are saying that the rules regarding the encadrement has been done, encadrement and everything has been done. Here, my lord, I just received this today from one of the
Please give a
clients.
copy to the other
I
side.
have given. My lord, behind the scenes, my lord, this is going on. They are trying to amend the rules now. If they are already they are saying that it is an equivalent, they are considering that it is an equivalent post, my lord, and everything. Why are they having meetings, my lord? And when I kindly see the last person, my lord. The last
What
person,
are you trying to show from here, Mr.
Well, I'm
Pukal?
trying to show that they are trying to make amendments out here, my lord, also.
They're not entitled to make any
They are,
amendments?
no, I'm just saying.
Is there something illegal for them
No,
to
no,
make
it's not
any
illegal, my
amendments?
lord. What I'm trying to point
Then
out over here.
does this document shows that they're trying to bring in the
No, no, no,
color
no, no,
of
my lord.
a translator or anything?
My point is not that, my point is
Then-
that they were saying that it's equivalent, no, my lord. And in
But where does this say that it is talking about that post?
they are saying that they want to, my lord, now amend.
Matlab? What is matlab?
My lord, they're trying to say that they're wanting to amend the rules. So
Yes.
on this side, they are trying to amend the rules, trying to bring all
Amend the rules in what context?
in the translators, trying to
Where
include
is
the
it?
translators.
Where is it mentioned translator here?
Because my lord, all these people are the same people. Directly inform me that a meeting
And
has
how
been
can
scheduled for
this
verification
court
of
take
draft information.
cognizance of this document which is just
I
passed in
just
this
pointed it out,
fashion?
my lord. I just pointed out. My lord.
No, please don't point out like this. You want to bring something, you bring it by way of an affidavit. You cannot just pass on papers and start making submissions on that, Mr. Fukan. This is the court of law. You can't, and this doesn't indicate anything. How do we know what is this? Just because
It's
the
said, my lord, that it's a
just
draft
because the
assignment.
government wants to make some amendment in the
That is the amendment.
Assam Information and Public
Because
Relation.
the respondent number 7 herself is there as a member in this. That is why I'm saying. Respondent number 7 at the bottom, the last member. My lord. That is why
What is Mr. Chaudhary? Can you enlighten what is this being?
No, my lord, the government wants to perhaps want to amend the rules.
Correct.
It doesn't indicate that they want to incorporate a particular,
Absolutely, that
provision.
because it does not indicate
It's
that.
a continuous process, my lord.
I just pointed it out. My lord.
In their affidavit, they have made a statement.
And my lord, in that statement also, my lord, one more thing. Last part I want to say something, my lord, regarding the government's affidavit, which they have said, my lord, at page 77, my lord. Page 77 of the respond number 3's thing, my lord. 77.
Yes,
There, my lord, at para 6, my lord,
the notification of orders.
they have already given, my lord, if I may, I'll be allowed to read, my lord. The translators along with journalists and librarians are getting promotion to post.
Where are you reading
Page
from?
77.
Page?
77, my lord.
I have page 77.
77.
Page 77.
Yes, sir. Page 77 of the affidavit in opposition
No,
filed
where,
by the government.
which has para 7, isn't it?
Yes, sir.
It's
Para
an-
6, my lord.
part of para 6.
Part of para 6.
So which part are you reading?
I'm reading, my lord, bottom from bottom, my lord, it's
77.
my lord, the 10th, this thing, my lord. The notifications.
Oh, yes.
The notifications or orders facilitating promotion of translator to JSC must have been issued on the basis of some office records by the Home Department. However, my lord, kindly note this part. However, no such notification or could be traced out in the directorate or department as in the 97. So they have themselves edited, my lord. There is no notification or executive order regarding translators, my lord, and my lord being my lord equivalent. My lord. And plus, my lord, I have shown with the advertisement itself that all our jobs are different. My lord. We are all specified jobs, and everybody's role is different. Everybody's job profile is different.
This document at 138 and 142 has been brought on record by which affidavit?
My lord,
Yes,
respondent number
by
7
us.
Huh?
By us.
By them.
By them.
Respondent number 7.
By the private respondent.
Private respondent. So that thing, my
And
lord,
where is the averment in support? Para 6.
6. There is no record. That's what the government is saying. That translators are same. There's no notification.
Mr. Fukan, let's read 142 again.
142.
142, because this has some bearing in the matter. So let us read it again from the beginning.
With reference to your letter on the subject cited above, I furnished first of all
Subject,
from the
read the
director to
subject. Subject is encadrement of translator
It's for encadrement.
and of translator.
Suggestion for
No,
encadrement.
subject is encadrement of translator.
Suggestion.
Why are you adding word? Where is the word suggestion there? In the subject.
Subject.
Do you find, correct me if my eyesight, there is something wrong, but I cannot find the word suggestion in the subject.
My lord,
Where
it's a
is the word
letter, my lord,
suggestion?
where the subject is encadiment of translator.
Yes, where is suggestion there?
It's not there, my lord.
Then
I
why are
apologize.
you saying suggestion?
Came out, my lord, and so I apologize. It is
Yes.
from the director, my lord, to the deputy secretary to the government of Assam, Home Department. And the subject is encadiment of translator.
Yes.
And my lord, it says, my lord, that sir, with reference to your letter on the subject cited above, I furnish below the required clarification. Implementation of the recommendation of the Pay Commission 1994 encadiment of translator of the Finance Budget Department with that of the Public Relation Department is feasible. I'll carry note that it's feasible. The scale of pay the translators of the Finance Department and that of this department is the same, as all the posts of translator in Finance Department have been lying vacant. Their seniority after encadiment will come under translators regularly appointed in this department. Non-implementation of the recommendation of the Pay Commission after getting no objection from Administrative Department is primarily due to non-implementation of the recommendation of the Pay Commission after getting no objection from the Administrative Department is primarily due to formal notification from the Administrative Department encadering cadres of the translators of Finance Budget Department with that of Public Relations Department has not yet been issued. My lord, can you note that?
Yes, please go
Then, my
ahead.
lord, 2. The departmental committee constituted by the government to appoint non-gazetted employees in the department has no power to select candidates for the post of translator as the scale of pay of translator is higher than the scale of up to which selection is empowered to the committee. ROP rules 1990 15 to page 12 has suggested encadiment of translator in the finance budget department only. Only, man. The ROP, C says ROP rules 1990 15.
Yes, yes. Now come to D.
And D, rule 1125 of the
See,
Assam
Mr. Fukan, don't get so anxious. You just read it calmly. We are trying to understand. Now come to D. This rule 1125 is that rule which you have been showing, right? Yes. Now read that, please.
Rule 1125 of the Assam Information Public Relations Service Rules 86 has clubbed together journalist, sub-editor cum proofreader and librarian together for promotion to the JIC, that is Junior Information Officer Group. The scale of pay of the translator is also equivalent to these posts. As such, the appointment will be guided by the same rules. No separate service rule will be necessary in this regard. Now, my lord, a separate proposal suggesting to government to empower the Departmental Selection Committee to select translators is being sent separately. It is being sent, man. It has not been encouraged. They have just sent a thing, propose that suggestion or proposal, my lord, if I may add. This part is crucial, my lord, the last part. A separate proposal suggesting to the government to empower the departmental selection. But as on date, my lord, the rule 1125 has not been amended. Still, that rule
1125 does not require an amendment.
Right.
If there is an executive instructions by which the post of translator is said to be equivalent to librarian, that is it.
And
That
my
is
lord,
it.
I have
But
also
the
brought-
only difficulty for that this court is facing, Mr. Chaudhary, is because of the averment in the government affidavit, which says they have nothing. Correct. And this document, because 138 on the other day also I had pointed out.
If your lordship would kindly have a look at the last sentence of page 142.
140.
That is one document
142.
which your lordships may like to call from the government. That
Yes.
will cleanse the issue.
Yes, yes. Which one?
Last sentence of 142, my lord.
Yes.
A separate
Yes,
proposal
this is what just now Mr. Fukan-
suggesting to the government to empower departmental promotion committee
Yes.
to
So
select
what has happened
translator.
to this?
This
What
lordship
has
may
happened?
call
I
for
think a little
to
clarification is
Uh-huh.
required here, because you government, you see, you cannot simply say that nothing is available in your office and file it on oath. What kind of an affidavit is that?
No, my learned senior has
It is the private respondent who has labored the hard work and got hold of these enclosures, which indicates that there is some.
100%.
There could be, you see, but this does not indicate that for 100% this has been done.
So what is
Now,
the
if this
extension of
court
this
has to
process?
author a judgment, the short point is only that if you show me that it has been encadred, that ends the matter.
Lordship, 100%.
That's all is required.
So
Have I understood it
no,
correctly? or not,
and
Mr.
that is why in the past also they have done it.
No,
Yes.
correct, but
No, that's what I'm saying. Because there
going by
must be
the
some
past,
authority.
it appears that there is something.
Yes.
Now, where is that? Probably there is something, because here even that clause D suggests that the scale of pay of the translator is also equivalent to that of these posts.
Lordship,
But
there are no
but you
separate
see,
pay scale.
it talks about the equivalence of the pay,
Yes.
but it It doesn't say that it has been considered as an equivalent post
And the
or
second
something.
line is that therefore there's no required for any separate rules for that.
Correct, but then what about the last line?
Hmm.
A separate proposal suggesting to government to empower the departmental selection committee to select translators is being sent separately. What has happened to
I
this?
think that must be there, Miller.
Must be.
Yes,
I'm
because that
quite
was
sure
from
because
the directorate to the government.
Correct, and otherwise, how these promotions were being done?
Correct.
Or perhaps there is some document. You have a look at it.
So I'll give the updated status of the proposal, Lordship. What has happened to the proposal?
The Lordship is absolutely correct, my lord. Government affidavit could have been much better.
Correct.
And my lord, one more thing, my lord, regarding the encardment also, I have placed the judgments also, my lord, where my lord
That's all right, Mr. Fukan. Since everything depends on this,
Yes, my lord. And
let
also,
us first give a chance and find out if something can come.
Yes.
During the course of the hearing, it has come out from the notification dated 21/9/2024 issued by the Director of Information and Public Relations, Assam, Dispur, Guwahati, pertaining to the subject of encadrement of translator, which is enclosed as Annexure 3 to the affidavit in. This is which affidavit?
this is affidavit filed by the respondent number 7, my lord.
Affidavit in opposition filed by the respondent number 7. That a separate proposal suggesting to government to empower the departmental selection committee to select translators is being sent in connection to Rule 1125 of the Assam Information and Public Relations Service Rules 1986. Stop. Before proceeding further, before proceeding with the hearing further, this court is of the opinion that the government respondent, that the respondent number 3 be directed to place the status of the proposal and also the relevant notification by which the post of the translator has been made equivalent to that of librarian, librarian stroke journalist stroke sub-editor cum proofreader, if any. List again on, yes, when do you want it? On the reopening?
Yes, immediately after the.
My lord, will extend the interim to the next date of listing.
Of course, Mr. Fukan. This matter is part heard. Yes, date please. List on such and such day.
Any date convenient to Lordship after the reopening.
Reopening or piece up?
22nd? 22nd.
List again on 22nd so and so. And interim, if any, shall continue to the next day of listing. Matter shall remain as part heard. Huh?
My lord, this matter will be taken up after some time, my lord. Learned AG is appearing, my lord. He is in court number 1, my lord.
Well, 3 and 45 may be taken together. Same matter.
3, 45 and 26.
No.
42.
3 and 45. 3 is a motion.
No, 45 is a motion.
Oh, sorry.
45.
What is the issue involved here?
Millard,
What is the issue involved here?
Millard, the issue in this case is the petitioner Millard, he originally belonged to Health Aid Department of Government of Assam. At one point of time, this Tezpur, it was a mental hospital. Subsequently, in view of the judgment of the Supreme Court in Millard Syllabus's case, it was taken over by Government of India. Now, at the relevant point of time when all these developments took place, the petitioner was joint director. Now, after the institute was taken over by Government of India through Northeastern Council, the petitioner was made the director in a non-tenure post. And subsequently, my lord, he was also made the professor.
Some instructions were required from the health department.
No, my lord,
No.
no, in the second, in this item 45, it's a motion. And in the item number 3, my lord, their pleadings and everything are complete.
Because it appears it was directed to be listed today as a first item.
First
item.
Well, my
Alright.
lord, what had happened? Both these posts of director and professor, these are inseparable. Now, wow, what the authority has now done, my lord,
They've clapped
now
it.
they have appointed as an in-charge director. And my lord, in-charge can be given in a post in terms of FR 19.9 when somebody is having lien over the post. No, there is no
But
none.
as far as 3 is concerned, it has come for admission today.
3 is a motion. Sorry,
No,
45 is a motion. 3 has come up for admission.
Anyway. Yes. Health. Is there be some instructions I think was sought
Yes,
for?
yes, Lordship.
You have it?
We have received that written instructions, Lordship.
You are supposed to take a policy decision
Yes,
for
Lordship.
granting of AICTE pay scale.
Yes, Lordship. in
Postgraduate
homeopathic
teaching
colleges.
staff. Have you given a copy to the other side?
Yes, Lordship. Yes.
Yes.
So on this figure, some time may be granted, Lordship.
Some?
It will take some time, Lordship. After vacation.
Yes. MS Devi, Learned Standing Council Health
Health Department, D.
Uh,
Bora.
furnishes a copy of the letter dated 21/9/2024 received from the Joint Secretary to the Government of Assam, Medical Education and Research Department, Dispur, whereby the Director of Ayush has been requested to submit a report on the policies adopted for improving the functioning of SJNHMCH, particularly in the areas of academics and patient care services. And it is further mentioned that only upon such report being reviewed, the pay scale enhancement of for the facilities of SJNHMCH can be proceeded. Stop. She accordingly submits that she accordingly seeks further further 2 weeks time to place
Let it be 4 weeks, Lordship.
4 weeks for what?
For
having the
for the
policy.
policy to be.
So she accordingly seeks 4 weeks time so as to place the policy decision by the next date of listing. Prayer is allowed to list after 4 weeks on a date to be fixed by the registry. This I will keep, or
yes,
a copy of the correspondence dated 21/9/2024 is kept on record and marked as X.
Till 6 to 9. This matter may be taken after suspension.
Why?
Lordship, in this matter, I have received the instructions as per the Honorable Court, Lordship. I will file an affidavit, Lordship.
All right, let
2
her
weeks
file.
time may be granted,
As
Lordship.
prayed for by MS
D. Bora.
D.
D.
D. Bora, learned Standing Council, Health Department, which is not opposed by the other side, list this matter after 2 weeks on a date to be fixed by the registry to enable the Health Department to file their
File an additional affidavit.
affidavit in the matter.
Obliged,
Report
Lordship.
the instruction. To bring on record the
Yes,
instruction.
additional affidavit.
Yes.
To bring on the instruction received by way of an additional affidavit. Yes, RP Sharma. No, TC Chuda, government advocate. Yes, 10 days affidavit. What happened?
Also, it has been informed to me by the emphasizing additional senior that the affidavit has been filed today itself, Lordship.
Affidavit is filed.
Today, I think today itself it has been.
Have you received?
How-
How can it be filed when they have not
Just
received?
I will take some information from the office, Lordship.
No, but please have your information correct because you cannot
It was
file
only
anything.
verbal information. Is that
No, it
actually-
may be that they are filing it within the course of
Yes,
the day.
yes, yes.
That is a different thing.
At what stage? Lordship?
No,
Others,
but
Lordship, give me some time, Lordship.
because you see, you are making a submission before this court, and this court is going to record that submission. So be
No, it
mindful.
can be recorded. The process of filing the
Correct.
affidavit
So
is
say that there's no difficulty. Mr.
CKS Bora.
CKS Bora, learned government advocate
government
for the
advocate.
state respondent, submits that the affidavit in opposition shall be filed within the course of the day. Stop. In view of the aforesaid assurance, list this matter immediately after 2 weeks on a date to be fixed by the registry.
Please, Your Lordship. Under the issue invoked in this petition, like the
Yes, government.
Lordship, here what happened, Lordship? We have received the information there. Lordship, one copy maybe.
I think there was when there is a case.
Yes, Lordship, the record, Lordship. I have the honor to request you to submit a photocopy so and so. It may be stated here that original service book in respect of the said pensioners could not be traced up from our end. This is from Director of Pension to the Chief Executive Officer to the PND department. So that is the thing, Lordship. It is
What
a
is
case
to
of.
be done? Take some. You find out. I am adjourning it today.
In fact, PND department. At least the PND department should also be there, Lordship. They also have to
Who
take
is
some.
appearing for PNRD?
I'm from on behalf of.
He doesn't know anything. But at least this payment of pension has to
Yes.
be from the department. Also,
You are a standing counsel?
No,
then
on behalf of SZ.
When did you join the bar?
1 month. Lordship.
1 month. It's very, you see, it's very unfortunate when the department sends juniors who just joined the bar
yes, Lordship.
to
And
attend a matter of such where high stakes are involved. It's a pension matter.
Lordship.
It cannot be dealt like this. Please ask someone to be here from PNRD. We'll take it after some time. This is not correct. You cannot just simply send someone only for the marking the attendance.
But chief would
May please, Your Lordship.
Yes.
The opposite side had to file an affidavit and had to drop the records.
Wait, what is the issue?
Mother, the issue is here, Mother, the private respondent has been promoted.
Senior assistant.
Yes.
Yes.
Lordship, we haven't received the instructions as of yet. So
You have not received instruction.
No.
So when are you going to receive the instructions?
we'll file the affidavit as soon as we get the
As soon as you.
As soon.
So you don't have a day, you don't have a time frame within which you will receive the instructions. Here also you are appearing for PNRD.
No, this is for on behalf of K. Kumar.
Where is Mr. Kaur?
He haven't arrived yet for some personal difficulties.
Huh?
For some personal difficulties, he hasn't come today.
Mr. Naik, you're seeing what is happening. This is difficult. Some sense of responsibility must be there, isn't it?
Yes, sir. Definitely.
I can understand in some situation you need to send someone, but PNRD and all, even here,
Lots of other standing councils are there.
correct, somebody may, I am not
wait for-
appreciating the manner in which a junior who's just joined a month ago has been sent for seeking time.
If
And
Lordship
it
waits for
matters-
some time, Lordship, other councils may appear.
You please let them know, Mr. Nayak,
Lordship, I will call.
because it is difficult, you see.
Yes.
Anyway, in this, I am giving you the time. Let them, as prayed for, on behalf of Mr. K. Kumar, learned additional AG Assam, comma, list this matter after 2 weeks for enabling the state respondent to file their return in the matter. Interim order passed earlier shall continue till the next date of listing.
May Lordship, I am here on behalf of Mr. K. Chief. He is unable to come due to some personal difficulties. Kindly attend the matter for
You are for the petitioner?
yeah, for the petition.
All right. Item 618. No? Mr. Nayak, anything you want to say?
Yes, this is matter relates to regularization, Lordship. We have already filed my affidavit. Matter relates to Handloom and Textile Department. If they intend to file their reply, Lordship, in the meantime, they file, Lordship.
You want to file any reply?
I'll take necessary instructions from my senior counsel.
This is what is happening, you see, for both sides. As prayed for by MS, A, so and so Learned Counsel for the petitioner list this matter after 3 weeks on a date to be fixed by the registry. It is needless to be clarified that if the petitioner which desires to file a rejoinder to the affidavit
Filed by the Finance Department.
affidavit in opposition filed by the respondent number,
Respondent number, the Finance Respondent number 4, Lordship.
I think 2 replies have been filed, Mr. Nayak. There are 2 AO, 1 by 2, 1 by 4, and there are 2 affidavit in reply.
In that case, Lordship may fix this matter
I
for
think it has
hearing.
been already
Lordship.
filed.
Yes, Lordship.
Just adjourn it, huh? List after so and so, as prayed.
Item 19.
Compassionate.
Appeal pending.
Yes, father died on 22/108, applied 12/12/8. DLC 2009. DLC rejected?
No.
Recommended.
DLC recommended,
And
Lordship.
then SLC rejected in 15/2/2022.
This last 3 years, this one, Lordship, and this one appeal pending, Lordship.
Appeal is pending.
Appeal pending. It has been admitted, Lordship, because the bunch of repetition was disposed of on this ground, Lordship.
What is to be done then?
Lordship, can you see the last order? That was already with pension.
Last order?
Yes.
Last occasion, I appraised your Lordship that appeal is pending, Lordship, but I could not give the number, Lordship. The 287/23, Lordship.
Yes, it's there. Though court has been informed that the issue involved is. So then I will adjourn this.
Lordship.
In view of the
Pendency of
One thing I will.
There is an appeal pending. Then it is submitted. It appears that
Last order, the case which this court, my lord, the order dated, my lord, 21/4/2022. It was passed, my lord, in WCC 26886 filed by the petitioner, page 57, my lord. In that case, while this was decided, my lord, on that day, my lord, there was this office memorandum which is challenged and set aside, my lord, it was in force. The honorable court, my lord, while deciding the case of the petitioner, my lord, in the same ground, my lord, has given a direction that has interfered with the 3 years lapse period, my lord, and thereafter directed the authority, my lord.
okay. It appears that the issues involved in the present writ petition is sub judice before the division on before the Honorable Division Bench of this court in WA 287 of 2023. Stop. It further appears that this court earlier on 16/10/2023 directed in view of the aforesaid pendency of the appeal, directed listing this matter in the first week of December 2023 with liberty to the parties to inform this court by making a mention in case of any outcome in the writ appeal. Stop. Since today when the matter is called, it is submitted at the bar that the said appeal is still pending. In view of the aforesaid endorsement made by the learned counsel for the parties, let this matter stand adjourned sine die, giving liberty to both sides to inform the registry in case of any development in respect of WA
287, Lordship.
287 of 2023.
Obliged, Your Lordship.
Instead of considering the persons who are required to be considered the petitioners,
Instead
of considering the persons who are required to be considered, the department had considered an imposter and given him the appointment. We approached this honorable court. This honorable court said that since it was a case of impersonation, caught, dismissed from service, now the petitioners have to be considered.
There is an order from this court.
The only stand taking now in rejecting the case is that
Devabrata.
is what they
No,
now
but there
try
is
to
an
rely
order
on.
of this court.
My lord.
But there is an order of this court in this case.
Therefore,
Then-
the last order reflects that how it will be applicable is
Yes.
subject to come up with. And that affidavit has not come till date.
See, Ms.
Actually-
Bhattacharjee, I find very difficult to appreciate this submission from the government side as regards the applicability of the Devabrata in cases where government does not take action. Here, you see, it's a matter of 23. Now we are in end part of 24. Till now, government has not even bothered to file an affidavit and simply makes a submission that this case has become time barred.
Lordship.
What prevents the government from filing affidavit on time? Why?
That's true,
Why
Lordship.
such careless attitude of the government when matters of in matters relating to compassionate appointment?
Lordship.
When you want to take advantage of a decision of the apex court which says that in case of lapses the claim becomes time barred, it appears.
Lordship.
You understand what I am saying?
I understood, Lordship.
Yes. And also in this case, Mr. Majumdar is saying there is already a direction of this court.
Lordship.
So if there is a direction of the court, perhaps
Lordship.
then that ground may not be available because
Lordship.
this court has already directed for consideration. Appears in the context of this case because it appears an imposter was
Lordship
given. So I think facts are different here. So you file your affidavit. Otherwise, I will
Or
dispose it.
Lordship, can it be taken up at the end of the list, Lordship?
All right.
By this time, I will
You
just
get
get
it.
the
If we
instruction,
can, we'll
Lordship.
dispose it of otherwise
Lordship.
because looks like a genuine case here.
Because today, actually, we are not having the brief also. That's the main problem.
You are not
Lordship.
having the brief.
Yes, Lordship. That's why I'll go through the court record and I'll accordingly take instruction,
All right.
Lordship.
You find out.
Lordship.
If you want, I can fix this at 2.
Yes, Lordship. Two,
Mr.
Lordship.
Majumdar?
I have another matter fixed in
All
some
right,
other
you
bench.
have a look at it and then you
Aye,
inform.
Lordship. Lordship.
21 to 23.
Yes, Mr. Buragohai.
If I may take a lot to until the 23 first.
But what about the
They have filed an affidavit today morning.
Morning, brother.
A counter affidavit wherein they have stated some point.
anyway that counter I don't think has.
No, Lordship, only today I had.
All right. You like to file a rejoinder?
I used to file, but the point that I'm raising, my lord.
See, Mr. Buragohai, this court will always give you an audience.
Yes, my lord.
But what is the use when this affidavit is also not in front of this
Yes,
court
of course,
today?
of course.
Will it serve any
No, no,
purpose? So you save your energy for the next date. Mr. B. Chaudhary, Learned Standing Counsel, SLRC, submits that the counter affidavit has been filed in
In all the cases.
In all the cases,
Yes.
has been filed today. However, the same is not available on record. Let registry verify and place the same on record. List
Let it come after.
after 2 weeks on a date to be fixed by the registry. In the meantime, petitioner may file their rejoinder if necessary.
It comes after the vacation and between the vacation that
2 weeks will be after the vacation.
obliged.
Also, the matter relates to
Pay structure.
Health department is supposed to file affidavit, my lord.
Finance has already filed.
Yes.
Health. Mr. Bora.
My lord, we have, because my lord, there is a communication from the directorate to the government, my lord, but in response to that communication, what has happened, my lord, we have to take instruction, my lord.
You take your instruction.
Yes, my lord. We need
How much
some
time? 2 weeks?
2 weeks, my lord.
As prayed for by Mr. D. Bora, Leonard
Standing Council,
Standing Council, Health,
and Family.
which is not opposed by the other side, list this matter after 2 weeks to enable the health department to file their return in the matter.
Yes, my lord.
Wait for take date, my lord.
That will come, Mr.
Obliged.
Mr. Pathak, affidavit in opposition is filed, I think, on the last occasion.
But then I have examined the matter, my lord. Our reply as such is not required. However, the respondent number 2, this is a case where he was earlier serving in Assam Rifles. Then he
Who is
moved on to
two?
the CRPF.
Who is 2?
2 is the Assam Rifles, my lord.
Who is appearing?
My lord, the same central government council, my lord, should be represented.
Yes, Mr. Gugul?
Belendra Kumar.
According to you, an affidavit is necessary from 2.
2, my lord, because the
Mr.
plea
Gugul,
was...
you examine the matter. If required, you file an affidavit.
Yes. No, no quoting this. Let's say accommodate us to I will inform concerned council.
So I'll say that in the meantime, you file.
Lost.
It appears that an affidavit in opposition has been filed on behalf of respondent numbers 1, 3, and 4. Stop.
Simantini bolu ase no? Simantini.
However, no return has been filed on behalf of respondent number 2. Mr. K. Gogoi, Leonard CGC, who is Leonard CGC seeks 2 weeks time to obtain instruction in the matter. Prayer is allowed. List after. Yes, Ms. Gurwa.
Institute, my name.
You file anything?
Yes, I have filed it.
Do you know about Dinway Foundation?
Yes, no. Assam Rifles had not to required affidavit, Lordship, because petitioner is posted in CRPF, and all relevant documents related to his service record is with CRPF. Therefore, affidavit filed by the CRPF is covered with.
You file a rejoinder then, as prayed for by Mr. B. Pathak, Leonard Counsel for the petitioner. List this matter after 2 weeks to enable the petitioner to file rejoinder. 2601.
Lordship, in item 26, we have received instruction and affidavit prepared, Lordship. We shall be filing it by next week, Lordship. And in item 1, Lordship, I just have received instruction. Lordship, the police verification is pending, Lordship. That's why it is not done. And once the police verification is received, Lordship, appointment letter will be issued. I have sent the instruction in mail. Item 1, Lordship.
Item 1, Your Lordship, with due respect, Your Lordship, the selection was
No,
done on
item 1 or file 2.
11 March 2023, Your Lordship.
Appointment dibo kaise.
In item 1, Ms. Bhattacharya, the appointment will be given.
Will be given once the police verification is received, Lordship. It was sent, Lordship. I have sent the
I am not
instruction.
disposing it. I will record.
Lordship
the
may dispose it of.
MS, I can dispose it of.
Yes, Lordship. May.
No, I will not dispose.
Okay,
MS
Lordship.
M. Bhattacharjee submits that she has. Where is that instruction?
I have
Sir?
emailed it, Lordship.
কিবা বেলেগ বৰা এজনৰ এপিল পেণ্ডিং আছে সেইটো কাৰণে হেৰি হোৱা নাই
This is that case where your name appears at serial number
Yes,
11
Lordship.
and selection.
Yes, Lordship.
So I will do one thing.
Lordship.
I will dispose this off by directing them to appoint you within a time frame.
Yes,
because
Lordship.
it appears.
Yes, Lordship.
Heard MSG Bora, Leonard, this is item 1. G Bora, Leonard Counsel for the petitioner, stop. Also heard MS M. Bhattacharjee, Leonard Additional Senior Government Advocate for respondent numbers.
Lordship here.
For respondent numbers
2, 4, 5, and 6, Lordship.
Not
Oh, 3 also, Lordship. 2 to 6.
2 to 6. And R. Borpujari, Leonard Standing Counsel, Revenue Department for R1. By way of this petition under Article 2 to 6 of the Constitution of India, comma, the petitioner is seeking direction to the respondent authorities to give effect to the selection list published in the official website of Nagaon district on 13/3/2023, whereby the petitioner had been selected as a government Gram Pradhan at serial number 11 of the select list issued by the Deputy Commissioner Nagaon, Assam, Additional Deputy Commissioner Nagaon, Assam, Subdivisional Officer Civil Koilabor, and the Circle Officer Koilabor for the village of Sikoni Pathar under the Sotyal Mauza under the Revenue Circle of Koilabor, District of Nagaon, Assam, as per the advertisement number so and so, page 14 of Pajama, on 5/9/2022. Stop. Today, when the matter was moved, comma, MS M. Bhattacharjee, Learned Additional Senior Government Advocate for the state respondent, places a correspondence dated 26/9/2024 received from the office of the District Commissioner Nagaon, whereby it is informed that the appointment to the petitioner could not be given as the police verification report was not received from district police authority. Stop. It further appears that reminders to the police, to the district police authorities have been already issued on 23/23 and 11/3/2024. It further appears that it is the stand of the respondent that upon receipt of police verification report, comma, appointment shall be issued to the petitioner. Stop. In view of the aforesaid endorsement made by the learned additional senior government advocate, comma, this court is of the opinion that this writ petition can be disposed of at the motion stage itself by directing the respondent authorities to complete the process and by issuing appointment orders to the petitioner in accordance with law, preferably within
Lordship.
Within
within a month, Lordship.
within 1 month from today. Stop.
Subject to police verification.
No, I have said in accordance with law.
Oh, Lordship.
So that will be covered.
Yes, Lordship.
Isn't it?
Lordship may keep it as a part of record.
Disposed of, huh? And a copy of this correspondence is kept on record and marked as X.
Lordship, item 26,
One,
Lordship,
two,
will be.
One is disposed of. Yes.
Item 26, Lordship. This may be tagged with, I mentioned about another matter, Lordship.
In item 26,
Sorry,
you have filed affidavit today.
You will file, not
You will
today,
be
Lordship,
filing.
by tomorrow or by next week, we'll be filing.
As platform by MS M. Bhattacharjee, learned additional senior government advocate, list this matter after 2 weeks on a
Yeah,
date.
Lordship, this I stated about a matter, Lordship, 8 WPC 86924.
Wait, I'll put it.
Yes.
After 2 weeks on a date to be fixed by the registry along with WPC
86924.
869 of 2024 to enable the respondent to file the affidavit in opposition.
This is fixed on 23 October, Lordship, 23rd October.
Sorry, MS M. Bhattacharjee, learned senior government advocate, submits that the return shall be filed within the day from today. Stop. In view of the aforesaid submission, list this matter on
23 October, Lordship.
23/10/2024 along with WPC number
869
of
2024. Deeply obliged, Lordship.
Item 27.
Yes.
Well, the matter relating to my lord, not allowing the application of matter for his allotted post in Ames Guwahati.
For his allotted
Post.
allotted post. You're not being allowed to join.
Madam, not
Who's
allowed.
stopping you, Mr. Gogoi? Yes.
For a post of the technical assistant matter,
Yes.
the combined CR examiners initiated by the Ames Delhi. Combined matter, combined equipment matter examiners initiated by the Ames Delhi. For all
Ames.
India.
Ames Delhi.
All India. And my lord, I completed my, and my lord, I was allotted for a post of laboratory technician at Guwahati, my lord, Ames Guwahati. Now, kindly have a look, my lord.
Yes.
Page 35.
Page
35.
35.
35.
Yes.
This is the allotment.
Yes.
After that, my lord, page 36. I was not allowed, my lord, because I have lack of qualification. According to Ames, my lord.
You are Avijit Chaudhary.
Obviously.
Following seat is allotted.
Laboratory technician.
Yes. Then 30. After 35.
After 35 minutes, I file reply.
No. 35. It says you are allowed.
Allowed. 36 my lord cancel. Not allowed to join. Because I have lack of proper qualification.
If you do not have qualification, how are you eligible?
Kindly have a look on page 31. Is that what is
Page
31.
According to you, you are qualified. Mr. Khonikar?
Madam?
According to you, you are qualified. Yes.
On the page 32, that is 11 question. Page 32, madam, 88, madam, second, third column, madam.
Yes.
Page 32. There is the post of laboratory technician.
Yes.
Or a qualification, madam, BSc in medical lab technology or equivalent. Or equivalent. That equivalent, madam, has not been defined in this.
88 technical.
Madam. No, madam. 88 technical. Madam. One, madam.
Laboratory.
Laboratory technician.
Qualification.
BSc in medical lab technology or equivalent.
No, equivalent would be equivalent to BSc in medical lab technology.
No, BSc in medical lab technology.
Correct.
For equivalent.
You see, you said equivalent is not defined, but equivalent would mean it has to be equivalent to BSc in medical lab technology. You
Right.
cannot just have any degree.
No, but BSc in medical technology or equivalent. That means there must be some equivalent course.
Or
No,
equivalent,
but
Mr.
I'm
Gogoi,
I'm
or
coming to
equivalent would mean equivalent to
I'm
BSc medical lab.
I'm coming to
Lordship,
that.
Lordship.
Correct.
Lordship, Lordship. There,
I am coming to that one.
there is no ambiguity in the advertisement.
Correct.
Lordship, Lordship. There.
Page 41, Mark, kindly read.
What degree do you have?
BSc matter, zoology, plus
BSc in zoology.
And diploma in medical laboratory techniques.
BSc in zoology and diploma
Diploma in medical
lab technology.
medical.
And this is to the post of laboratory.
Laboratory. Page 41. Can you read?
So, but then I will go to that page,
I'm
Mr.
coming to-
Khonikor. But on the face of it, it looks like a degree in medical lab technology, equivalent degree is required. How can diploma be an equivalent degree? You are having a diploma in medical lab, correct? All right, yes.
Page 41.
Page 41.
Is only the Institute of Medical Science, madam.
Yes.
The report of the coordination committee for bringing uniformity in the recruitment rules of various non-faculty posts, their nomenclature, qualification, and pay scale. The sector in AIMS New Delhi.
Yes.
Next, madam, page 42.
Yes.
There's a column 2, madam.
Yes.
There's a CL number 1, madam. This is laboratory techniques. Education qualification. 1, madam. BSc Medical Lab Technology from a recognized institute. Next, madam. BSc in Physics, Chemistry, Mathematics, Biology. Plus Diploma in Medical Lab Technology from a recognized institute.
Yes. You have
Then
BSc
I have
in
the
zoology.
second, I have the madam, second qualification.
You have BSc in
BSc in
zoology and
biology.
diploma in
Ah.
medical lab.
Man, I am BSc in Biology and Medical and Diploma in Medical Lab Technology.
This is for all Indian.
All in system. Can I have a look at this is the medical recruitment for implemented recruitment rules, madam?
1 second, 1 second.
2015, madam.
1 second. This is a suggestion sent.
Research.
Huh?
Research.
Suggestion, right? Yes.
These are, madam, on the basis of these suggestions, madam, the common, madam, the common recruitment examination was held, madam.
Yes.
This was conducted by the AIMS Delhi.
Yes.
And madam, according to the 15 rules, madam, this is the 15 madam, recruitment rules, not faculty. And the paragraph, third paragraph, madam.
Yes.
In pursuance of the above mandate, so-and-so posts of each aims were sanctioned by the Government of India in the financial 2013-14 for the recruitment. The present exercise is confined to preparation of recruitment rules for non-faculty posts. Under this is important. All these new aims were established in line with AIMS New Delhi. They were asked to follow the examination recruitment rules AIMS New Delhi. Although AIMS Guwahati is a autonomous body, but this has to be followed. This is a new AIMS.
Yes.
And not even not equivalent that has been not defined any otherwise not has been defined. And another one, 2012 these are all page 43
Yes.
This is a report matter. In this report also matter, kindly look page 44 matter. This is a relevant matter.
Yes.
Our last part matter is a technical level matter. 6 line. The BSc Medical Lab Technology from recognized institution or matter second matter. That is matter BSc Physics, Chemistry, Mathematics, Biology. Diploma in Medical Technology.
Third, no? BTech biotechnology plus diploma.
Right. Diploma in medical.
Yes.
That is BSc zoology plus diploma in medical technology.
Yes. Yes, Mr.
This is equivalent.
Mr. Gogoi?
On the basis of this, my lord, the common recruitment examination was there. I was allowed to appear, my lord, and push to.
I'll come back to you if necessary.
So my lord may kindly come to the advertisement lordship. It starts from page 31 to 32.
Yes.
On the basis of that advertisement lordship, the interview was held for the assistant technician laboratory. It is in serial number 88, page,
Serial number?
page 32 lordship.
Yes, yes, yes.
Second, third, 88 technical lordship.
Yes.
Lordship got it?
Yes.
My lord may directly come to serial number 4 lordship.
4, yes.
Technical assistant / technician within the laboratory lordship. It's for Institute for AIMS. My lord may kindly mark it. AIMS Guwahati lordship.
Yes.
It is a level 6 lordship. Age is correct. There is no dispute. My lord may kindly come to the qualification part lordship.
Diploma in medical lab technology.
Medical lab technology or equivalent.
Yes.
And 5 years experience in the concerned field lordship. If he belongs to the first category lordship, then he should be the diploma in medical lab technology or equivalent to the medical lab technology along with 5 years experience lordship.
Now here he has diploma in medical lab.
Lordship. So
has-
he medical lab technology, then lordship he will come to Roman 2 lordship.
No, but he has that.
Lordship. Roman.
The question is only, my lord.
One second.
Let
Why
him
do you
finish.
all
Let
get
him finish. Let him
impatient,
let him
Mr.
finish. Lordship.
This trend is not good.
Let him finish.
I have heard you patiently.
Let
And
him
I have
finish.
said that I'll
Otherwise,
come back to you if necessary. You have a right to reply. Why do you keep disturbing when the other sides are arguing? Yes.
there is a 2 category of qualification lordship. First category is lordship. The candidate concerned, he should be BSc in medical lab technology or equivalent lordship along with 5 years experience lordship. And the second category is lordship. If he is not a lordship BSc in medical lab technology, then lordship he has to be lordship diploma in medical lab technology or equivalent lordship along with lordship 8 years experience in the concerned
So
field. lordship.
you mean to say that this diploma in medical lab technology alone is not
No,
the
lordship.
qualification?
No, lordship.
It has to be along with
With the-
8 years experience in the concerned field.
Concerned field.
You are saying that, correct?
Advertisement, the word of the advertisement is very specific, lordship. There is no either or lordship. So lordship, my lord may kindly again lordship may read it. Diploma in medical lab technology or equivalent and 8 years experience in the concerned field lordship. It is not says that or 8 years experience along with 8 years experience lordship.
But in case of the
In case of
other
lordship,
aims-
first category lordship, he should be BSc in medical lab technology or equivalent to medical lab technology along with 5 years experience lordship.
you see, in case of aims, in case of the other aims,
Lordship.
this 8 years is kept as a different serial number.
It's a post is defined lordship.
What does it mean?
Technical assistant technician. It is not for laboratory lordship.
No, I am just trying to understand.
Lordship.
Because here,
Lordship.
1, 2, and then or, right?
Lordship.
So 1 and 2 together.
Lordship, 1 and 2 together.
Then or diploma in medical lab or equivalent.
Equivalent lordship.
Number 2 is 8 years experience. So
8 years
1 and 2 will be together.
Lordship. 1 and 2 will be together lordship. And even
Because
lordship.
there is no or.
No,
after-
or 1
after
and
one.
1 and 2 will be
But
together. We
here,
have to
instead of saying 1 and 2, it has been said
lordship.
together.
Lordship. We have to read it conjointly lordship. We have to read it conjointly. And petitioners have not that particular qualification. Otherwise, also
They have the diploma, but
Diploma.
they don't have this 8 years experience.
8 years experience. Otherwise, lordship BSc part also. He is BSc in the zoology lordship. and chemistry is a subject, biology is a subject,
No,
Lordship.
but as per this qualification, he only requires diploma in medical lab technology.
Medical lab technology,
And 8 years experience in the concerned field.
concerned field, Lordship.
According to you, he has diploma in medical lab technology, but he does not have 8 years experience in the
8 years
concerned field.
experience, he had
I've
not.
understood you correctly?
Lordship, Lordship.
Now, yes,
And Lordship, he has the biology, he has the BSc in
Zoology.
BSc is there, Lordship.
in zoology.
In zoology, Lordship. But the BSc in medical lab technology is a 4 years course, Lordship. And BSc in zoology,
Where are those findings?
Lordship, we have filed affidavit, Lordship.
Where?
We have filed affidavit, Lordship. Paragraph 10 onwards, my lord, may kindly page. It starts from page 45, Lordship.
Yes.
Paragraph, Lordship, I may again read it. Lordship.
Paragraph?
Paragraph 10, page 46, Lordship.
Yes, please read.
Lordship, that with regard to the statement made in paragraph 8 of the writ petition, the petitioner has contended that despite having BSc subject zoology and chemistry and diploma in lab technician course and having worked in the King's George Medical University lab technician and AIMS Library with total experience across all organizations being 5 years 4 months as laboratory technician and qualifying AIMS CRE exam, technical assistant technician so and so, Lordship. His candidature was cancelled on so and so, Lordship. Then my lord may kindly come to.
Where does that?
It is brought out. It is brought out that as per the recruitment rules of non-faculty post for New Delhi new AIMS 2015 as well as the CRE advertisement dated so and so, the required qualification for technical assistant technician
You are reading
laboratory
from
page 47, Lordship.
paragraph?
Continuing paragraph 10 is continuing, Lordship.
There is something missing here. Oh, page 3 is not there in the court's copy.
Lordship, I have to verify it, Lordship. Then, Lordship, I am extremely sorry, Lordship.
Second copy to Rasaniki's person. Second file to.
It is missing. It is missing.
No, that is when I was thinking, where did you read
Lordship, it
the
is there.
remaining part? I couldn't find.
Lordship, it is there, Lordship.
No, I understand because the page mark.
Page mark is, Lordship, after 40.
No, internal page I have seen.
Lordship.
3 is not there.
Lordship.
From 2 it has gone to 4.
3, Lordship, gone to next page, Lordship. Page.
No, is there? 3 is there.
It is there, Lordship.
Oh, if it is there, I will.
It is there in next page, Lordship.
Achha,
Probably
then
they
it's
have, when stitching, they have, Lordship.
Oh, then it's all right.
That's fine.
It is after 4.
After 4 is this,
It
Lordship.
happens.
Lordship. And even my Lord, second file may be there. Lordship, may kindly page 48, then 58.
Yes.
48, Lordship. It is bought out, my Lordship.
Yes.
It is bought out as per Lordship.
Yes.
Lordship. It is brought out that as per the recruitment rules of non-faculty post or new AIMS 2015 as well as CRE advertisement dated so and so, the required qualification of technical assistant / technician laboratories, Lordship, that is retarded, Lordship, BSc in medical lab technology or equivalent and 5 years experience in the concerned field, diploma in medical lab technology or equivalent and 8 years experience in the concerned field, Lordship. The competent authority of the AIMS Guwahati had decided that the petitioner was not eligible as per minutes of the screening committee, which had stated on the subject that B1, the required qualification as published by the advertisement for the post of technical assistant is so and so. It is to be noted that the qualification of the petitioner Abhijit Chaudhary is BSc Zoology Chemistry, diploma in lab technician course and 5 years and 4 months experience, Lordship. That is the reason, Lordship.
All right.
And that portion was again reiterated, Lordship, in paragraph 11, 12, and 13 also, Lordship. If Lordship permit, I can read it, paragraph
No, it's
11,
all right.
Lordship. Paragraph 11,
It's all right.
we stated that the AIMS Guwahati is an autonomous body, Lordship. That part is there, Lordship.
So you are relying on 10, 11, 12, 13.
10, 11, 12, 13. Although designation is, Lordship, it is there.
As long as the page is there.
Lordship.
I thought the page was only missing.
Page is, Lordship. ups and downs.
Yes.
Lordship. And regarding equivalency, Lordship, it is an admitted fact that Lordship, he is belongs from the zoology and BSc in zoology, Lordship. It's a 3 years course, Lordship, admittedly, and BSc in technology, lab technology is a 4 years course, Lordship. It's a
Yes.
So Lordship, it is not equivalent. Otherwise, equivalency part, if Lordship permit, I can place some judgment also regarding.
No, but here he is not. There is no quarrel about the equivalent,
Lordship.
isn't it?
Lordship.
Now the controversy, because he already has the diploma.
Lordship.
If I have understood, Mr. Khonikar,
Diploma
if
he
I have
has, Lordship.
understood, you have the diploma.
I have a
Correct.
But I am
but-
seeking my lord, one, my lord, not two, my lord, not one,
Exactly.
category one, my lord, not two.
Exactly.
He is saying that I am in the category number two. Man.
No, I am not saying
I'm
the
the category
category
number
number.
one. Man. That is BSc laboratory technician is equivalent to BSc plus my lord diploma in medical technology.
So you are.
This is the equivalent.
So you mean to say that your degree in BSc Zoology is equivalent?
No, BSc zoology plus my lord diploma in medical technology is equivalent to BSc medical lab technology.
No, how do you say that?
But this is my lord. I might have already
All
referred, my
right,
lord.
all right. Just once. No, by showing those similar at Ames Delhi, those suggestions. Just 1 second. Yes, Mr. Gogo, you wanted to show some decision on equivalent.
The equivalence, Lordship. Just again, I am reiterated, Lordship. BSc in medical test laboratory is a 4 years course, Lordship, and BSc zoology is a 3 years course, Lordship.
That part is in your affidavit.
That part we have, although I am not, Lordship, that part I am not stated, Lordship. Otherwise, it is admitted fact, Lordship.
No, what do you say? Please say it
BSc
again.
in medical lab technology is a 4 years course.
BSc
in medical lab technology, Lordship.
Med Lab
Uh,
is 4 years.
4 years course, Lordship. And BSc chemistry, zoology, and botany is a 3 years course.
BSc
Chemistry,
chemistry,
zoology, and botany, or maths, any
zoology,
BSc degree is a 3 years course.
3 years course.
Lordship.
And that is why you are saying they are not.
It is not equivalent.
Only on this ground.
Lordship. It is not equivalent. And regarding equivalency part, Lordship, Honorable Apex Court time and again reiterated, Lordship. Just I hand over the judgment and Lordship.
The matter is at admission stage, but I'm taking it up for disposal.
Lordship.
I thought with that understanding we were proceeding, right, Mr. Khonikar?
Lordship.
Yes.
Here I am relying, Lordship, paragraph 30, 31, and 34, Lordship.
Paragraph
30, 31, and 34.
30.
30, Lordship. 30, 31, and 34, Lordship.
Yes.
If Lordship permit, I can read.
Yes, please.
30, Lordship. The question of equivalence is submitted by the respondent so and so, Lordship. Added the party has once again put forth its position quite equivalency. The NCT has drawn a distinction between the two degrees to the extent that while MA in education is a degree in the discipline in education, the MA degree is a practitioner's degree, and reference has also been made a committee constituted in pursuance to the impugn judgment, which is an expert committee in view of the recognition of the MA program as a 1 year duration. In order to acquire the MA degree, one who has to spend for 2 years, kindly mark it, 2 years after the first degree, because for an MA degree, a BA degree is mandatory, Lordship. It is in these circumstances a conclusion was reached that from the point of view of the duration and the circular inputs, MA qualifies itself as a master programs in the education and is even recognized by the UGC and NCT as such. In a sense, this puts to rest one of the controversies raised by the respondent number 3. Initially, MA was a 1 year program and only subsequently converted into a 2 years program in 2015. As this very issue has been examined by the expert committee of the NCT and NCT concluded in favor of the appellants, there is also a categorical statement in the
Gogoi,
Lordship.
you see, they have raised the issue of equivalence. If you want to say it is not equivalent, you must come up with the explanation in your affidavit,
Then also I can
you have to.
I can put
Otherwise,
one.
how this court is going to go
Otherwise,
into this
equivalency
issue?
part is an admitted fact
You
that
see,
it is,
this court is not an
it
expert.
is not, it is not the duty of the lordship. Honorable court, lordship.
You are
So,
right, but
lordship,
you see, when something is brought before
Lordship.
this court
lordship,
under 226,
lordship,
this court will have to see the manner
lordship.
how it is done.
Then
This
also
court
I
will
can,
definitely not go to the legality of the to the order otherwise per se, the decision.
lordship,
But the manner the decision is reached, that manner this court of course has the duty
otherwise,
and the
lordship,
power
lordship.
to go into. How can you say this court has
No,
not the
no, I am
power?
not saying that.
So that
Regarding
is- you
expert
see,
opinion,
that
lordship,
is- no, that is-
regarding,
no, that is why I am saying.
I am not saying
See,
that
that is why I am
226,
saying that in order for this court to appreciate
lordship,
that it is equivalent or not equivalent, both sides must play
Lordship.
something. Now they have brought in some documents from AIMS Delhi to show that this is equivalent. Now, if you are, according to you, it is not so, then you must,
I can,
because your affidavit doesn't talk about it.
I can,
You are only talking about under category 2, but the petitioner
no,
says
no, I am not, I am emphasizing category 1. Category 1 as well as category 2.
in your affidavit.
Even affidavit also lordship category 1
So
lordship.
where have you said
Affidavit is
about
there
the
lordship.
equivalent part?
You know, equivalence part I can explain lordship.
That is what I am
Otherwise
saying.
lordship, the equivalency lordship.
No,
Equivalency,
Mr. Gugoi, about
lordship.
the equivalent part, there has to be something on your record.
No, I can place it. Even I can place,
How Mr. Khonikar
I can
is
place
going
the
to
record of the
rebut?
expert body also lordship.
Only issue is not equivalent. This is
I can place the body,
You see, I was investing time in this matter thinking I could dispose it of. But if your pleadings are not complete in this regard, then it is difficult.
lordship. Otherwise I can place the records of the expert view also lordship. What expert says.
Mr. Gugoi,
I will
record
place by.
is subsequent. First, you have to give a right, the right to the opportunity to the other side to rebut.
Lordship, I'll place by way of affidavit. I'll place
When?
it by after 2 weeks, lordship. After 2 weeks.
Mr. K. Gugoi, Learned Additional Senior Government Advocate,
As a CGC lordship.
Learned CGC, seeks 2 weeks time to file additional
Lordship,
affidavit
lordship.
pertaining to the issue of
Equivalency,
equivalence
lordship.
to the post of, to the degree of MSc.
MSc Zoology and MSc Biotech.
No, the main one is MSc.
BSc.
Sorry, BSc Medical Laboratory. Stuff.
As-
Prayer is allowed. Lists after 2 weeks on a date to be fixed by the registry.
There is a wisdom about it.
Interim, if any, shall continue till the next date of listing. Mr. Konika, take this back.
This matter is pertaining to removal from service under Department of Proceedings. Affidavit and reply affidavit has already been filed. May I pray, Lordship, this matter may be taken up today itself for final disposal.
I think record nalage.
This is a matter of dismissal.
Lordship, during the
Matter of
time,
issue is dismissal.
yes.
And I'll admit and post it for hearing, and on that date you produce the records.
May I pray, Lordship, let it be the admission hearing, maybe after vacation, Lordship. Otherwise, if it goes in the hearing column, Lordship, it will take time.
This matter needs to be heard. It will take some time.
Yes, that's why, Lordship, I'm praying that let it be the admission hearing after vacation, Lordship, any date from the hearing date.
As prayed for, list this matter after 3 weeks on a date to be fixed by the registry to enable to make an endeavor to dispose this petition at the admission stage.
May I pray, Lordship, for a date, Lordship. 24.
Yes, next.
Lordship, in this matter, we have prepared an affidavit, Lordship, will be filed within a week, Lordship.
As prayed for by MS M. Bhattacharjee, Learned Additional Senior Government Advocate, submits that an affidavit in opposition has been prepared and the same shall be filed within a period of 1 week from today. Prayer is not opposed. List this matter after 1 week, after 2 weeks on a date.
They are going to file this
After,
in a week.
Yes, Lordship. After
puja
the
vacation is there.
yes, Lordship. After the vacation.
2 weeks on a date to be fixed by the registry. In the meantime, if petitioner if petitioner may file rejoinder if necessary.
Lordship.
Oblige, Your Lordship.
Yes, Mr.
In this
Majumdar.
case, my lord,
Where is Forest? No affidavits filed till date.
No, they've started a disciplinary proceeding in 2020.
Yes.
Exonerated all my seniors.
Yes, my lord, we have received the instructions, my lord. Yes, we have received the instructions.
What instruction have you received?
My lord, the Joint Secretary has, my lord, issued a letter, my lord, to the inquiry officer, my lord, why the report has not been submitted till date, my lord. And also explanation has been called for on 12/8/24 for delay in submitting the inquiry report, my lord.
That is the instruction.
Yes, my lord.
What is the prayer, Mr. Majumdar?
My lord, that
The charge sheet.
Charge sheet.
Are you on suspension?
No, my lord. I'm serving. My seniors have been exonerated of the same charges, and my promotion is.
How much time the disciplinary proceed? That is not, nothing is mentioned.
Nothing is mentioned, my
Then
lord. Yes, my
this is
lord.
going
Lordship
on
may
since
fix it on next
2020.
Wednesday, my lord. I'll bring that all the instructions, my lord.
When?
On next Wednesday, my lord.
Next week, I think, is going to be a motion day. Tomorrow. You need a verbal communication. Give them a call and find out what is happening. Why is the disciplinary proceeding
Yes.
not concluded?
Okay.
Tomorrow.
My lord.
List again tomorrow. I have not recorded, but you remind me.
I'm obliged.
Item number 16.
Sorry, my lord, I was not present, my lord, when the matter was called, my lord.
Yes. You are PNRD.
Yes, my lord.
Why are you
My lord, my
sending
lord. I am clarifying that, my
a
lord.
junior who has just joined the bar
My lord.
in a matters which has some importance?
That is, I am
You see,
very
they are,
sorry, my lord.
you are a government council,
My lord,
correct?
my lord.
Some standard has to be
My lord, yes,
maintained.
my lord. May
isn't
I
it?
submit, my lord?
I understand sometime for
Yes,
for just accommodating a Passover for the time being is
My-
mentioned, one can
lord.
appreciate. But in matters where returns have not been submitted, in matters where certain instructions are required,
Yes, my lord. May,
how
may,
do you
may I submit
expect
on?
someone who's just joined the bar, he has no knowledge, the court is asking,
My
he's
lord,
not
my
being able to interact with the court. Does
Yes,
it look appropriate, Mr. Counsel?
My lord, lordship is very much
I'm
correct.
sure
my lord.
there are sufficient numbers of
My
panel
lord.
advocates in the Department of PNRD,
My lord.
correct?
Yes, my lord. May I
And
submit
if they
the
are not
why, my lord?
sufficient, then make arrangement
My
to
lord.
engage.
Yes, my lord.
There are so many advocates.
My lord. The issue of this writ petition, my lord,
Yes.
is the recalculation of pension, my lord. Petitioner is already getting pension. The issue is recalculating. And now we are proposing to allow their prayers, my lord. Now, what happened, my lord, in this case?
You are proposing to allow the prayers.
Almost, my lord, because, my lord, it's covered case already. So we want to comply petitioner's case
Yes,
also.
because on the
Consider.
last occasion, one
Lordship may
judgment
kindly
was
go to the last 4 or 5 dates, my lord, orders, my lord. The government advocate taking time, my lord, for instruction for tracing out the service book of the petitioners.
Has it been traced?
No, that is why, my lord, the government advocate was supposed to take instruction whether they have traced or not.
Which is the relevant order?
Last 4 or 5 days, they are taking time, my lord.
Yes, what happened to the records?
Yes, my lord.
Mr. Datta, what are you seeking here? The recalculation you are.
What had happened, my lord, this was already my lord allowed. There is, my lord, the pension was.
I think this order dated 5/8/2023 sums up your
Exactly,
grievance,
ma'am.
correct?
Yes, yes.
The grievance of the petitioners herein is that they have been paid the regular pension as per incorrect rate of scale of pay at rupees 494 instead of 566 per month. As such, they are praying for refixation.
My lord. In fact, my lord, they wanted to make recoveries, my lord, that was disallowed, saying that you cannot do it.
And which is that judgment which you said is this Justice Justice Bhuya's judgment
Yes, Justice Bhuya's judgment.
in 2076,
Page 100. 100.
page
100.
100.
Yes. In fact, there is a line series of judgments, my lord. There are
Yes.
other judgments. Para 14, my lord.
Yes.
My lord, is that they could not show any records. Page 103. In the present case also, the respondents have not been able to place any materials on record to show that the fixation of pay of rupees 66 per month in respect of petitioner from July 1981 was erroneous and was based on incorrect principles.
as notice of the recoveries were made after retirement of the petitioners.
I think I can pass a similar order
Exactly,
because
my
there is no
lord.
positive
Yes, my
direction.
lord.
It says
Problem
that
is that, my lord,
no,
we
you
want
see,
to send a proposal, reproposal.
whatever you do, there is been this is a pension matter. It cannot be kept pending in this fashion.
My lord,
You see the direction at 16,
my lord.
paragraph 16 of 103.
Yes, my lord.
You won't be prejudiced.
Yes, yes.
Accordingly, it is hereby directed that the respondents, more particularly the Commissioner PNRD, shall examine the case of each of the petitioners and thereafter pass appropriate orders for refund of
No,
the
no,
amount deducted.
refund has been made, my lord.
Refund has been made.
After refund has been made, they are now paying the pension at the old rate, my lord. That is why, my lord.
That is why, my lord.
Page 122, my lord.
No, that cannot be done.
That
Yes,
cannot
yes.
be, my lord.
Now,
Perhaps lordship, after when the lordship this pension thing has been sanctioned by the department, it goes to the AG. AG is not a party here, and pension department is saying the records are not with you. So I think so.
AG is part of
General.
the same state. You can always coordinate and find out what has happened.
Let him file it.
So why should he file? Why are you all not doing what is to be done? Every time you shift the buck to the other side department.
my lord,
Page
there are 8
122, my lord,
petitioners.
That order, my lord, there also the AG was not a party, my lord. They didn't comply with, my lord. My lord, this kind
But
of.
just one thing, Mr. Doctor. In this case, refund was not done.
Not.
Therefore, there was a further direction.
Yes.
In your case, what is the direction
No.
that you are seeking?
No, refund was done in our case. We were there, my lord, earlier. Now, my lord, subsequently.
Oh, this is in case of you.
Yes.
This order which
Yes,
is
yes, my
passed
lord.
is in
Yes,
respect
some
of you.
Yes, my lord.
Now, after this, what has
After this,
happened?
now, since they're paying at the old rate, my lord, we again filed the writ petitions. And my lord, another similarly situated person, page 122, he also filed the same writ petition.
You file a representation, writ petition.
Writ petition.
Because after this also, after examining,
Yes.
whether there was an examination or it was not done,
No, it was done, my lord. That's why, my lord.
that examination was done.
Done, my lord.
And
That's
therefore they refunded.
refunded, my lord.
But after refund also they are paying you at the old rate.
rate. Now, my
How
lord,
can that be done?
that's why, my lord, some similarly situated persons will appear before sound court, page 122 order, my lord. That was the second round of writ petition, not the first round of, my lord. Now, in the second round, this honorable court has again held, my lord, that you have to pay them according to the 566, not 494.
Page?
Page 123, it starts, my lord, page 127. This is the operative part.
So division bench also they had approved and that was, dismissed.
That was dismissed. Thereafter, we had to come for the second round of litigation, ma'am. Their entire.
So you have to be paid 566.
Yes, madam. Page 127, their entitlement to pension is based on the scale of your 566 per month. Now, madam, they are coming with this plea and that plea, the service record is not available, this is not available, that is not available. Only to be delay the process, madam.
I am allowing it. This order is very clear.
So we clear order, madam.
We are not opposing, my lord. We are not opposing.
I'll pass the order at 2 o'clock.
To Belegata Madam notice.
Mr. Saikya, Mr. Chaudhary, I'm in the middle of a judgment. I'll just give that and I'll take up your matter.
Yes.
Heard Mr. M. Datta, Leonard Counsel for the petitioner. Stop. Also heard Mr.
S. Datta.
Datta, Leonard.
Standing Council.
Standing Council.
PNRD.
PNRD. And you are there, Mr. Dhar? You are there? And Mr. R. Dhar.
4 minutes. Respondent of 4 minutes.
Leonard Counsel for respondent number 4. By way of this petition under Article 226 of the Constitution of India, the petitioner is seeking direction to refix the pension of the petitioner by taking their correct pay scale as rupees 566 within bracket basic pay PM instead of incorrect pay scale of rupees 494 per month, on the basis of which the pension of the petitioners were earlier calculated. That earlier case is page 17. Annexure 17, page 122.
Earlier case, my lord. No, there are several judgments here, my lord.
No, where in case of you,
The last, my lord, we had earlier approached this honorable court, my lord.
yes.
There are 3 writ petitions, my lord. Starting from my lord, page 100, my lord, annexure 12, my lord. 12, 13, 14, my lord.
12, 13, and 14.
14, annexures 12, 13, and 14, my lord. Starts from page 100.
The case of the petitioners are that they had served as secretaries in different Gao Panchayats under various Jila Parishads, and after rendering service for fairly long periods, they were superannuated from service. They had superannuated from service. Upon being superannuated, and at the time of payment of the retirement dues, the respondent authorities came to a conclusion that the petitioners had excess drawal of salary which was thereafter recovered from the retirement dues. Aggrieved by such actions of the respondent authorities, the writ petitioner approached this court by way of WPC 2076 of 2013, wherein this court, by order dated 14/8/2013, upon holding that the respondents have not been able to place any materials on record to show the fixation of pay at rupees 566.00 per month in respect of the petitioners with effect from July 1981, and as such the same is erroneous and fixed on the basis of incorrect principles, and accordingly allowed the writ petition by directing that the respondents the deduction made by the respondents from the retirement dues of the petitioners cannot be sustained. Thereafter, this court directed the respondents, more particularly the Commissioner Panchayat and Rural Development Department, Government of Assam, to examine the case of each of the petitioners and thereafter pass appropriate orders for refund of the amounts deducted from the retirement dues of the petitioner within a period of 3 months from the date of receipt of the certified copy of this order. Stop. It is the specific case of the petitioner that, pursuant to the said order, the case of the petitioner was examined and thereafter the amount deducted from the retirement dues of the petitioners were refunded to the petitioner. Stop. However, despite of such examination and deduction, the petitioner is still being paid as per the is still the petitioner's pension is still being paid as per the incorrect rate of scale of pay rupees 494 per month. Correct? Instead of corrected pay scale of rupees 566 per month. And accordingly, this writ petition has been filed. Stop. Mr. M. Datta, learned counsel for the petitioner, draws the attention of this court to an order passed in a similar situated person, in respect of a similarly situated person, in WPC 7793 of 2019, in the case of Dinesh Chandra Das and others versus State of Assam and others, wherein this court directed that the entitlement to the pension of the petitioner is to be based upon the scale of pay of rupees 566 per month, and accordingly set aside the pension payment order being given to the petitioners on the basis of the incorrect pay scale of rupees 494. Stop. Mr. N.
S.
Datta, Learned Standing Counsel, PNRD, submits that he has received no instructions to object. You said you have.
This is
Rupak. That he has received instructions to the effect that the Director of Pension Assam, by letter dated 29/2023, has submitted 2 numbers of petitioners' service books, namely Tulsi Bora, he's the petitioner?
Yes.
Petitioner number? Namely, and Pankaj Lod.
Tulsi Bora,
Petitioner
number 6 and 7.
Petitioner number 6 and 7 under Sunitpur Jilla Parishad. And so and so for recalculation of pension, and rest of other 6 numbers of petitioners' service book is not being traced out yet in the office of Director of Pension Assam, as per letter dated 18/7/2024 received from the Director of Pension Assam. Stop. Be done as it may, it appears that the case of the petitioners have been re-examined pursuant to the order of this court dated 6/9/2014.
No, my lord. 14/8/2013.
14/8,
2013.
2013, whereafter the excess, wherever the recoveries made was refunded. Stop. That being so, it appears that despite such re-examination, the petitioner is being paid pension at an incorrect rate. Hence, this petition can be disposed of with a direction to the respondents to pay the pension to the petitioner at the correct rate. A time frame has to be given because this is arrear, no?
My lord.
To pay the arrear pension
As well as the current
as well
due
as the current pension in the correct rate.
Right.
Stop. It is needless to be clarified that the that such exercise, in order to release the arrear pension in the correct rate, be concluded within a period of
3 months, my lord.
2 months pension.
My lord, we have to reconstruct if they
3 months, all right. 3 months from today. This over the first and observation direction disposed of.
Oblige, your lordship.
Highly obliged.
16, no? Disposed of. 3, Arukuman?
My lord, will kindly take this motion first, my lord.
340 and
3 and 45. Okay.
Lordship, my submission motion may be segregated from the other case
Let me first take item 3.
because there is a direction for today's disposal.
For first item,
Yeah, and it can be segregated also.
what is
Both the
this?
issues are different.
This matter is fixed today for final disposal.
Yes. Yeah.
Unfortunately, though it was supposed to be as a first item in the 10:30, now it is 2 o'clock. Anyway, what is the matter?
Yes. My lord, the matter is otherwise simple, but factually it's a longish matter. Now, my lord, the matter relates to the post of professor and director of LGBI.
Is there a stay operating?
Yes, there is a stay.
There is a stay operating.
My lord, both these cases.
What is the stay?
My grievance is against Government of India. My grievance is not against State of Assam. Both the impugn orders are passed by the Government of India. I am only saying under the terms, special facts of the case.
Mr. Gogoi, you are for the central government.
And I am entitled to the benefit of this Assam government pension rule. To that extent, my lord, Assam government figure in this litigation. Otherwise, Assam government has no role in this case.
What is the issue?
Yes. Now, my lord will kindly.
But urgency has been shown on behalf of government of Assam. Mr.
Yes.
Sarkar,
I will respond, Lordship. If Assam government is not an important party, then why they have made
no,
a
but
party?
what is the issue? I have not.
Issue is very
understood
simple.
anything.
One in one lineup. My friend will continue. On 22nd of August, he superannuated. He is continuing on the basis of the interim order. So that is his case. Issue whether he can continue beyond 22nd
No,
of
my
August.
lord, why I
That
am
is the case.
saying Assam government is a proper party. I am not saying it's a not proper party. I am claiming relief against Government of India. I am working under organization under the Government of India. Earlier I was under Assam government. Now all that time, my lord, the case is I was appointed to a non-tenure post. There is a resolution of the. Let me go very sequentially, my lord. If your lordship would kindly come to.
This will take some time.
It will take some time.
Can this not wait after the vacation?
Yes.
No, Lordship. The interim order was given to a particular time. Thereafter, on the adjournment,
Where is
it was
the
continued.
interim order?
The first interim order, it is only in the The first interim order.
My lord, there are so many cases, my lord, interim orders are continuing.
Yes, Lordship.
People are
Only
enjoying
thing is
stay
that-
orders for 6, 7 years.
1 second, Mr. Chaudhary. 3724.
Lordship.
Yes,
it is
yes. it will be-
37 2024. He superintended on 22nd of July, not August, Lordship. 1 month prior. Already he is continuing beyond the age of superannuation. So every day is very crucial.
superannuation is under challenge, and,
Yes,
and
Lordship.
by way of a
Yes.
interim order, the petitioner is continuing at the post
Yes.
after the retirement age.
After the retirement age. That
from
is why
June,
every day is
from
very
July
crucial.
24.
Yes, Lordship. He should have gone out of service on 22nd of July.
All right. Yes, Mr. Chaudhary.
Yes. My lord, I address your lordships on the motion or on the other case? The other
I
where there
have
is a stay
item
order.
number 3 right now.
My lord.
I have item number 3 in front of me.
Okay. My lord will kindly come to page 30. In fact, my lord, this agreement between Government of Assam and Northeastern Council, it starts at page 25. My lord will kindly come to page 26.
Yes. This agreement is between Government of Assam and Northeastern Council. Yes.
I'm reading from the first subparagraph.
Yes.
Whereas, as a result of public interest litigation in Sheela Barse versus Union of India and others, and following Gopal Subramaniam Commissioner's report, the Honorable Supreme Court of India, through order dated 3/10/94, has accepted the recommendation of the Commissioner. Whereas, in pursuance of the Supreme Court order stated above, and the Commissioner's recommendation, Government of India has accorded sanction to the Northeastern Council, Shillong, to take over LGBI Institute of Mental Health, Tezpur, and develop it as a regional institute by its sanction order dated 18/12/97. And whereas in pursuance of the above order, a society will be formed with aims and objectives of investigation, diagnosis, and treatment of the mentally ill
This is
patient.
that mental health at Tezpur, that one.
Yes,
Is
that's
not-
Shillong, that Tezpur one. Earlier we used to call it mental hospital.
Correct.
Now it is Lokopriya Gopinath Bordloi Institute of Mental Health and Science. It's a Government of India institute now, where, my lord, in psychiatry, my lord, the courses are also being conducted, apart from being an hospital.
Okay.
So, my lord, that was the decision. Then, relevant for the purpose of the case is, please come to page 29, my lord.
Yes.
7. Whereas LGB Institute of Mental Hospital be made a regional institute for Northeastern region and NEC, the institute will be renamed as LGB Regional Institute of Mental Health. Then, my lord, please come to page 36. Because earlier we are all Government of Assam employees. Page 36.
Yes.
All incumbent
36.
officers, 6, page 30. my lord.
Yes.
All incumbent officers and other employees of the institute shall, as from the date of commencement of this agreement, be governed by and be subject to rules set out in the constitution and bylaws of the institute hereto, as mentioned from time to time. All the existing employees will be given choice of absorption in the new setup or reversion to the Government of Assam. So option would be given. If somebody would like to go back, they can go back to Government of Assam. If somebody feels that no, he should be absorbed in the new institute, it can be done. Now, this last line is very important, my lord. The terms and conditions governing all employees serving and employed by institute shall not be altered to their disadvantage. So, the agreement took care of the interest of the employees who were on the roll of the institute on the date of taking over. If one opts, he may go back, and if one opts, he may remain. But in any case, the conditions of service will not be altered to their disadvantage. Well, this is an aspect which will have vital bearing So I have brought it to your Lordship's notice.
Yes.
Now please come to page 35. In pursuance of Government of India, Department of Development of NER, dated 13/5/2002, Dr. S.K. Deuri is hereby offered the post of Director, Lokapriya Gopinath Bodloy Regional Institute of Mental Health, Tezpur, on regular basis in the pay scale of so and so. So, my lord, earlier I was joint director when I was in the Assam. Now I has been made a director.
No, but were you an existing employee under that hospital?
Yes, I was a joint director
Earlier.
of Government of Assam in the Health Aid Department, and by virtue of that, my lord, I was a head of that hospital, not that mental health institute, other hospital which was under the Government of Assam. Now, in 2002, my lord, I have been appointed as a director. Now, facts are really longish, my lord. In any case, now my lord will kindly come to page 38.
It's all right. You take your time because
Yes.
if this
Because I have
case
to
has
put
to be
the-
taken up for disposal, I have to be apprised of all the facts.
Yes, my lord. And I have to put the facts in perspective also.
Yes.
Page 38. I am directed to say that Governor of Assam is pleased to grant quasi lien to the following 184 number of officers and staff of LGB Regional Institute of Mental Health, Tezpur, for a period of 2 years with effect from 17 to 99, or till submission of option by the employees on finalization of the terms and conditions of service as per para 6 of the agreement signed between Government of Assam and NEC. So, my lord, gradually how things are fructifying. Then please come to page 41. This is very important. This is 3rd of August 2016. This is a communication by the petitioner as a director to the Government of India, my lord. I would like to bring the following facts to your kind notice and consideration. This matter has taken a very long time, affecting my service career. The details are as follows. I was recruited as the head of the erstwhile Mental Health Institute on the recommendation of the APSC in 93 at level 4 of the State Health Service. In 97, I was promoted to scale 5 as a joint director Health Services and also as director of LGH by interim board of administration constituted by the Apex Court. The institute was taken over by the Government of India, respecting the Honorable Supreme Court order in 99, along with the employees. My service was accordingly brought under Government of India in the year 99. That in the year 2002, the Government of India created the post of director in the scale of so-and-so as per the order of the Guwahati High Court. Honorable Guwahati High Court during that time was monitoring the implementation of the Apex Court order in regard to the LGBRIHM and has ordered absorption of the existing employees into the Government of India fold. I was absorbed into the post in 2002, which I've referred. In the year 2009, the post of director has upgraded to level of so-and-so. After absorption in the Government of India, my cadre is not finalized till now. Because of this, I am facing certain drawbacks in my service career. I would therefore request you to kindly look into the matter and finalize and fix my cadre in the Central Health Service. Therefore, there are precedents of encadering officers into CHS from other services and also from standalone single post requirement that they have given in Institute of Ranchi. I would therefore request you to finalize my cadre under CHS as I have already completed more than 17 years of service under the Government of India. Then, my lord, please come to page 42, my lord. This is a letter by the Government of Government of India on 29th of November 2016. I am directed to refer to the above mentioned subject and to state that expenditure white dated Department of Expenditure white ID note dated as stated as so. As per clause 6 of the agreement between Government of Assam and NEC, Government of India, the terms and conditions of employees, that is employees of the state government as on the date of agreement, that is
This is
11
which
to
you had
99,
referred.
shall not be altered to their disadvantage.
This is that clause of the agreement.
Yes. As these employees are stated to be governed by Assam Services Pension Rule 1969, it would be appropriate if pension of these employees as per these conditions are continued to be paid rather than employing CCS pension rule. So my lord, since we are all throughout we are governed by the Assam government rules, therefore why not our pension cases should also be governed by the Assam rules of 69. In view of approval of Department of Expenditure to grant pension as per state government rules, you were requested to submit retirement proposal as per approval of Department Expenditure in the as indicated above. This issues with the approval of the Secretary. So in principle, Government of India agreed that their cases can be considered under the Assam rules. Then Milord will kindly come to next page. This is a communication by the government to the director. I am directed to refer to your letter dated 13/12/16 on the subject mentioned above and to convey approval for creation of pension cell at so and so for disbursing the pension benefit and other post-retirement benefits to inherent employees of LGBR Tezpur as per Assam Service Pension. So it was eventually decided, my lord, the pension rule would be Assam pension rules. Now, my lord, at page number 41, I referred to my letter dated 3/8/16, whereby I prayed before the central government that I should be encadred in CHS. This was rejected at page 44. I am directed to refer to the subject mentioned above and to state that the matter has been examined by CHS division of this ministry. CHS division has informed that proposal for encadrement of Dr. Deuri into CHS cadre is not agreed in view of the following. CHS rule does not provide for absorption as method of recruitment at any level. Encadrement of created post only is permissible under rules and not incumbents holding created posts. So, my lord, end of the day, they said that you can't be encadred in central health services. Therefore, in a peculiar situation, I continue. And neither of the state government nor of the central government. Now, my lord will kindly come to the next page. Now, I
You had
wanted
accepted the option that was given to you to be
Yes.
retained.
I stayed back.
You exercised that.
I didn't opt to go back to the government of Assam.
Where is that?
My lord, I have, it is there. There is no dispute on that, my lord.
Okay.
Now, my lord will kindly come to page 45.
Yes, I have 45.
This is the document which, my lord, propelled my first litigation. In pursuance of cabinet decision dated 19/8/22, the governor of Assam is pleased to raise the age of retirement of faculty members of all medical colleges of Assam under Medical Education and Research Department from 65 years to 70 years with effect from the date of cabinet decision, that is 19/8/22.
So here is the issue. You
Yes.
are below
I
70.
said
but
I am
above
entitled to
65.
this benefit.
So you are below 70, above 65.
Yes.
And so you want to say this
Yeah, of
benefit.
course, my lord,
this
because
is
I
why.
can't hang in balance.
And
Yes.
now
It will
encadrement
further
is
be
already
clear.
rejected.
Yes. Now, my lord will kindly come to page number 46.
Yes.
Now, this is a communication. Your
One
lordship
second.
will kindly
Mr.
come to
Chaudhary, just one second.
yes, page 46.
One second. All right. Yes, yes, you have your water.
I'm sorry, thank
No,
you.
I have it.
Yes, yes, yes.
Yes.
Now please come to page 46. This is a communication between LGBI, that institute, and the Government of India in the Ministry of Health regarding superannuation of the director, that is the petitioner. Now please come to serial number 4. Government of India entered into an agreement with Government of Assam.
Mr.
in
Chaudhary, just as you are placing the things, things are also running in my head. So the terms and conditions which said cannot be altered.
Yeah, to my disadvantage.
To your disadvantage. This is what you are
Yes,
now
it will
trying
come
to
at
do.
several stages, Miller. I'll point out, and this is one stage.
All right.
Now kindly similar. This is a communication between the organization and the Government of India. Now please come to Miller, paragraph 17 at page 48.
Yes.
This was something to do with the superannuation of the petitioner. The response from the ministry to the suggestion could not be traced in the institute's record. However, in its reply to an RTI dated 13th of May 2021, ministry has stated that the current director, that is the petitioner, was absorbed in a non-tenure post, and as per instructions of the Honorable Guwahati High Court, he will hold the same till his superannuation like other inherited employees of the institute, as his service could not be utilized in any other cadre. Because, my lord, I was never appointed to any tenure post. I was appointed to a non-tenure post. Eventually, Government of India also agrees. As I unfold my argument, my lord, this will appear. Then, my lord, will kindly come to page number 54. This was the order which I challenged in this proceeding.
This document is the response pursuant to a RTI.
Yes, Miller. Not whole thing, but in that there is a reference to an RTI reply.
Oh.
Well, as I unfold, things should be absolutely clear, Miller.
Yes, yes.
I'm just placing the facts.
Yes.
Please come to page 54, which was impugned in this proceeding.
Yes.
I am directed to refer to the subject cited above and to say that Assam state-run so-and-so was taken over by central government with lock, stock and barrel on the orders of the Supreme Court in 1999. Ministry of Donor White order dated conveyed approval for creation of 196 posts, including one post of director. The order was issued with the approval of the Ministry of Finance. Dr. S.K. Deuri was offered the post of director so-and-so on regular basis. White order dated 24/6/2002, which he accepted. White later dated so-and-so. Since then, Deuri is continuing at the post of director. In this connection, it is submitted that as per Constitution of the Institute, Sri S.K. Deuri is attaining the age of 65 years in July 2024. Hence, he is superannuated on 31st of July 24. It is requested to release his superannuation pension, GPF, and all other retirement benefit as applicable under the Assam Services Pension Rule. These issues with the approval of the competent authority. I challenge this communication principally on the ground that as I am also a faculty member, as in the Government of Assam in the meanwhile has raised the age of retirement of faculty members from 65 to 70 years, I also should be extended this similar benefit. To that, my lord, kindly come to the affidavit of the state.
Yes.
My lord, the state's affidavit starts at page number 63.
Yes.
Please come to page 67.
Yes.
Para 11 on top. That in view of the above stated facts in the preceding paragraphs and on the basis of record, it may be stated that S.K. Deori was initially employed under Health and Family Welfare Department, but upon taking over of the institute by Ministry of Health and Welfare, he has been absorbed into the institute. Pensionary benefit will be given by central government, but as per Assam Pension Rule 69. This aspect was communicated to the director by Government of India by its later so and so. Now this is important. Extension of service under Government of Assam are applicable to only faculty members. Also, will kindly mark this of medical colleges within the Government of Assam from 65 to 70 years, but not to the said institute having been a society registered under so and so. Whereas Health and Family Welfare Department's notification dated 37/16 on retirement indicates that age of retirement of all allopathic doctors, all cadres, as 65.
But at that relevant time, when
Yes.
this was taken over by the central government, that time the age was 65.
Milord,
That time the age of retirement for the faculty members of medical colleges in Assam was 65.
no, Milord, not
At
even
that time-
65. I think at that point it was 60 years.
60.
Subsequently, it was made 65, then to 70 years. Now, my lord, the true stand is taken by the Government of Assam. Number one, that this benefit of enhancement of age from 65 to 70 is available only to faculty members.
Of
They
Assam-
would like to say, I am not a faculty.
Of medical colleges
Yes,
in Assam.
yes. And please see, my lord, and in other cases, they retire at the age of 65 years. Therefore, there is nothing wrong in that order, which is under challenge. So this is the stand. Now, my lord will kindly come to our reply. It starts at page 76.
Just 1 second.
76.
Just 1 second. I'm still in 67. What does Roman 2 indicate? The
At page, my lord.
page 67, that para 11
One
which you
second.
were reading.
One second. Roman 2, my lord. Pensionary benefits will be given by central government, but as per and under Assam pension rule. Fund will be provided by Government of India, but
it would be
computation
under
and
the-
all
that
will
would
be
be under
made
the
as
Assam
per the
pension
69 rules. Yes.
All right.
Yes. So far, so good, my lord. There is no problem. Now, please take my affidavit in reply.
Yes.
Milord will kindly come to page number 114.
114.
Yes, it's
Yeah.
part of that affidavit, Milord.
No,
Reply,
affidavit
reply.
in reply starts from 191.
No, Milord.
There's another one.
Reply. The particular reply to which I would like to draw your lordship's
There are
kind
two
attention.
replies filed.
It starts at page number 176.
Huh?
1 second, Milord. Yes, 76.
Yes, there is one at 76.
Page
also.
76.
In this, you want to rely on?
This is an reply to the state government's affidavit.
To state.
Yes.
Yes.
Now, my lord, I'll have your lordship's kind attention to the minutes of the proceeding of the Board of Administrator of 22/2/97. It starts at page 112. At that point of time, Guwahati High Court was monitoring this, my lord, taking over aspect
Yes.
in terms of the Supreme Court's order. Para 5 at page 114. Page 114.
Yes.
It is also considered meet and proper under the circumstances of the aforesaid scheme that the post of present incumbent Sri S.K. Deori, namely Superintendent LGB Institute, Tezpur, be upgraded to the rank of Joint Director, but he shall be designated as a Director of the Institute The proposals under resolution 4 shall include this proposal also. So this was a decision taken by the board of directors. Sorry, they call it, my lord, a board of administrators in terms of the order of the Supreme Court. Then my lord will kindly come to page 117. This is Board of Administrators minutes dated 3697 at page 116. I'll have your lordship's kind attention to page 117.
Yes.
On the question of starting the DPN course, Dr. Dewry informs, on the basis of what has been learned from NIMHANS, that it would be possible to start DPN course with one assistant professor in each of the following subjects, namely psychiatry, clinical psychology, psychiatric social work, and psychiatric nursing. It is accordingly resolved that advertisement be issued for 5 posts of assistant professor, one in each of the above subject in the pay scale of so and so. So, my lord, the institute was evolving. Various steps were taken. Now, please come to the next page, page 118. At that point of time, I was the superintendent. After Roman 5, my lord, the superintendent, Dr. S.K. Dewry, will issue the advertisement in one local as English daily and one national English daily having circulation in South India also. Then my lord will kindly come to page 120. This is another Board of Administrators meeting held on 27/1/98. The minutes of the, has a lordship got it?
Yes, yes.
The minutes of the 12th meeting held on 2012-97B and are hereby confirmed, subject to the modification in item number 4, that member secretary will be in charge of the DPN unit with the status of associate professor of psychiatry in the institute. So, my lord, now my status has not only become, my lord, associate professor. The post being created hereby for the purpose, and he will be paid the difference between the present emolument and those of associate professor and medical colleges in Assam. With, now this is very important, and those of associate professor of medical colleges in Assam with pay protection. So, my lord, I become a associate professor. Then my lord will kindly come to 122. It's not very necessary, my lord. In fact, my lord, 122 would be necessary. Please come to 122, my lord. In fact, Honorable Justice A.K. Patnaik was monitoring this case, my lord. I appeared in this case, I find from this record. It was on 8/1/98. It has come to the knowledge of the court that there is a proposal to take over the LGB Medical Institute test pool by NEC. It has also come to the knowledge of the court that Union of India has sanctioned some amount for the development of the institute. In view of the aforesaid development, I am of the opinion that Northeastern Council as well as Union of India should be heard by this court when the matter is taken up from time to time in future. Accordingly, I direct that notice will be issued to the Northeastern Council at Shillong to enter appearance in this regard to their council. So far Union of India is concerned, a copy of these orders shall be furnished to so-and-so Senior Central Government Standing Council so that he may make himself available before the court as and when the matter is listed. So this is how from time to time. Then my lord will kindly come to page number 132. Before that, lordship will kindly come to page 130 for a moment, my lord.
130?
130, yes.
Yes.
Now, this is the minutes of the Executive Council of NEC, my lord. It starts at page 129, at 130 towards the bottom. Therefore, the 5th line from the bottom, my lord.
Yes, I've got it.
Therefore, the Executive Council had agreed to provide facilities for employees at par with Central Government of India and Central Government pay scale is adopted for the employees of institute at all levels. Now, this is very important, my lord. Page 132. This is the report of the empowered committee constituted to oversee the process of absorption. Now, my lord will kindly come to page 138.
Page 138.
E. On more or less on top, my lord, E. All recommendations to the medical faculty post. Has your lordship got it?
Yes. This document was folded. That's why I was not being able to find it. Yes.
All recommendations to the medical faculty post shall be as per MCI guidelines. The existing guidelines followed by Central Government of India is followed in case of null medical faculty post. In case where exemptions are made, clear reason for doing so is recorded against each individual post. Therefore, whatever recommendations are there of the medical council, that will be followed. Now, my lord will kindly see at page 139. Now, post conversion. On top, Dr. Solendra Kumar Deuri, MBBS, DPM, MD, Psychiatry. Present position, Joint Director, Assam. Additional responsibilities, Director, Associate Professor and Head of the Department for all academic and department, Medical Superintendent. Now, proposed allocation, Director and Professor of Psychiatry. So, from this date, my lord, I become Director and Professor.
Where is the date?
Yes. My lord, this is the recommendation. 1 second. Page 132.
Just give me the date.
1 second. Lord, the date is. It was sometimes in my lord 2000, 2001.
2000?
Yes.
2000, 2001.
Yes, 2000 or 2001. So, two important thing emerges, my lord, that any appointment has to be as per recommendation of the MCI, and secondly, the status of the petitioner, which was of associate professor and director, has become director and professor of psychiatry. And kindly see the last column, my lord. Completed 15 years of administrative experience after post-graduation in psychiatry, 5 years as a deputy superintendent, and 10 years as superintendent, out of which more than 2 years as director of the institute and associate professor in charge of the academic activities. So to say that I am not a faculty is travesty of justice. Now, my lord, we'll kindly come to page number 144. This is 3rd of July 2006. I have to bring in
Page?
page 144.
Yes.
As per recommendation of the Departmental Promotion Committee meeting held on so and so, it is to inform you that Dr. S.K. Deuri, Director so has been conferred the status of professor in the institute with effect from February 26, 2006. So I became a professor and director. Now, my lord will kindly come to page number 155.
Yes.
Now, this is part of the constitution of the institute, my lord. Please see appointment of director.
Yes, 20.
Yes. Page 155, clause 20. The director of the institute shall be appointed by chairman of the council by invitation on recommendation of charge committee duly so and so. Terms and conditions so and so, so and so. He shall, however, be eligible for reappointment. Now, supposing, my lord, tomorrow a new director is to be appointed, this is the procedure. But when I became, it was by virtue of the court's order, my lord. Now, kindly come to page 150. This is part of the executive council decision, my lord, of the institute. That is held on 24/2/2011 at 157. I'll have your lordship's kind attention to page 158. I've been also saying, my lord, that I was appointed to a non-tenure post. Now that position is reaffirmed by the authority. The matter of proposed amendment in the bylaw under section 22 and 23 concerning the tenure of director of the institute was taken up for discussion. Just now I have placed it, my lord. The members were unanimous to the fact that the matter of revising the provisions of the bylaw have arisen due to an extraordinary situation and it needs to be addressed without delay. When institute was under administrative control of the government of Assam, the director of institute was appointed as a non-tenure regular post. And if the post is now made a tenure post, after it was taken over by government of India, then incumbent will be without a job after completion of his tenure. The incumbent director was absorbed into government of India fold as a director of the institute after takeover. Members noted that the director is a qualified psychiatrist and has more than 10 years of service left. The Honorable Chairman proposed that incumbent director may be regularized in his services till the date of his superannuation, as it would not be proper to change the rule to his disadvantage due to takeover by government of India.
Yes.
So what remains, my lord? That they say, now at this stage, if we alter, then it will be to his detriment. Therefore, I should continue. So, my lord, this is a reply to the stand of the state. When they say,
as regards this, there is no controversy.
No.
They had allowed you to be in
yes.
service till
In fact, my
superannuation.
lord,
It is
yes, now
only
all of
the
a sudden,
age.
yes, now all of a sudden they
You
have
want
come.
to say 70,
Yes.
and they are saying 65.
Yes.
Correct.
Now, my lord, now Assam government wanted to say, though Assam government was not required to contest this proceeding according to me, subject to what my learned friend may say, subject to what your lordships may hold otherwise.
You
Here
have
is
made
a
them a
case,
party.
my lord.
You have made them a party.
No, I have made them a party because
They have not come on their own.
I have made them a party because, my lord, I want to take help of the rules. Assam Service Pension Rule 1969, only for that limited
All right.
purpose. And also to show that once I was their employee, how my services were taken over. Now, my lord, by way of this reply, I have dealt with the stand of the state government that I am entitled to the benefit of the Assam government circular at page number 45, whereby, my lord, the faculty members' age was enhanced from 65 to 70. Yes.
That document is at which
Page 45 of the writ petition.
Yes.
Now, my lord, they in page 67 of the reply which I have read, there they takes a stand. This benefit is available to a faculty.
Assam
Now I have
Medical
shown I am a
College.
faculty. So this benefit should be given to me. Now I'll trouble your lordship once again with the writ petition. Please come to page 61, my lord.
Page
61. of the writ petition.
61.
Yes.
Yes.
Now, this is a notification issued by, my lord, National Medical Commission. Now, there is no MCI, my lord. This is the body, regulatory body.
It's called National Medical Commission.
Commission. Please come to 3.2.
Yes, maximum age.
Maximum age limit up to which a person can be appointed or
70.
granted extension or re-employed in service against the post of teachers or medical superintendent or dean or principal or director as the case may be, which are required to be filled up as per the norms of the National Medical Commission in any medical college institution for imparting graduate and postgraduate education shall be 70 years. So, my lord, be it under that state government notification at page 45 or be it under, my lord, medical commission thing, I am entitled to serve up to 70 years. And the post of director and professor of psychiatry in the respondent institute is inseparable. Because of the peculiarity of the facts as things have evolved. So it cannot be separated. Therefore, my lord, if I continue up to 17 years with both, or I don't continue at all. Now, my lord, Government of India has filed an affidavit. Please take that. It's a small affidavit. It starts at page 163 to 169. I'll refer to two paragraphs, paragraph 3 and 4 at page 164 and 165.
Yes.
That after going through the contention and averments made in the respective paragraphs in the writ petition, the answering deponent craves leave of this honorable court to place the brief facts of the case for proper adjudication of the issues involved in this case, instead of giving a parawise reply. Then, my lord, the entire history is, narrated, my lord. Now, please come to page 166. Now, kindly see they are relying upon clause 22(5). Now, already I have shown, my lord, clause 20, how it is not applicable is already dealt with by the Executive Council of the institute itself. Clause 25, tenure of service. Superannuation of age of faculty staff is 65 years and non-teaching specialist doctor is so years, and for other staff. My lord, in an appropriate case, after coming into force of the institute in its present form, if somebody has joined the job, yes, this may be applicable, but not to me, because you have not applied 20 to me. There where you said at page 158, my lord, which I have read, that I am in a non-tenure post, therefore I should allow to continue until I superannuate. Yes. That the petitioner had accepted the offer of respondent and therefore will be covered under the constitution and bylaws of the institute. Government of Assam notification raising retirement age of faculty will not be applicable on the petitioner, as neither the petitioner is an employee of Government of Assam and neither has he lien on the services in the Government of Assam after accepting the offer of respondent. So they say that I am not an employee of Government of Assam, therefore I cannot. Then give me that benefit of page 61 of the writ petition. How can I be denied both, my lord?
Let's go to 61 once again.
61 of the writ petition, my lord.
Where it
That,
says 70.
yes, it says
70.
faculty, yes, faculty members.
Let's go.
My lord, I have dealt with this in my reply affidavit. Kindly give me that little time, my lord.
No, you have all
Yes,
the time. Mr.
I'm sorry.
Patil.
I'm grateful.
I just
my lord.
want to revisit 3.2 clause.
Yes, yes. Page number
This is
61
by
of the writ petition.
NMC.
Yes.
And this comes in 2019.
Yes. It came into force on 14th of February 22, my lord.
22?
Yes. On top
Oh,
notification.
Yes, I stand corrected.
Yes. The maximum age limit up to which a person can be appointed or granted extension or employed in service against the post of teacher or medical superintendent or dean or principal or director as the case may be, which are required to be filled up as per the norms of the National Medical Commission in any medical college institute for imparting graduate and teachers shall be 70 years. Now, my lord, I have dealt with this. I'll have your lordship's kind attention to the affidavit filed by the government of India, my lord. That starts in page
What is their
191.
stand? What is the government of India stand?
Yes. Now my reply is in, my lord, page number 191.
Yes, I have it.
No? Yes.
Yes, 191.
Yes. My lord will kindly come to page 210. Page 210.
Yes.
Last para. That as regards to the statement made in para 3.8 of the affidavit in opposition, the deponent begs to state that some of the clauses of the constitution bylaws are not applicable in case of inherited employees of the institute as admitted and communicated by Government of India by their letter dated 19/6/2012. My lord, this letter is at page 249. I'll refer to it.
249?
249. Please come to page 249, my lord, in the same page, affidavit.
Yes.
Kindly come to paragraph 2, my lord. Institute has now two kinds of employees. The first category is the employees appointed by the institute after its takeover, as per the bylaws of the institute, and second category is the inherited employees.
You are an inheritor.
I am inherited. Inherited from the state government along with institute by somewhere. As regards the inherited employee, decision is yet to be taken on the status to be decided, their entitlement for post-titular, etc., etc., etc. So it is their own case, Mila. Let me read further, Mila. Because of existence of clause 9.6 of the agreement dated 11/2/99. For instance, clause 20 of the Constitution provides for appointment of director. This said provision was not made applicable in case of the petitioner by Executive Council in its meeting dated 24/2/2011. My lord, page 158 of my affidavit, which I have already referred to. Further, while RTI reply dated 13th of May 2021 issued by the ministry, wherein the authorities specifically mention that petitioner deponent is continuing in a non-tenure post. That is page 56 of the writ petition. Till the date of issue of the notification by Government of Assam, that is page 45, the age of superannuation from service of both governments were similar, that is 65 years. However, after issuance of the
Both
said
the governments, mean both central
Government of India as well as
and state.
Yes.
It was 65.
Yes. However, after issuance of the said notification, age of superannuation of faculty staff has been enhanced to 70 years from 65 years. Therefore, petitioner deponent is legally entitled to the said benefit as per the above agreement dated 11/2/99. Hence, clause 25 of the Constitution of the Institute is not applicable against the petitioner in similar line of clause 20.
This is the
as
Government
decided.
of India's affidavit.
I am replying to
Oh,
Government
this
of
is your
India's affidavit.
reply.
Yes. Government of India's affidavit is very small, below. They say, as per clause 25 of the Constitution, I must retire at the age of 65. I said, when it comes to that fixing the tenure, Rule 20 never made applicable. The government itself said there are two classes of employees. One who were appointed by institute,
And
others were
inherited.
inherited. In case of inherited, the decision has not been taken. That's why I'm saying you can't apply that 25 to me. In any case, I have as a faculty member under both government or state as well as government rules, my lord, I am entitled to extension. The Constitution and bylaws does not mandate maximum age of superannuation in case of post of director too. That
Right
as
now, in the Government of India, it is 70.
70.
Faculty.
for the faculty
As per
members.
the, my lord, that MCI regulation.
So there are all 7. And even here in Guwahati, it has been, in
Six,
Assam, it
70.
has been made 7.
7.
Your case is being singled out according
Yes.
to you.
Now, my lord will kindly come to page 212. That as regards the statement made in para 3(9) of the affidavit in opposition, the deponent begs to state that the Executive Council of LGBI as the institute in its meeting dated so and so has resolved at resolution number 8 that institute will follow extant instructions of the regulatory bodies, that is National Medical Commission for all posts. They themselves proclaim. Therefore, the institute is bound to follow. Lord, will kindly excuse me.
Yes, yes, please.
Bound to follow the instruction guidelines of the regulatory bodies. This institute is already following the regulation of NMC in case of assistant professor, where only 1 year senior residency is required to be eligible for the post of assistant professor, instead of 3 years in other institute under central government. National Medical Council, erstwhile MCI, issued notification dated 14/2/22, which I referred, that at page 61, notifying that clause 3.2, the age limit up to which a person can be appointed, granted extension, or re-employed in service against the post of teacher, medical superintendent, dean, principal, director, etc., in medical college institute for imparting graduate, postgraduate education shall be 70 years. Respondents number 1, 2, and 6, through their affidavit in opposition, have not placed the matter in proper perspective with any supporting document. They also have not mentioned about the resolution of the Executive Council dated so and so, and the recommendation of the empowered committee constituted as per notification dated so and so. This is page 31 of the writ petition. The said empowered committee recommended at annexure 2E, page so and so of the affidavit in reply against affidavit filed by the state, especially mention that all recommendations to medical faculty posts shall be as per MCI guideline, which was approved by this Honorable Guwahati High Court in PIL number so and so, in reply against the affidavit in opposition filed by the respondent number 4. Now, for a moment, if your lordship will kindly allow me to place page number 31 of the writ petition, Miller. Similar, this was the committee which was constituted by the institute itself at page 31. See the terms of reference. To examine, then, my lord, to examine, decide various service benefits, including health coverage, post-service benefit, which may be given to the staff employees. Then, my lord will kindly permit me to place page number 132.
This document at 31 is for what? For what?
Constitution
reference?
of a committee, my lord, where
This
one
is
of
not
the
relating to age.
no, my lord, no service conditions. It includes everything. Serial number 4.
Examine and decide various service benefits,
Yes.
including health coverage, post-service benefits, which will be
Everything.
given to the staff employees.
Yes. Now, Milord will kindly come to page number 132 for a moment.
132.
Yes. It's part of our affidavit to the affidavit filed by the state.
Yes.
Kindly see the heading, Milord. Report of the empowered committee constituted to oversee the process of absorption. Now, kindly see the, Milord, following broad principles. The institute will function as a modern psychiatric institute as well as a teaching cum training institute as reflected in the approved project report. So, my lord, amongst others, it is a teaching institute. That is how the relevance of, amongst others, my lord,
Yes.
faculty. Then my lord will kindly come to page 134, the recommendations.
Does these have any relevance for the issue in hand?
My lord.
Does this has any relevance to the issue in hand?
Yes. Yes,
Alright.
my lord. Yes.
Show me.
134. Please
Yes.
come to the recommendation, my lord.
Yes.
The empowered committee recommends that qualified, skilled employees of the institute with a satisfactory service record may be absorbed in a suitable position after reorganization, commensurating with their earlier position of the employee, where such an arrangement has become necessary, even if the original position of the incumbent is no longer there to absorb him or her. Now, please come to page 138.
Yes. The existing
E.
incumbent. Huh?
E. All recommendations to the medical faculty post shall be as per MCI guidelines. Existing guidelines followed by the central government of India is followed in case of non-medical faculties. In case wherever exception made, a clear reasons for doing is recorded against each. So, my lord, amongst others, the committee recommended that when it comes to faculty members, the guidelines of the MCI, now it is MDC will be followed. Now, my lord will kindly come to the next page, page number 214. Fifth sentence line, my lord. Sentence starting with in this regard at page 214 on top. In this regard,
1 second. 214.
I'm sorry, my lord.
Yes.
In this regard, the deponent petitioner relied upon the recommendation of the empowered committee, executive council as stated above, and judgment and order dated 28th of 2019 passed by the Honorable Supreme Court in civil appeal number so-and-so arising out of SLP number so-and-so, whereby the Honorable Supreme Court was pleased to observe that there can be no manner of doubt that regulation framed by the MCA relating to condition of service of professor in medical colleges shall prevail over the service rule framed by the state. Therefore, in the above reason, the instant case, also the constitution bylaw of the institute will not prevail over the guidelines of the National Medical Commission. What's it knows, my lord? Standard of education, it is the prerogative of the Government of India under entry 66 list 1. Now, under entry 25 of list 3, state has power, but it is subject to entry 66. That is what has been laid down by the Supreme Court. Now, what emerges in my humble submission is, my lord, the state's opposition that I am not a faculty member, therefore the benefit of that 2016 notification as page 45 cannot be extended to me, cannot be accepted. The stand of the Government of India that in terms of clause 25 of the Constitution, I should retire at the age of 65 also cannot withstand judicial scrutiny for the reasons I have already discussed. So on both counts, my lord, the stand of both the state as well as state is not tenable. It's a very open and shut case, my lord. Yes. My lord, I just kindly permit me to place that page once again, my lord. Page 158. Kindly see, my lord. Page 158.
Yes.
Last, my lord, that para I have already referred once. When the institute was under the administrative control of Government of Assam, the director of the institute was appointed to a non-tenure regular post. And if the post is now made a tenure post after it was taken over by Government of India, then incumbent will be without a job after completion of his tenure. The incumbent director was absorbed into Government of India fold as director of the institute after the takeover. The members noted that director is a qualified psychiatrist and has more than 10 years of service left. The Honorable Chairman proposed that the incumbent director may be regularized in his service till the date of his superannuation, as it will not be proper to change the rules to the disadvantage due to takeover by government of India. So, my lord, it is the decision of the institute. So now they are coming up with that order, my lord, whereby they say, I must retire at the age of 65 years. It's not correct. So this is my case. As far as, my lord, this item is concerned. Now, as far as the motion is concerned,
That will come later.
okay.
Yes,
Yes.
Mr. Saikya, let me hear you.
The issue is very simple, Lordship.
65 or 70?
65 or 70, and whether his post can be equated with the post of faculties of the government medical colleges of Assam or the joint director of the government of Assam's health services department. In Assam, the government of Assam in the health department, Lordship, there are two wings. One wing is health department, director of health services A,
Director of Health
services B,
Health Services A and B.
A and B. So far as A is concerned, Lordship, all the doctors who are also holding the post of director, joint director, and doctors of the various civil hospitals, they fall under the category of director of health services A. Whereas the doctors and the faculty members of the medical colleges, they come under director of health services B.
The retirement age is different.
Therefore, my lordship will kindly take the affidavit, my affidavit. Actually, that is the case. I don't have to
Here the
elaborate
petitioner
anything.
is under HSA, Health Service A.
He was appointed, his submission also at the very beginning, that he was
Joint
appointed by APSC as joint director in Health Service A.
So you are saying he is under A.
A, and age, the maximum age in Assam
65.
is 65, and that also has very little relevance.
And
If lordship
for
is pleased to
B,
take my affidavit for a moment.
For HSB, now it is 70, correct?
For B, it is 70. For A, it is still 65.
All right. Yes.
For that, lordship will kindly take my affidavit. Of my affidavit, page
Affidavit
72.
in opposition by R4.
I think, yes, lordship. Indrani Loskar, R4.
Yes,
Yes. Page 72. This document is not placed, so I am placing this.
Just one second. Page
72. 30th July 2016.
Yes.
These dates are also very important. 30th July 2016, the order of the Governor of Assam, in pursuance of Cabinet decision dated 27 July 2016, the Governor of Assam is pleased to raise the age of retirement of allopathic doctors, all cadres, and dental surgeons working under Health and Family Welfare A department from 60 years to 65 years with immediate effect. So this document will cover him, not the other document at page 73.
Mr. Saikya, it says allopathic doctors, all cadres and dental surgeons working under Health and Family
Yes,
Welfare A
these,
department.
from these doctors, the joint directors, all come from this.
From here.
From this. I don't think there is any dispute on that.
Okay.
And the other, in 2022, that page 73, in pursuance of the Cabinet decision dated 18/8/2022, the Governor of Assam is pleased to raise the age of retirement of faculty members of all medical colleges of Assam.
That is at which page?
73. Next page.
Next page. Yes. Yes.
Now the department has changed, so medical education research and research department. So the retirement age of all medical all faculty members within bracket medical of all medical colleges of Assam, that means government medical colleges of Assam, under medical education and research department from 65 to 70 years with effect from the date of cabinet decision dated so and so. Moreover, the faculty members medical who have retired and have not attained 70 years can also be engaged on contractual basis up to 70 years. The initial period of engagement would be 1 year, and period of engagement may be extended on yearly basis based on mutual agreement and satisfactory performance. So he is trying to take benefit of this. This is not applicable to him. If Lordship is pleased to come to his appointment order, which my
Before
learned
that, Mr. Saikia, can you just draw the
Read
attention
petition.
of this court to the averments in support of these two annexures in your affidavit in
I'm
opposition?
sorry, yeah, I'll take your Lordship to all the paragraphs, but first let us understand his case. My learned friend had placed that made that submission that in 1992, yes, just a second, Lordship. There was a specific submission I have heard from my learned senior friend that he was appointed under the Health A department as joint director. And that also, Lordship will kindly, it will be visible from this document. Page 35.
Yes.
While placing this document, my learned senior friend made a submission that he was the joint director of Health Services Assam Department, Health A. So, in pursuance of the Government of India, Director of the Department of Development NER, dated 13th May 2002, SK Dero is hereby offered the post of Director, Lokopriya Gopinath Bordla Regional Institute of Mental Health, Tezpur, on regular basis in the pay scale of 18,400 to 22,400, plus other allowances admissible as per rules of LGBH Society. He is directed to communicate his acceptance within 15 days from the letter of issue. So here, Lordship, a copy is marked. Lordship will kindly see serial number 6.
6A department.
Health Deputy Secretary, Health and Family Welfare, A Department, Government of Assam. And if you look at the paragraph of this writ petition in response of paragraph annex of 5,
Page 9.
Page 9, Lordship. Page 9, I am reading paragraph 5. That an empowered committee was constituted to assess the finalize the terms and condition and suitability of the existing staff for the post, which should continue out to the institute and examine and decide various service benefits of the existing staff by notification dated 15 January 2021. The committee recommended absorption of petitioner who was discharging his duty as associate professor and head of institute under Government of Assam. The Honorable Guwahati High Court 7/8/2001 accepted the recommendation of the empowered committee and instructed the Government of Assam to pass necessary orders. Subsequently, the post of director was created on 13/5/2002 and the petitioner was offered the post of director. The said offer letter did not specify the terms and conditions in detail. Till now, Lordship, he is not very clear what post he was holding, but if Lordship is pleased to look at here for documentation. Submission I have heard, but documents I am trying to find out. I hope there will be no dispute on this, that he worked for Health Care Department.
There is no dispute.
No dispute. If that is the case, if Health Care is his original place in the department, in the Government of Assam, then which notification will be applicable to his case? Whether 2016 notification or 2022 notification. It is a very simple case that way. And number two, he is trying to base
There
his
was
whole
one
case.
document Mr. Chaudhary had also shown.
In
whereby
case
he has now he has later on he was posted as director psychiatrist.
No, he was all along director.
No,
he was all along director till today.
No, Milord. When I joined, I was a superintendent.
Lower
When the
post.
matter was taken over, I was a superintendent.
He was never a
Alright, so
professor.
as far as A department is concerned, it's an admitted fact.
Admitted fact. And Lordship, one more submission.
And there you have already shown that in case of A department, retirement age is 65.
65. And on top of that, what exactly is that sentence? Page 30.
Yes.
Clause 6. This clause 6 everywhere is a bone of contention, Lordship. Here also in the Assam Accord also clause 6. So let us see what is clause 6 is all
Term and
about.
conditions, yes.
All the incumbent officers and other employees of the institute shall, as from the date of commencement of this agreement, be governed by and be subject to the rules set out in the constitution and bylaws of the institute hereto, as amended from time to time. No quarrel till this. All the existing employees will be given choice of absorption in the new setup or reversion to the government of Assam. So if he was working as superintendent, he had that option. He could have come back and joined as Joint Director of Health Services A, or he can continue and with the post which is being offered to him. The terms and conditions governing all employees serving and employed at that point of time. This was of 1999. So who were serving at that point of time or employed, this is a past tense, not future tense, by the institute shall not be altered to their disadvantage. So what is being said, till that moment, the conditions of service as well as condition of recruitment of this particular institute was not formalized. It has not come into place. Therefore, in case in future, if there is any conditions of service to be framed by this institution, that will not be there, which will be to the disadvantage to them at that point of time. So what we have to compare?
So
we have
in
1999. 1999.
What were the service conditions?
Yes.
Retirement age.
In future, service condition of Assam government will also change, and their service condition will also be formalized.
Yes, yes.
That can be better than Assam government, or it can be at par also. But whatever may be the situation, till that moment he was not a professor. Till today, where is a document to show that he has been appointed in this institute as a professor? He is himself is a director with his own coterie. He is sitting all these meetings, holding all these meetings. And whatever they want to write, it is in the resolutions. But whether that resolution has been converted to a specific order, notification, where is that notification? From 2000.
One thing is clear from page 30, that it is the terms and condition which was governing at that
point of 1999,
shall not be altered.
It should not be altered
to the disadvantage.
To their disadvantage.
So now you are trying to say that during 1999, that 2016 notification at page 72 relating to the A category, that had 65.
That has 60 at that point
60, sorry. 60.
In 2016, it went up to 65.
65.
So where is the detrimental situation? He has not been put to any disadvantageous situation at any point of time. All along, it is a win-win situation for him without any loss.
All right.
Now, what he is trying to say, that my post of director should be equated with the post of professors of government medical colleges of Assam. Even the health head doctors cannot say that they are discriminated against the doctors of the medical colleges. We have two different categories. The government medical colleges doctors, their age has been enhanced to 70. Like the vice chancellors of various universities, the professors are still 65, be it in the Guwahati University or other universities of the state. The vice chancellor's age is 70. The professor's age is 65.
Where do I find all this in your pleadings? I'm just asking
Yes,
this because
yes.
at the end I will need this.
Yes, and I will give a judgment of the division bench, which has cleansed all the
That is
issues.
all right, but
I'll place. No, but in the pleadings, I'm placing. I have a very few points to place. Lordship will kindly take my affidavit.
Yes. Your affidavit
Paragraph
is page
page
63 it starts.
63 it starts.
Right.
Paragraph 3, the relevant paragraph I will read. The answering deponent begs to state that Lokopriya Gopinath Bordole Regional Institute of Mental Health was earlier known as Tezpur Mental Hospital and was under any Division of Ministry of Health and Family Welfare, Government of India, and then shifted to PH Division, and currently Mental Health Division of the same ministry. In 1994, the Honorable Supreme Court ordered the transfer of the Stashpur Mental Hospital from the control of Assam government to the Government of India, along with 187 employees who were working. On 11/9/1999, the Government of India entered into an agreement with the Government of Assam, and later on an empowered committee was constituted to finalize the terms and conditions of existing staff and services. The committee recommended the absorption of the writ petitioner while he was discharging duty as an associate professor of the institution. In pursuance to the resolutions adopted by the Executive Council of Lokopriya Gopinath Bordoloi Institute of Mental Health, in its meeting dated 26/9/2000, the Secretary NEC Shillong and Chairman EC of the hospital, Tejpur, constituted a committee to oversee the process of absorption of the existing employees in the institute. Pursuant to the order dated 24 June 2002, Dr. S.K. Deuri was offered the post of Director of Institute through the notification dated 24/6/2002 by Chairman EC. Generally, the tenure of such post is of 5 years. That document which was already placed. The answering deponent Beksu stated, as informed by the Under Secretary, Ministry of Health and Family Welfare, in letter dated 29th November 2016, the DO expenditure as stated, these employees, they will be governed by the Assam rules of pension, Lordship, this paragraph. Now coming to paragraph 9. The deponent Beksu stated, in Government of Assam, in pursuance of Cabinet decision of 27 July 2016, the age of retirement of allopathic doctors, all cadres and dental surgeons working under Health and Family Welfare A Department was raised from 60 years to 65 years. White notification dated 30th July 2016, which I have placed. The age of the retirement of the faculty members medical of all medical colleges under Medical Education and Research Department was raised from 65 to 70 years. By notification 31st August 2022, Annex 4. Now, next page. In view of the above stated facts in the preceding paragraphs, on the basis of records, it may be stated, Dr. S.K. Deuri was initially employed under Health and Family Welfare A Department. But upon taking over the institute by MOHW, he has been absorbed into the institute. The pensionary benefits will be given by central government, but as per the Assam Pension Rules 1969. This aspect was communicated by the director by Government of India by letter dated 10/10/2017. The extension of services under the Government of Assam are applicable only to faculty members medical of medical colleges within Government of Assam from 65 to 70, but not to the said institute having been a society registered under Societies Registration Act 1860. Whereas Health and Family Welfare A Department notification of 30th July 2016 on retirement indicates the age of retirement of allopathic doctor all cadres as 65. Thus, under such circumstances, it is considered opinion of the Health and Family Welfare Government of Assam that Dr. Soilendra Kumar Deuri has to retire at the age of 65 and shall avail pensionary benefits as per the Ministry's direction dated 29/11/2016 issued with the approval of the Expenditure Department, Government of India, applicable to inherited employees of LGHM from Government of Assam. So this is the basic facts we have stated. Now, one thing is very clear, that the notification of 2022 is not applicable to him in his own admission. Because even if we consider that 2016 is applicable, because his corresponding post in Assam government was Health and Joint Director of Health Services within bracket A. So that way also he cannot be equated with the professors and other faculty members of the government medical colleges of Assam, where the age of superannuation is 70, not 65. Whereas his corresponding post, the superannuation age is 65. The constitution of the institution also says that the retirement age of the director is 65.
Where do I get that?
Yes. If Lordship is pleased to take the central government's affidavit. এখন কার? আরে, তোমার affidavit
163,
তোমার affidavit complete। What is it?
126,
155 also is there.
155.
155. 154 the constitution.
Constitution, yes.
In fact, Lordship, he got the benefit of 5 years tenure for almost 2002 to 2024, 22 years, when the tenure is only 5 years. Nobody challenges, that is why he continued.
Yes, 25.
155,
25,
yes, tenure of service.
65 years.
The superannuation age of faculty staff is 65, for non-teaching specialist 62, and for other staff it is 60. Specific cases of contract appointment may be made generally for a period of 3 years after following the procedure, etc. So he is a faculty there, so his age is 65. And the director's tenure is very clearly stated also. Problem. Just 1 second, Lordship, I'm sorry. The central government's affidavit has the full photo video, another copy. There's a copy for Lordship. 25 to Koluna, or tenure of the director.
This is the same document which is annexed, but the
Yes,
complete
yes,
set.
Lordship, it is a full one.
Full.
They have annexed 1 page.
Okay, okay.
That's why, because the director's tenure is also 5 years.
Yes, clause 10.
Appointment,
Clause 10.
clause 10.
Term of office of chairman and of the members. You're referring to that?
19, Lordship will find appointment of director.
19.
Yes, 2.
Yes.
The terms and conditions of the appointment and emoluments will be decided by the council. Director will be in overall charge of the institute and hold office for a period not exceeding 5 years at a time.
Yes.
So we are not, that issue is not here before this honorable court today, whether he can continue beyond 5 years or not. But the issue is whether he can continue beyond 65 years or not. So for that purpose, Lordship, my learned friend for central government will make elaborate submission on the facts and the laws there. But I would like to place one judgment of the division bench of this honorable court. It is reported 2012 1 GLR page 254. The narration of the whole history, how this was converted from a state government institute to a central government institute to NEC, everything is narrated, which are very relevant for this case also. So 2012 1 GLR page 254. Here, few of the employees, Lordship, they did not qualify, they did not have fulfilled the eligibility criteria of recruitment as professors. They were reverted back because 5 years leeway was given, during which time they can acquire a qualification. So this is the case.
And they could not.
They could not. Whether the, may I read, Lord, from
Yes,
paragraph
please.
1.
Paragraph 1.
1. Whether the appellants herein, who are both doctors, stood absorbed unconditionally and absolutely in the service of Lokopriya Gopinath Bordoloi Regional Institute of Mental Health, Tejpur, on the strength of the office memorandum dated 16/2/2004, issued by the director of the institute, is the principal subject of controversy in the present appeal. Before coming to the office memorandum dated 16/2/2004, the aforementioned, let me set out in a nutshell the undisputed material facts which have led to the present appeal. The institute was formerly known as Tejpur Mental Hospital. The pathetic condition prevailing, Lordship, kindly mark, Tejpur Mental Hospital. It is not an institute, educational institute, when it was with Assam government.
Yes.
Because his whole case is that he was a professor here. It is basically a hospital, just like our civil hospital, where also we have deputed our doctors of Health A department. The pathetic conditions prevailing in various mental hospitals in India and the plight of the patients suffering from various kinds of mental disorder were brought to the notice of the apex court by way of a public interest litigation on the basis of a report of the eminent social worker Sila Burse. On the basis of the recommendation made by the Gopal Subramaniam Commission, the apex court passed an order on so and so, so directed the Assam government to take over.
Yes.
Lordship will kindly come to Roman 3. As provided by clause 6.
Yes.
The existing employees of the institute, numbering in all 184, continued in the institute with the rights vested in them to exercise options. So 184 includes the director here. As aforesaid, for absorption until the terms and conditions subject to which they were to be absorbed were finalized. In the meantime, a society in the name of Gopinath Bordole Regional Institute of Mental Health, Tajpur, came to be formed, and steps were taken for development of the institute and its academic departments for teaching and training, and also for improving the quality of psychiatric care to be provided by the hospital wing of the institute. Notwithstanding the agreement entered on 11 to 1999, where this clause 6 is found, between the government of Assam and NEC, since the terms and conditions for further retention absorption of the Assam government employees who were at the relevant point of time working at the institute had not been finalized till then, and yet on the other hand a new body had taken over the management of the institute, two appellants, namely so and so and many others, sought for granting them lien for a period of 1 year with effect from 17 to 1999 on the ground that the service rules of the institute had not yet been completed and they were not in a position to exercise their option. As the terms and conditions of their absorption had not been finalized even till 17 to 2000, the appellant herein again wrote to the state government seeking extension of their lien for 1 year with effect from 17 February 2000, so as to enable them to exercise their option if they wish to continue in the institute on such terms and conditions. Having considered the fact that the terms and conditions had not been finalized in respect of the government employees who were till then working at the institute on the basis of agreement reached on 11 to 1999 between the government of Assam on one hand and NEC on the other hand, the state government issued a letter on 25th April 2000 granting quasi-lien to all the 184 number of employees, which included the present appellants, making it clear that the said employees would retain their lien for a period of 2 years with effect from 17 to 1999 till the time of submission of option by the employees for finalization of the terms and conditions of service as per clause 6 of the agreement dated 11 to 1999 aforementioned. The letter was issued with the concurrence of the Department of Finance, Government of Assam, as stated so and so. So I am skipping this part. Now coming to next page, Roman 8. What is the basic subject matter of the leads? In course of time, the director of the institute issued an office memorandum dated 16 to 2004.
Where are you reading? Paragraph 8.
In Roman 4 of that paragraph.
Oh, Roman 4. Yes, yes.
In course of time, the director of the institute issued the office memorandum dated 16 to 2004. It is this memorandum, which has already indicated above, forms the principal subject of controversy. For the appellant rely on this letter to support their contention that they were permanently, absolutely and unconditionally absorbed in the said institute by virtue of the letter aforementioned. Whereas the case of the respondent is that the absorption which the letter aforementioned stated about was an absorption subject to conditions of absorption which were made known to all concerned, including the present appellants, by letter dated 3/5/2002. This is very important. Lordship will kindly mark this. 3/5/2002 aforementioned, which specifically stipulated that since the pay scales of the central government were higher than those of the government of Assam, the employees, in order to be fitted against a redesignated post, must fulfill the criteria prescribed by the recruitment rules, and they are accordingly required to acquire necessary educational qualification within a period of 5 years, or else they were to be reverted to their parent cadre. This apart, further case of the respondent is that the copy of the letter dated 13/5/2002, which according to approval of for the restructuring or creation of certain number of posts in the government of India pay scale, also laid down guidelines for offering such posts to the eligible employees of the institute who were eligible and qualified. The respondent plead that those employees serving the institute who had not acquired eligibility criteria were given the option of acquiring necessary qualifications within a period of 5 years, and in the meantime to come over to the Government of India's pay scale. According to the respondents, as the present appellant had failed to acquire the educational qualification, which in terms of the letter dated 13/5/2002, they ought to have acquired. The director of the institute issued the letter dated 11/6/2006, addressed to the secretary to the Government of Assam Family Welfare A Department, informing the latter that some of the doctors, including the present appellants, could not acquire their requisite qualification within the stipulated period of 5 years and therefore cannot be absorbed in the institute after conversion of the institute into a teaching cum training institute. The director of the institute accordingly requested the government to do the needful to repatriate to their parent cadre whose doctors who could not acquire the requisite qualification for enabling them to be retained in the service of the institute. Agreed by the letter dated 11/6/2006, aforementioned, the present appellants along with others filed a writ petition which gave rise to so-and-so with a prayer to set aside and quash the 11/10/2006 letter, and also to restrain the respondents from reverting to the petitioners to their parent cadre in the health department by judgment and order dated 9/10/2007. Since the writ petition stands dismissed, two of the writ appellants have as preferred this appeal. Now coming to the findings, paragraph 6. We are now required to consider, in the light of the admitted facts as narrated above and the rival submissions made on behalf of the parties, the question as to whether, by virtue of the Office Memorandum 16/2004, the appellant stood permanently absorbed, and if so, whether enforceable right has accrued to them, warranting this court's interference with the letter dated 11/10/2006 aforementioned. To find the correct answer to the question, let us assume for a moment that the Office Memorandum dated 16/2004, the director of the institute had permanently absorbed the present appellants in the services of the institute, and such absorption was unconditional and absolute. Let us also assume for a moment that the appellants were unaware of the letter dated 13/5/2002. This is the source actually, 2002 aforementioned. The question posed above gives rise to yet another question, and it is whether in the facts and circumstances of the present case, the High Court would be justified in setting aside the impugned letter dated 11/10/2006 and in directing the institute to retain the appellants in the service of the institute and or prohibit state government from repatriating the appellants to their present cadre. The question raised above necessarily takes us to the PIL to which the institute owes its birth. The very fact that the institute is born as a result of the directions issued in the PIL, one is left with no choice but to conclude that it is in exercise of the power vested in the Supreme Court under Article 32 of the Constitution of India that the directions had been given by the Supreme Court to the Government of India to take over the management of Tezpur Mental Hospital as it was then known and upgrade the same with a view to providing better medical facilities to those who are mentally sick and might have suffered from mental illness. The directions so given were undoubtedly to enforce the right of those who were suffering from various mental disorders and to safeguard the rights and interests of all those who were likely to become mental patients. This is the predominant public interest which the apex court directions given in Sila Burse's case aimed at protecting. Treating this public interest as the pivot around which revolves the entire appeal, it needs to be further pointed out that the apex court's order in Sila Burse's case had cast unavoidable responsibility on the Government of India and also on Government of Assam to ensure that the directions in Sila Burse's cases are scrupulously and faithfully abided by all concerned. It was also this reason that the High Court too was required to monitor the development which had been taking place as a result of the direction issued in Sila Burse's case. No wonder the Government of India took a decision to vest Tezpur Mental Hospital in the NEC and develop the same into a regional institute of mental health. As the Government of Assam could not have shirked its responsibility as a state, the deed of agreement dated 11/2/1999 was executed by and between the Government of Assam on one hand and NEC on the other. By virtue of this agreement, Tezpur Mental Hospital was handed over to the NEC for better management, This agreement already indicated above perceived formation of a society with a aim and objective of investigation, diagnosis, and treatment of the mentally ill patients in all forms and rehabilitation of patients of the northeastern region of India. The hospital was to be upgraded as an autonomous regional institute of mental health with participation of its management by the NEC and the government of Assam. Following the agreement so executed, the institute was formally handed over to the NEC by the government of Assam by order dated 22nd October 1999, passed on this in this regard. Pausing here for a moment, Lordship. In 1999, the institute was at a certain stage. It is a mental hospital. NEC and central government stepped in to upgrade it
To an institute.
to an institute, but not to a medical college. Treatment of the mentally ill persons. It has no induction of persons as a student.
Even today.
Of late, very late, it has started. But in 1999 or till that transition period up to 2006, it was not that situation. So whether he is a professor status, not a professor, has no relevance at all. Whatever has been upgraded, it is always for the betterment. So there is no downgrading.
So there is only treatment, not teaching.
Not teaching. So we cannot equate. And he was also not teaching. He was superintendent. That is a purely administrative post.
So at that time?
At that point of time.
He was superintendent.
He is, I think, deputy superintendent first, then superintendent.
At that 99, when this agreement was entered,
His I heard his submission.
That time he was,
superintendent.
All right.
I am continuing, Lordship. It is in terms of the agreement dated 11 to 1999, a society was formed under the name of so and so. Since the society has been formed under the agreement dated 11 to 1999, aforementioned, it is funded by the NAC as the state government. Every year, state government is also having a contribution there. So state government has a stake. I have a right to address this honorable court. I am not an intruder here. The institute could not have acted and cannot be allowed.
Party,
Lordship.
You've been made a party, otherwise you would have been made a pro forma.
But my learned friend is saying that he is seeking the relief from the central government, not from the state. Yes. We have, because when every day there are complaints. Every day there are complaints against his director. So many complaints are flooded in Dispur. Had it been the other institute, Lordship, we would have taken
as far as this case is concerned, your presence is definitely...
Yes, Lordship, my chief secretary has made a party here.
Correct. And you are also a signatory to the agreement.
Absolutely, Lord. So every year we are contributing a huge amount. The institute could not have been acted and cannot be allowed to act in violation of the conditions which were stipulated under the terms and conditions of the said agreement, nor can the state government, the NEC and/or the government of India disown its responsibility to ensure that the objective with which the institute was established are not defeated by any independent or unilateral action or decision of the institute or any of its functionaries. That letter of 2004 was issued by this gentleman only, where he said all are absorbed unconditionally, absolutely, which was a letter on the division bench of this honorable set aside, as well as the single judge also. This obligation is an integral and inseverable part of the predominant public interest, which warranted and still warrants the institute to ensure that the purpose with which the apex court had passed various directions in Sheila Burse's case, leading eventually to the birth of the institute, does not violated or diluted. Bearing in mind the above basic duty which stood cast on the government of India, the government of Assam, the NEC and the institute let us now consider further development in the matter. These are very relevant. That's why I'm placing Lordship.
Yes. It also has a little bit of the history. How?
Yes, Lordship. Because these were not placed by the other side. That's why I'm taking your Lordship, because the relevant paragraphs are much later. The whole history, how it was born.
Correct.
What is now of great relevance to point out is that at that time, when the agreement dated 11 to 1999 was executed, then Tezpur Mental Hospital was a hospital owned and maintained by the state government. So it was purely a hospital, not a medical college. Obviously, the employees of the Tezpur Mental Hospital were employees of the state government. These employees could not have been forced to serve the new institute which was to be formed. At the same time, the transition of the Tezpur Mental Hospital into an institute of the standard, which Sila Burch's case envisaged, was not possible without providing the institute, which was yet to be born, with suitable employees. Provisions were accordingly made in the agreement dated 11/2/1999, delineating the manner in which the institute on its part would function with the help and support of the government and its employees. It was this object which Clause 6 of the said agreement proposed to meet, as Clause 6 is extremely relevant for the purpose of this appeal. Clause 6 of the agreement is reproduced herein below, the same clause, Lordship.
Yes.
That
But
cannot
you
be
may
altered
skip-
to their disadvantage.
you
It
may
has been
skip
quoted.
that.
Now, what is the interpretation of the Honorable Court now?
Yes. 14.
In the face of the provisions made in Clause 6, it became clear that notwithstanding the fact that Clause 6 made further service of the employees of the institute subject to the rules set out in the Constitution and bylaws, the institute, as may be amended from time to time, Clause 6 provided the freedom of choice to the existing government employees serving Tezpur Mental Hospital to either get absorbed in the new setup on new terms and conditions. This is very clear, Lordship. Under new terms and conditions, they have to accept it, which were to be yet to be settled and finalized, or revert to the service of the state government. Clause 6, however, made it explicitly clear that the state government employees will not be able to serve the institute except in accordance with the rules and bylaws of the institute. I have placed the Constitution, Lordship. So nobody will be allowed to serve in this institute by violating the Constitution or the
And
bylaws.
in that clause 6, it is said that in the
It cannot be
Constitution-
detrimental.
It
Now,
cannot
on
be.
one point, if it is detrimental, you have the options to go back to your parent department. That is Government of Assam.
No, but I don't think that we need to go that far, because in this case,
Now, I'm countering their argument.
yes, but no, but in this case, the Constitution, the retirement age is not detrimental, because he was already the same. It was the same age.
In fact, he got benefit.
Correct. It was 60 then.
He
Now
was
it is
60.
65.
65. He got benefit of the Constitution, not of
That's
2006
what, of the
Assam
Constitution.
government's notification. It has nothing to do with the Assam government's
Because
notification.
as per the Constitution, the new terms, it is 65.
65.
Correct.
So he's getting benefit.
He's getting a benefit.
Had he
It's not
been
detrimental.
55, he would have a case. If it
But,
was suppose reduced to
Mr.
55.
Zaika, maybe at the end of your argument, just point out that particular averment or page from where it is clearly discernible that at that time, at 99, the retirement age of the petitioner terms would have been 60. Just at the end, you may. I don't wish to break the flow of your argument, but just point out that particular.
That particular.
You may ask your junior, Mr.
Yes,
Dhar. you
we'll
may-
find it out.
Yes.
Maybe it will
Mr.
be 58.
Gogoi, Mr. Dhar, you may
Yes.
just look and keep that page.
In fact, I am sure it was 58. at that
Whatever
point.
it is,
I'll
because
place
you
it.
understand why I'm asking.
No, I understand.
Because, yes.
Why? I'll get a proper, in writing, I'll place it, Lordship, tomorrow.
That would be important.
I'll place it to the
Very
court
good,
master,
very
Lordship. Because that will have a very important
Correct,
relevance.
correct.
Because their whole case is that it has been to their detriment.
Correct,
No,
correct,
all along they are getting benefit. All along.
Correct.
Their service conditions, the salary, etc. And those who were not qualified, they got 5 years time to fulfill that requirement of eligibility. So may I continue?
Yes, please.
So this line is very important. This is the opinion of the court now. However, made it explicitly clear that the state government employees would not be able to serve the institute except in accordance with the rules and bylaws of the institute, which is going to be framed at that point of time. Now it has been framed. Since no service rules has been admittedly framed by the institute as yet, it logically follows that all steps taken by the institute with regard to the conditions of recruitment or conditions of service of its employees have to be yielded to the predominant object and public interest with which the institute was given birth to. The institute could not have thus deviated from the primary objective which has been judicially determined. Logically, therefore, the service conditions to be set out by the institute were to be such which would be subserve the object with which the institute was formed. Upon its birth, the institute, as already indicated, have two wings, one wings being academic, the other administrative. The academic department was to be involved in teaching and training of persons who could impart knowledge of psychiatric treatment so as to improve the quality of psychiatric care which the hospital wing of the institute were to provide. It was to meet the objective that the executive committee of the said society constituted an empowered committee. This empowered committee has, as already indicated above, made recommendations with regard to the various service conditions of the employees of the institute, including the condition of recruitment. The condition of recruitment were not only in tune with the requirement of the Medical Council of India, but also in tune with such conditions which enable an employee of the Government of India to avail the pay scale fixed by the Government of India. The institute accepted the recommendations made by the empowered committee, and the same received the seal of approval of this High Court, which had the responsibility to monitor the taking over of the Tezpur Mental Hospital by the NEC. It was therefore natural that the state government has also agreed with the recommendation made by the empowered committee. In terms of the recommendations made by this empowered committee and also the orders of the High Court, posts of various faculties of the institute, including postgraduate degree, were created. These are all subsequent development. Obviously, the institute could not have ignored the recommendations so accepted and so approved by the High Court. The institute thus confronted a situation where it could not have retained in its service anyone who do not fulfill the criteria laid down as conditions of recruitment for the eligibility criteria of a doctor who has already serving the institute as a state government employee, admittedly perceived postgraduate degree in various disciplines as one of the conditions of recruitment. It was in order to ensure that such conditions of recruitment were faithfully adhered to that the Government of India Department of the Northeastern Region declared by letter dated 13/5/2002 the aforementioned creation of various posts in the institute. This letter, in unambiguous terms, made it clear that the existing post would no longer exist, and this post would be redesignated in terms of the said letter so as to bring the employees of the institute at such pay scale which other employees of the central government would receive from the such post. The relevant portion of this letter reads that, Lordship will kindly come to next page at serial number 2, Roman 3.
Yes.
The post of director. The post of director of the institute may be in the pay scale of 18,400 to 22,400, corresponding to the joint director of health services of Assam government, Lordship, which he is also admitting. So far as the joint director of health service of government of Assam, the age of superannuation, if we accept their argument also, it is 65, not 70. So therefore, actually no case is there. That is why every day is crucial in my submission, I said. From beyond 22nd of July, his continuance is against the law. However, because of the interim order and we could not place the correct position before the court, that order was passed. However, that is why we filed a vacating petition maybe also. So we have filed a...
And you now have taken it
yes,
up
Lord,
for
for final disposal. That is why there is a hurry in this matter.
So, that is the reason this court has is investing so much time in this
Lordship,
case.
I'm highly
There is,
obliged, Lordship.
a lot of admission matters which are yet to be taken up to there on
all these subsequent
Anyway.
petition. My friend is also waiting, and some other doctors are waiting. They are all ready with writ petitions because of this case.
Majumdar from there to here, he has traveled.
First, he was waiting outside. He was enjoying our difficulties. Now he has some confidence. He's gaining some confidence.
Anyways, yes.
So next paragraph.
17.
Yes, 17. The letter dated 13/5/2002 makes it clear that no post which was in existence until 13/5/2002 would exist at the pay scale of the government of Assam, which the doctors serving the institute at the relevant point of time were otherwise enjoying. Consequently, each of the then existing posts, according to the letter dated 13/5/2002, was to be redesignated and renamed with new pay scale consistent with the pay scale of the central government from its very inception, from the very entry level. So they are getting everything in tune with the central government's pay scale and benefits. So everything is to their advantage, not to their disadvantage. The letter dated 13/5/2002 aforementioned also made it clear that every newly designated post with new pay scale would be available only to such person who fulfill the conditions of recruitment so as the qualification and experience were concerned. Since all the employees of the institute do not fulfill the eligibility criteria as regard their qualification and experience, they ought to have been repatriated to their respective parent department. However, as an one-time exception, the government of India decided that the then serving employees would be allowed to come over to the government of India's pay scale without fulfilling the condition of recruitment. But their such absorption or their being allowed to enjoy the government of India's pay scale was conditional, and the condition appended to the enjoyment of such pay scale was that the employees who do not fulfill the eligibility criteria must acquire the same within a period of 5 years, and if any one of them do not acquire such qualification within 5 years, he was to be repatriated to his parent cadre. These conditions, incorporated in the letter dated 13/5/2002, made it clear that the continuation of any doctors in the service of the institute would not be permitted beyond the period of 5 years from the date when the institute was born, unless the doctor concerned acquired the educational qualification and experience in terms of the conditions of recruitment as had been finalized by the authorities concerned and had the seal of approval of the High Court. Nothing had been pointed out at the time when the writ petition was heard, nor was anything pointed out at the time when this appeal was heard to show that the content of the letter dated 13/5/2002 was not in tune with the objectives which the directions was given by the apex court in Sila Burse's case, aiming at achieving. The appellants have expressed at the time of hearing of the appeal their ignorance about the letter dated 13/5/2002. Whether the appellants were really ignorant or not is not, even today also, they are not producing this letter. All the history has been quoted before this honorable court, but this very crucial, important letter was not placed by them. There is a suppression or maybe a deliberate suppression of this letter in present proceedings also. Whether the appellant had really ignorant or not is a question which we would answer a little later. Suffice is to point out here that assuming that the present appellants were not aware of the content of the letter dated 13/5/2002, the question which stare at us is whether the face of the letter dated 13/5/2002, the law would permit even the director of the institute to permanently absorb the appellants without any conditions appended thereto when the appellants do not admittedly satisfy the eligibility criteria for their further retention in the service of the institute. It is also worth remembering that many a times the word absorption appears to be misnomer in service jurisprudence, for absorption means nothing but appointment into a service wherein the person sought to be absorbed was not actually born. The service jurisprudence does not permit a person to be absorbed unless and until he satisfies the conditions of recruitment. So we can skip this part, Lordship. This is regarding absorption, and in response to that part, coming to paragraph 24.
Yes. Coupled with the above.
Coupled with the above, it is also important to point out that the present case, the agreement between the state government and the NEC was entered on 11/2/1999. This agreement made it clear that the terms and conditions of the employees who were at the relevant point of time serving Tezpur Mental Hospital were not to be changed to their disadvantage, and that their absorption in the institute, which was yet to be born, would be on obtaining their choice for such absorption. In the intervening period, the state government employees, including the present appellants, could have continued to serve the institute only on lien. No wonder, therefore, the appellants had applied and the state government accordingly granted quasi-lien for a period of 2 years with effect from 17/2/1999 or till the date of submission of option by the employees or finalization of terms and conditions of their service as per clause 6 of the agreement aforementioned. This lien would have obviously expired on 17/2/2001. The fact that the appellant also clearly understood that they would not be able to serve the institute any longer without their lien having been extended, they applied by later dated so-and-so of the affidavit in opposition to the state government for further lien from 17/2/2001. Thus, the lien originally granted by the state government continued and has, in fact, according to the records produced by the state government, has been continued, and in consequence thereof, some of the state government employees who had been serving the institute have been granted even pro bono promotion. Coming to paragraph 27 now. In the context of the facts and attending circumstances, two different cases wherein the interpretation of clause 6 of the agreement dated 11/2/1999 was involved, a division bench of this court on 7/11/2006 in WA so and so observed, as provided in clause 6, the existing employees numbering 184 appointed against substantive posts continued in the institute with right vested in them to exercise options for consideration for absorption. The provision in clause 6 made it clear that with effect from the commencement of the agreement, the officers and employees of the institute will be governed by and be subject to the rules set out in the constitution and the bylaws of the institute, and they will be given the choice of absorption in the institute or repatriation to the parent department under the government of Assam. The right of exercising options for consideration of permanent absorption in the institute cannot be read in separation with the other provisions of the clause, wherein it is provided that the terms and conditions governing all the employees serving and employed in the institute shall not be altered to their disadvantage. This means that the incumbent officers and other employees should have been allowed to continue as till finalization of the terms and conditions of the service. It is in this context the state government by letter dated 15th April 2000 addressed to the director of the institute informed about government's decision of granting quasi-lien to all the 184 officers and employees for a period of 2 years from 17 to 1999 or till date of submission of option by the employees on finalization of the terms and conditions of service as per para 6 of the agreement signed by between the government of Assam and NEC, whichever is earlier. The word whichever is earlier in our considered opinion was out of context. The lien of the instant case was granted obviously with a view to mark time to enable the authorities of the institute to finalize the terms and conditions of service and to call for options from the officers and employees as provided in clause 6 of the agreement. It is conceivable that the officers and the employees could be asked to exercise their options before finalization of the terms and conditions. It is pertinent to mention here that all the 184 officers and employees were state government employees appointed against substantive posts, and their absorption in the institute would bring a drastic change in their condition of service, since the institute is a cooperative society having its own identity. The status of the government servants cannot be allowed to be changed by an authority without obtaining an options from them as well as concurrence of the state government. Obviously, such option could not have been invited before finalization of the terms and conditions of the service and the institute. From what has been observed above, it becomes crystal clear that the question of absorption in the institute would have arisen only on finalization of terms and conditions. In the present case, there is nothing other than the letter dated 13/5/2002 laying down the terms and conditions subject to which absorption of the appellant was possible. Since the institute was under the pervasive control of the central government in terms of the judicial orders, neither the institute could have deviated from the terms and conditions which the central government had set, nor could the present appellants as state government employees got themselves absorbed on terms of the and conditions other than those which stood incorporated in the letter dated 13/5/2002. This is very crucial because this letter said the terms and conditions. Later on, the constitution came. Situated thus, it is clear that since the present appellant as the state government employees had not fulfilled at any stage the conditions of absorption as were incorporated in the letter dated 13/5/2002, the state government had no option but to continue to grant extension to the appellant's lien, and since the appellant had not within the stipulated period of 5 years acquired the eligibility criteria for permanent absorption, the state government had to pass and has in fact passed orders on 27/2/2008 recalling the appellant from being posted in the parent cadre. So what I'm trying to emphasize or stress upon from this judgment is that they were given that option of clause 6. You have to abide by the terms and conditions to be finalized in the institute. If you are not happy, a continuous lien was granted. If you are not happy, you can opt to go back to your parent department. But if you opt to continue in the institute, then you are governed by the terms and conditions as set in the bylaws and the constitution, which is very clearly the division bench opinion in paragraph 14. In 14, it is very clearly said, the last line,
Yes.
however, made it explicitly clear that the state government employees would not be able to serve the institute except in accordance with the rules and bylaws of the institute. In fact, that is why his continuance as director beyond 5 years is against the spirit and mandate of this judgment. It's a contempt. And 27 also, which I have just placed, no? That below next.
27, that quoted portion,
Yes.
it is quoted, I think, where
Yes.
it says obviously such option could not be.
Yes.
No. That quoted part, right, in our considered opinion.
Yes, yes. That whole paragraph, Lordship. So, three division bench judgments very clearly says these two judgments number is there. Writ appeal 398 2004, 399 2004, and the judgment which is reported WA 200 of 2008.
Yes.
So all these judgments of the division bench very clearly explain the purport of clause 6 of the agreement. That is one part. If we take that line of argument. On the other hand, if we accept their line of argument, then also they do not fall into the category of the doctors who are serving in the medical colleges of government of Assam. Health B.
A.
They belong to
They belong to A. Sorry.
and they belong to A. So they cannot equate themselves with the doctors of Health B. The letter of 13th May 2002 very clearly says the post of director is corresponding to the post of joint director of health services. The pay scale, his appointment order or offer letter, the same pay scale, 18,000 up to 2,000, 22,000. So in that view of the matter, Lordship, there is no material, no merit in the case of the writ petitioner to continue seeking a prayer for allowing him to continue beyond 65 years, commensurate with the period of age of superannuation of the doctors of the government medical colleges of Assam. If that is his comparison, Lordship, it is absolutely a comparison which cannot be accepted by any reasonableness or any cogent reason. In that view of the matter, in my humble submission, the writ petition is liable to be dismissed. And in any case, they are because the interim order is also till today. So as Lordship is taking up, so I am praying for dismissal of the writ petition by vacating the interim order. Highly obliged. My friends will continue. Lord.
Yes, Mr. Saika. Mr. Gogoi. Mr. Suika, just you kindly give that document.
Of 1999, the age of superannuation of the doctors of health. Already we have it.
58 years.
It was 58.
All right.
59, all government servant. All government servant. All of them, 59 years.
May I place it, Lordship? This is of 25th January 2005. May I read it, Lordship?
Yes.
Raising the age of retirement of the state government employees from 58 to 59 years of superannuation. Government has been considering for some time past the question of raising the age of superannuation of state government employees from 58 to 59. After very careful consideration of all relevant aspects, as it has been now decided that the age of retirement of the superannuation of the state government employees, other than those in whose case the age of superannuation is 60, should be 59. This decision is applicable to all state government employees who are due to retire after 1st January 2005. Those employees who retired on 31/12/2004 on superannuation will not be entitled to get this benefit. The age of retirement of grade 4 and other government employees who are at present entitled to serve up to 6 years, including the present events, will continue 6 years.
Right.
So till that moment, there was no distinction of health head doctor, health B doctor. All are in the same category.
58 it appears.
It was 58. Then in 59, it was enhanced. So 99, it was 58.
All right.
Obliged, Lord.
Mr. Gogoi, you give a copy to the other side.
Even enhancement of 60 also there also I will provide it. So Lordship, regarding the factual part, Lordship, my seniors I have already explained everything. I am not lost the honorable court's valuable time. Just I clarify, Lordship, certain documents which was relied by the petitioner, Lordship. So, my Lord, at first, Lordship, they have paid that their enhancement is should be as per the, their case is that it should be by the as per the OM of the government of Assam, Lordship, where it enhanced the age to up to the 70 years, Lordship. And regarding this particular issue, Lordship, we have already filed our affidavit. If Lordship permit, I can place 2-3 paragraphs of our
Yes,
affidavit.
yes.
Affidavit, Lordship.
Why should I not permit you, Mr. Gogoi?
Lordship. So, Lordship, I am basically relying paragraph 3, Lordship. Paragraph
Page,
3,
page.
it is in internal page 164, Lordship. It starts from, Lordship.
164.
164, Lordship. 164, Lordship. 164.
Yes.
164, paragraph 3, start, Lordship.
Yes.
Up to, Lordship, Roman 6, Lordship, there is a history, earlier history is there, Lordship. So, my Lord may kindly come to from Roman 7, Lordship, 166.
Yes.
166. That the Department of Expenditure by letter dated 29/2016 stated that consonance with the clause 6, that is in page 30 of the repetition, Lordship. Clause 6 of the agreement between Government of Assam and Northeastern Council Secretariat, Ministry of Home Affairs, Government of India, the terms and condition of employees, that is employees of the state government, as on date of the agreement 11/2/1999, shall not be altered to their disadvantageous position. That clause 6, Lordship. As these employees are stated to be governed by the Assam Service Pension Rules 1969, it would be appropriate if pension of these employees as per these conditions are
Mr. Gogoi,
continued.
just 1 second. Time নহ'ব। কিমান থাকি গ'ল কিমান? I don't think there shall be time for the other matters. If any date, if both parties consent to any particular date after vacation, you may just inform the court master, because next week is a motion day.
Item 20, this may also be taken up after.
Whatever, just inform. If both parties are there, then please do it in front of the court master. Mr. Datta, please inform the court master.
My Lord, only one judicial order is required. My Lord, the APSC matter. My Lord, the result of the few of the candidates are withheld. My Lord, that can be announced. My Lord, that
I cannot blindly give you that
before your
direction.
lordship in the next day.
Sorry?
My Lord, that result.
But this
can
matter is in an admission stage.
be, yes, admission. But they don't have any objection, my Lord.
Will you item number?
Item 48 to 52, your lordship.
Item number 48 to 52. Will you list this on Monday?
Tuesday, my Lord.
Tuesday?
My Lord.
All right.
Public.
Yes, Mr. Gogoi.
So, Lordships, I am continuing. Shall not be altered to their disadvantages, as these employees are stated to be governed by the Assam Service Pension Rules 1969. It would be appropriate if pension of these employees as per these conditions are continued to be paid. Rather than applying CCS Pension Rules 1972, the same was conveyed by the Ministry of Health and Family Welfare to the LGBI by letter dated 29/11/2016. I will place letter on this letter, Lordship. Then, my Lord, 8. The clause 25 of the Constitution of the LGBIM Tezpur as set out below for ready reference.
You are at page?
Page 166, Lordship.
Para 8.
Roman 8. Lordship.
Roman?
8.
There's no Roman. Page 166.
166, Lordship.
Oh, there are two 166.
Lord.
Okay. Roman 8.
Roman 8.
Yes, yes. Yes, read.
The clause 25 of the Constitution of LGBIM Tezpur as set out below for ready reference. Tenure of service, Lordship. The superannuation age of the faculty staff is 65 years for non-teaching specialist doctor, 62 years, and for other staff 60 years. Lordship. Here, Lordship, 3 categories are employees there, Lordship. For the faculty members, it should be 65 years, Lordship.
Yes.
And non-teaching specialist doctor, it is 62 years, Lordship. And for other staff, it's a 60 years, Lordship.
Superannuation age of faculty staff 65,
65 years,
non-teaching 62,
62,
and other 60.
60 years. Just I clarify one thing, Lordship. Here the petitioner, the post which was held by the petitioner is a non-teaching staff. He should retire in the 62 years, Lordship. He's benefited 3 years more, Lordship. The 3 category, one is the administrative, one is the Lordship, other is the Lordship, the teaching staff, Lordship. And teaching staff, Lordship, for
But
65.
he is not a doctor, no? Is he a doctor? No.
No, Lordship.
He's not a doctor.
No, Lordship. It's a non-teaching staff, Lordship. That's why I'm referring to
Non-teaching specialist doctor.
Lordship.
He is
And-
not that.
Not
But and for other stuff,
other staffs, Lordship.
I think he will come under that.
Other staffs, Lordship.
If we go by
Other staffs, Lordship. Yes, because the particular post which he is holding is neither a faculty nor a doctor, Lordship.
So that means 65, 62 both will not come.
No, then loss is
60 will
He
come.
will come within the category of 60 loss.
But then, but that also will not be detrimental to his interest because
No,
at,
no.
at 99 in 99 it was 58.
It was 58 years, Lordship. As per the clause 6, it is there, Lordship. At no point of time, Lordship, his service condition was altered, Lordship. No point of time. The petitioner had accepted the offer of the respondent and
Mr.
therefore.
Gogoi,
Lordship.
after we conclude,
Yes.
I will. You can take a day, but
Yes.
just give me the compilation of these relevant, just the
Lordship, I will provide.
from 99 those
Lordship,
what you have given.
Even Lordship, we have prepared one also. I will provide.
Very good.
Detail I will provide. Lordship.
Yes.
And some of the most important documents, Lordship, which should be necessary for determination of the particular issue is not annexed here, Lordship. It is annexed in the item 42, Lordship.
What is that?
Item 42 regarding here you have annexed
Mr.
one
Majumdar is in item 42.
Lordship.
You are a petitioner there.
I have Lordship verified after that I have found that, Lordship. The document by which document it was transferred to the NEC to the Ministry of Health, Lordship.
In 42, you are also the issue is same.
Issue would be, my lord, because after his retirement, he has imposed the punishment of compulsory retirement on me. So his entire on me. So his entire stand that he was the professor and the director, that he could not have been so per official documents, certified copies of which we have taken.
Basically, your case is interlinked, not similar.
Interlinked.
So
Anyway, I think let's do one by one. Otherwise, it will get confused.
Just that point out, Lordship, one document I am relying from that for proper adjudication issue. Because, Lordship, when it was transferred to the Ministry of Health and Family Welfare, Government of India, Lordship, the conditions are totally defined, Lordship. After that, Lordship, EC has no power, empowered committee has no power. The document which was relied by my senior sir, Lordship, that document will not do it. I will just point out it, Lordship. So, Lordship.
No, but otherwise, if we see it one way, it appears a very simple issue.
Lordship.
The issue that this court has to decide in this case is whether the petitioner retirement age is going to be 70 as per that document, or
yes, Lord, this is
65. Correct.
This
Now,
is,
in order to decide this issue, this court has to first see what was the retirement age
Lordship.
in 1999.
Lordship.
That the document
Lordship.
shows is 58.
Lordship.
Correct.
Lordship.
Now, after that, the terms has been changed. The
Lordship.
constitution you
Lordship.
have placed.
Lordship.
The constitution does not determine
Lordship.
the age that is fixed
no point
is
of
not
it.
detrimental
Lordship.
to what he was.
Lordship.
What was the earlier age? That is the issue.
This is the moot questions my lord have to decide, Lordship. Not other things,
That is the only thing.
This is
So
the moot
the
question,
rest of
Lordship.
the things
Rest of the things, Lordship,
may not have much relevance.
not a single point is relevant here. Only that particular moot question which was indicated by my lord is to be decided in this
Correct.
case.
Now, here, if the petitioner places a document and shows
Lordship.
that in 1999 it was 70, then it would have been another thing.
Lordship.
Correct.
No, Lordship, that was not there.
But that appears not to be, because
Even
till now
Lordship-
no such document has been placed by the petitioner.
Even
On the
Lordship,
contrary, you
MCI
have
guideline-
placed this document which abundantly clarifies
Lordship.
that it is 58
Lordship.
around
Lordship.
1999.
Lordship. Even Lordship, the MCI guidelines also Lordship misinterpreted.
So
before your
even if
Lordship.
we don't go into this AB business,
Lordship.
even then
Then it is also clear,
because,
Lordship.
because now as per the constitution, it has to be as
It
per the
has to be.
constitution.
As per the constitution, I will place the latest judgment of the Honorable Apex Court. What Honorable Apex
And
Court
if
has
we
said.
go by this constitution, though I don't want to get into this now because that will create difficulty.
Lordship.
Because apparently the petitioner was allowed to be retained in service till 65.
65.
Correct.
Lordship.
So if we go into that will create
That
difficulty.
part we have leaked, Lordship. Now we are taking the age of 65 years, Lordship. 65 years. We are supposed, Lordship, that part Lordship says not to decide whether it should be 60 or 63 years.
When
but
is Mr. Chaudhary going to give his reply?
As per instruction of my senior, he will give his reply on Tuesday, Lordship.
Tuesday.
Yes, Lordship, because Monday he has a matter before Supreme
Why
Court.
not tomorrow?
Not tomorrow, Lordship, because tomorrow he
No,
has...
it's difficult because this matter I cannot keep it for a long time because next week is a motion day. Every day we've been informed from the bench that a lot of bail matters are also going to be assigned to this bench.
Lordship, tomorrow is the first
Instruction
item,
aha nahi
Lordship.
dena, Rupa?
Lordship,
Aisa?
may I pray to take up this matter tomorrow as a first item?
No, not this first item and all. I'll keep it tomorrow. Maybe at 2.
Lordship. So I have another 30 minutes time required.
No, I am hearing you.
Lordship.
But I just wanted to
So,
find out.
Lordship.
Yes. You
So,
can.
Lordship, if you want to tomorrow, then tomorrow we'll continue, Lordship.
No, till you have some more time. If you
Lordship,
want.
Lordship. Then, Lordship, I am continuing, Lordship. Page 166 itself, Lordship. The petitioner had accepted the offer of the respondent and therefore he will covered under the constitution and bylaws of the institute. It is our specific stem, Lordship. The government of Assam notification raising the retirement age of faculty will not be applicable to the petitioner, as neither the petitioner is an employee of the government of Assam, neither has any lien on the service of the government of Assam. Next page, Lordship. After accepting the offer of the respondents, Lordship, after Lordship taking the search of the director, Lordship, it's as per the Lordship, the constitution, it should be a tenure post for 5 years, Lordship. After even the tenure post also, Lordship.
Yes.
After accepting that condition, Lordship, no lien in the previous post, Lordship. His lien is, Lordship, already over in the Assam government.
Yes.
Further, it is submitted that no action has been done by the respondents against the petitioner, by which he can claim that the service of the petitioner has been altered or the petitioner has been put to a disadvantageous or the action of the respondent creates any hardship to the petitioner.
This is what we have
Lordship,
indicated.
only Lordship has indicated, Lordship. Then, Lordship, that the notification dated 14/2/2022 issued by the National Medical Commission is only a direction with respect to the maximum age limit. I will clarify it, Lordship, from the notification itself. Just I pointed the paragraph, Lordship.
There I have noticed
Lordship.
the word maximum.
Maximum, Lordship. I have clarified whether he is fall in the category or not. After that paragraph, I will directly come to that notification, Lordship. Respect to the maximum age limit.
You see, 14 to 2022 may bring the age to 70. That's a different aspect.
That's a different aspect, but whether he is fall within the 3 categories or not, Lordship.
Right now, it is the constitution.
Constitution. Even Lordship, he is not within the category of that 3 categories.
Mr. Chaudhary, Mr. Gogoi perhaps will might
take some time.
Some time. So I was thinking tomorrow for the hearing, because otherwise this matters becomes very difficult. And next week, I'm told, apart from motions of this bench, even bail matters are being assigned. So,
Well, tomorrow actually second half I'll be going out somewhere, Milord. So if it is not inconvenient, could be on Tuesday, Milord. Next. Or it can be done this way, Milord. If my learned friend is not concluded, let him conclude tomorrow. I'll give my reply on Milord Tuesday, Milord.
all right, we can do that.
Yes, I think that can be done.
We can do this. All right. All right, that would be, I think, better.
Lordship, Lordship.
Because I think you have some more, right?
More, Lordship.
You can conclude tomorrow.
Lordship,
I can
Lordship, Lordship.
fix it at 2 also if you want.
Lordship, Lordship.
Or
My Lord, at 2, then
At
it will
2
be,
tomorrow.
then it will be easier.
Then further hearing remains inconclusive. Further hearing tomorrow at 2.
Lordship.
Part third,
Oblige, Lordship.
So it will, you may not be there.
There is a motion, Michael.
Just before that, I think there is an interim order here also.
Yes, it has to be extended.
Interim, if any, shall continue till the next date of listing. Now, what is that motion?
My lord, in that motion, now
Let that
what
be
had
along with this.
Along with, because this
No,
issue
my
is
lord,
related
my
to
lord,
this
what has
issue.
happened, they have already placed somebody, my lord. If your lordship will kindly come to the impugn order, my lord.
This is also relating to the
Yes,
age.
yes, now my lord and also.
So if Lordship held that, Lordship, he should be.
Yes, Mr. Chaudhary.
Yes, page 172, my lord.
Page 172.
Yes.
Somebody else has been.
Yes, my lord. And my lord, most importantly, under FR 919, it cannot be done. If your lordship will kindly come to page, my lord, 175.
Now, where is the prayer?
Yes. Prayer is for stay, my lord.
No, main prayer.
Yes.
You are
prayer-
challenging this. Recall the order dated 1909.
Yes, yes.
This is that order which you just showed me.
Yes.
1909.
Since the dispute is going on and court is in session of the matter, why they should precipitate, my lord?
Mr. Chaudhary, since I'm already hearing this matter and we're fixing it tomorrow. Let me issue notice and let them have the instructions by tomorrow. Or
Well,
I'll keep it at the motion stage itself. Let them have the instructions tomorrow. Let me have a look.
Okay.
Since I'm hearing the matter, you see, and a person has been rightly, wrongly, it appears.
No, nobody has taken over, can't take because
Only,
that's why I'm
only
saying,
the
my lord.
appointment order has come.
Yes. No, if your
Then
lordship can
status
give me
quo
1
till
minute
then.
time, my lord.
Mr. Gogoi, status quo till then.
Yes.
Lordship already is there.
No, he has not joined, right?
My Lord may kindly peruse. My Lord may kindly peruse the first order of the WPC. There is no direction regarding director, Lordship. My Lord may kindly peruse.
Wait, Mr. Gogoi.
Lordship.
This the petitioner has already been. Has he
He is
handed over?
no more director, Lordship.
No. He has been superannuated.
Lordship.
Has he left?
He is superannuated, Lordship.
No,
He is
my lord.
superannuated. Lordship may kindly observe, Lordship. Kindly peruse the first order of the petition number, Lordship.
Yes, it is there.
3769.
Yes.
3769.
That we have
Lordship.
annexed that order, my
And
lord.
Lordship, time and again, even Lordship, the earlier occasion when Lordship the proceeding was going on, this is the submission of the petitioner. Council is that Lordship
Page,
is
Mr.
not
Chaudhary.
holding the post of the director,
Yes.
Lordship.
If your lordship would kindly come to that order at page 163.
163.
Yes. The operative portion is at page number 167.
Taking into the facts and circumstances recorded above, a case for passing of an interim order is made out. Accordingly, it is directed that the impugned order pertaining to the superannuation of the petitioner is concerned is stayed. So similar order I can pass.
Lordship may kindly peruse paragraph 8, Lordship.
It is however
Paragraph 8,
clarified that
Lordship.
the FRCST order is only pertaining to the services of the petitioner and not confined to the post of director.
Lordship, this is the issue, Lordship.
Means?
It is pertaining to superannuation, not confined to the director, Lordship. Director
So I'll
already.
give the same direction.
Lordship may same paragraph 7 and 8.
Yes.
We have no objection,
All
Lordship.
right, I'll give 7 and 8.
He is not there, Lordship.
Very
He is not
well.
a director,
My
Lordship.
lord, on that day,
He is not a director, Lordship.
my lord, on that day, that issue, because on that day the issue was whether I am a faculty member. Because the state government specific case was, I am not even a faculty. Now that is why in that context that order was passed. Now my lord, only submission is now lordship is hearing the matter. Now why should they precipitate, my lord? In any case, matter will be heard tomorrow. Then maybe had the vacations not intervened, then things would have been over. Now why? And where is the question of, because who is having lien over that post? I'm having lien over this post. If I'm having lien over this post, my lord, nobody else can be given an officiating charge. That's the law, FR 19, 919, that I have annexed. If your lordship should kindly come to page 175 for a moment, my lord.
1 second.
FR 919 I have
just
annexed.
1 second. I'm just reading this order.
Yes. Where, my lord, they wanted to retire me. Court says this order will be, court protected me.
Yes. Yes. Yes.
My lord, the broader picture that I am a faculty member, that I am a director is before your lordships. On the very first day, my lord, those two affidavits were not before the court. Therefore, that I was also appointed as a faculty, also appointed as a director, that I was holding a non-tenure post. All these aspects were not clear before the honorable court. But today, lordship is having the entire larger picture. In this situation, my lord, where is the scope to bring somebody else, my lord? If I do not succeed, that's a different thing.
Mr. Chaudhary, prima facie, this court is not satisfied as regards that age.
Okay.
That is why this court is finding it difficult to give you an interim today. I'm being very honest. Of course, I have to hear you in your reply. See, the issue that is very short. Whether during 1999, what was your age? The age of retirement. That they have brought in a document to show it was about 58. Now, now the constitution that has been brought, that constitution, it is 65.
No, my lord, that constitution will not apply to me because I'm an inherited employee.
No, but
okay,
that one. Now suppose that is your argument. Then the next per contra argument is that it is A and B. Now A is 65, B is 70.
My submission is I am entitled to get any benefit from both ends. Be it under MDC prescription, be it under the Government of Assam prescription. Now, matter is very simple. The Government of Assam says that I am not a faculty member, therefore I cannot get this benefit. Government of India says, as per 25, I am supposed to retire at 65. But I am also a faculty. According to your own circular, I am entitled to.
Tomorrow then, I think it's already time.
Yes.
42 and 45. The motion is 45.
Motion is tomorrow.
42. 45 and 42.
Huh? 42, that's right. I said 42 and 45.
Yes.
Along with tomorrow.
May please your lordship. Lordship with regard to item number 53.
Yes, Mr. Das.
Actually, it's a part-out matter, lordship.
50?
So what 53, lordship?
53.
Lordship, what lordship would like to do, lordship? We will like to fix the matter next week or may lordship?
53.
Yes, lordship. Supplementary, lordship.
Good, supplementary list. 90 or 8.
There are two matters. Let it come after the vacation.
All right. 53. In item 53, due to paucity of
item number 46 and 53.
Due to paucity of time, the matter could not be concluded, could not be taken. 53 to Kobo hearing could not be concluded today. Fixed. Yes, a date after vacation.
In the month of October, your lordship. Otherwise,
give a date.
Lordship, or maybe on October 24th, your lordship.
Fixed on 24/10/2024.
Yes.
And another item is 40. 46 is also part third. Oh,
Yes.
Same. 46. Same date, 46.
24.